Good morning. The Senate will come to order. We will start momentarily. I just want to give all members an opportunity to get somewhere near their seats. The Senate will come to order. The senators will take their seats. The senators and all in attendance, please stand and be led in prayer by the Honorable Lionel Spruill, Sr. from the 5th Senatorial District. Senator Spruill.
Let us pray. God, my Father, the Father of Abraham, Isaac, and Jacob, we come to you this morning, dear God, my Father, said thank you because you've been so good to us. Thank you, dear Father, because you woke us up this morning to allow us to see another day. We ask, dear Father, please to forgive us for all our many sins. But we're here today, dear Father, first to give you all the honor, all the glory, and give you all the praise. I ask you, dear Father, please to touch each and everyone here today. Help us, dear Father, to work together, that we will please you first, dear Father, then we will do the business of this commonwealth. Help us, dear Father, to love one another, because love soothes things. Help us, dear Father, to touch one another. Let us know, dear Father, we can do whatever that's in your mind to please this commonwealth. Touch it, dear Father. Let us stop fussing. Let us stop arguing. Let us do what's best for the Commonwealth of West Virginia. We will thank you, dear Father, for all that you have done for us. We will be so careful to give you all the honor, give you all the praise and all the glory. In Jesus' name we ask these things. Amen.
Amen.
I pledge allegiance to the flag of
The United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Nathan Hatfield, for leading the Pledge of Allegiance. The senator from Hanover, Senator McDougal.
Thank you, Madam President. Madam President, I move that the rules of the Senate be suspended with the conditions that were laid out on the first day of session in order to allow members to vote.
Thank the senator. The question is, shall the rules be suspended All in favor of suspending the rules will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all senators voted? Senator Locke, could you please vote me? Thank you. Do any senator desire to change their votes? The clerk will close the rolls.
Ayes 32, no 0.
Ayes 32, no 0. The clerk will call the roll. All those in present, please vote aye.
Senator Norman, how do you vote?
Senator Norman votes a good morning aye.
You have a quorum, Madam President.
Thank you.
Senate Journal for Thursday, February 4th, 2021.
You just name a senator to waive the reading.
The senator from Hampton, Senator Locke, moves the reading of the journal be waived. All in favor of waiving the reading of the journal will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all senators voted? Do any senator desire to change their votes? The clerk will close the
Senator
roll.
Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 31, noes 4.
Ayes 31, noes 4. The reading of the journal is waived. Communications from the House of Delegates. The clerk will report any communications from the House of Delegates. The senior senator from Fairfax, Senator Saslaw.
Madam President, I move that we waive the readings of communications from the House of Delegates.
The question is, shall the reading of the communications be waived? All in favor of the waiving of the reading of the communications from the House of Delegates will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all senators voted? Do any senator desire to change their votes?
Senator Norman, how do you vote? Senator Norman?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 30, noes 6.
Ayes 30, noes 6. The reading of the communications is waived. The clerk will report any communications from the governor.
We have a communication from the governor this morning to the Senate of Virginia. To the Godfather, Majority Leader Dick Saslaw, happy birthday. Sincerely, Ralph S. Northam, Governor.
Happy birthday, Senator Saslaw. The question is, shall the reading of the communications, I'm sorry, we already did it. We already wished happy birthday to Senator Saslaw. Is there any other business in the morning hour?
Madam President,
The senator from Roanoke, Senator Edwards.
since we're in the morning hour, I thought it'd be appropriate when he finishes talking to give a happy birthday to our majority leader, who was, it says, born before Pearl Harbor, although he didn't fight in Pearl Harbor. But congratulations and happy birthday to our majority leader. And I also want to say happy birthday to my lovely wife, who's also today's her birthday, although she was not born before Pearl Harbor. So let's give him a big round of applause, the majority leader.
Madam President, I want to thank Senator Edwards and the governor. I also want to note that while I was born before Pearl Harbor, I was not the cause of it. And I would appreciate it if you all would quit spreading those rumors.
While you're still standing, Senator Saslaw. I'm calling on the senior senator from Fairfax County, Senator Saslaw.
Yeah, this is to announce that we will be communicating bills in batches to the House. The clerk's desk will announce that if you need a bill held up or whatever, you'd have to communicate that right away. But we will be communicating these. We won't wait all the way to the end. Thank you, Madam President, Madam Clerk.
Thank you, Senator Saslaw. The clerk will read the calendar.
Thank you, Madam President. Page 2, uncontested calendar, Senate bill on third reading. Senate Bill 1357, a bill to direct local school divisions to develop and administer diagnostic and growth assessments to each student to assess core subject competency.
The senator from Henrico, Senator Donovan.
Thank you, Madam President. I move the bill pass and speak to that motion.
Senator has the floor.
Thank you, Madam President. This bill, I think most of you are familiar with now. It attempts to address the issue we've heard from so many of our families that their kids are behind and they don't know how far behind, and they're very worried about having lost an entire academic year. So this bill will allow us to test in the fall when the children return to school, please God, and we will assess where they are based on their grade level performance. And then we will assess diagnostically. These are 2 diagnostic assessments in the winter, and then in the spring we'll do a shorter assessment of progress. This is using the same SOL guidelines and standards, but it's no longer the end of the year giant SOL. It's 3 smaller tests applying what we have in our armory of where we think the kids should be, but applying it in a way that individualizes it for that child so that we can help them succeed and master the information. And so that's what this bill does. It currently is testing grades 3 through 8 based on the SOLs, and prior to that with pre-existing assessments to see where the younger kids are in reading. It does no longer have a fiscal impact because of the amendments we applied yesterday, and I've discussed that with Madam Chair. Thank you, Madam President. Again, I move the bill pass.
The question is, shall Senate Bill 1357 pass? All in favor, please vote aye. Those opposed, no. Are the senators ready to vote? Do any senator decide to change their votes?
Senator Norment, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 36, no 0.
Ayes 36, no 0. The bill passed. The senator from Hanover, Senator McDougal.
Thank you, Madam President. Madam President, if I could ask the clerk, does that complete all the bills on the uncontested calendar, so the remaining of the calendar is contested?
That is all the bills on uncontested calendar, third reading.
Okay. Madam President, if we could be at recess until 10:45 for the Senate Republican Caucus to continue remunerations and ruminations in our room. 10:45, please.
Without objection, the Senate will stand in recess until 10:45 a.m.
Senate will come to order. The senators will please take their seats. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I see we've received a communication from the House, and I move that we waive the reading of it.
Thank the Senator. The question is, shall the reading of the communication from the House of Delegates be waived? All in favor of waiving the reading will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote? Senator Norment, how do you vote?
Senator Norman votes aye.
Senator Chase, how do you vote?
Encourage her to unmute.
Are we on mute? Not on mute? Okay. The clerk will close the roll.
Every time to do the wear red day thing. That'll be at the end of the day. Sorry. Ayes 35, noes 2.
Ayes 35, noes 2. The reading of the communication from the House of Delegates is waived. Clerk will call the calendar.
Page 3.
One second.
Page 3, regular calendar, Senate bills on third reading. Senate Bill 1138, a bill relating to sexually transmitted infections, infected sexual battery repeal. And there is a floor substitute.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. I will yield to the senior senator from Richmond City.
Thank the Senator. The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that we reconsider the vote by which Senate Bill 1138 was engrossed and advanced to its third reading.
Thank the Senator. The question is, shall the vote by which the bill was ordered engrossed and advanced to its third reading be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norment, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 36, noes 0.
Ayes 36, noes 0. The motion is agreed to. The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that we reconsider the vote by which the floor amendment was agreed to.
Thank the Senator. The question is, shall the Senate reconsider the vote by which the floor amendment was agreed to? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norment, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 37, no 0.
Ayes 37, no 0. The motion is agreed to. The Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. With the recommendation that it be rejected, I move the floor amendment. I think.
Thank the Senator. Yes. With the recommendation that it be rejected, question is, shall the floor amendment be adopted? All in favor of the motion will say aye. Those opposed, no.
Aye.
No.
No.
No, I'm
No.
sorry.
That's okay.
I haven't had enough coffee yet.
That's all right. No, the noes have it. The floor amendment is rejected. Senior Senator from Richmond City, Senator McClellan.
Mr. President, I move we waive the reading of the floor substitute.
Thank the Senator. The question is, shall the reading of the floor substitute be waived? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The reading of the floor substitute is waived. Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move the adoption of the floor substitute. And speaking to that.
Senator's the floor.
Thank you, Mr. President. The floor substitute does two things. One, it incorporates the floor amendment that was put in at the request of the sheriffs dealing with reporting of certain information to first responders who may have been exposed to a certain communicable diseases. The second thing that the floor substitute does is, rather than repealing the infected sexual battery statute, which was the subject of discussion the other day, it amends the infected sexual battery code section. This is at lines 30 to 44 to basically now, rather than making it a crime, knowing you're infected, to have sex with someone with HIV, syphilis, or hepatitis with the intent to transmit those three diseases, it makes it a crime to engage in sexual activity with any sexually transmitted disease that poses a substantial risk of transmission to another person according to the CDC recommendations regarding such risks of transmission. And the crime means you have to have both intent and the person has to have actually been infected. And with that explanation, I move that the floor substitute be agreed to.
Thank the Senator. Do any other senators wish to be heard regarding the floor substitute? Seeing none, the question is, shall the floor substitute be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The floor substitute is adopted. Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that the bill be engrossed and advanced to its third reading.
Thank the Senator. The question is, shall the bill be engrossed in advance to its third reading? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The bill is engrossed in advance to its third reading. Senior Senator from Richmond City, Senator McClellan.
I move that we suspend the rules and dispense with the third constitutional reading.
Thank the Senator. The question is, shall the rules be suspended and the third constitutional reading be dispensed with? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 37, no 0.
Ayes 37, noes 0. The rules are suspended and the third constitutional reading is dispensed with. Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that the bill pass. And speaking to that motion.
Senator, is the floor.
Thank you, Mr. President. I think this bill has been thoroughly explained and debated already, and with this change, this bill will modernize our HIV laws and decriminalize HIV positive status. These laws, again, regardless of the intent when they were put in, and frankly, the intent when they were put in was to comply with federal statutes that if we didn't comply with, we would not get federal funding dealing with addressing HIV and AIDS. But what we have learned in the 30 or 40 years since then is that these laws actually are counterproductive from a public health perspective, and they also stigmatize HIV plus status and are based on what we now know was incorrect science. And with that, I move the bill pass.
Thank the senator. For what purpose, the senator from Rockingham, Senator Obenshain, rise?
Mr. President, speaking of the bill,
Senators, the floor.
Mr. President, members of the Senate, I do appreciate the efforts to address some of the concerns that were addressed on the floor yesterday. However, I would respectfully submit that this doesn't do it. A couple of things I want to point out, and I do appreciate the gentlelady's efforts in taking out the full repeal of the sexually infected battery. That was a step in the right direction. But let me explain what we've done. This downgrades intentional sexual battery with the intent to transmit HIV, syphilis, hepatitis from a felony to a misdemeanor. Why is that important? Well, think of, first of all, many of us think that's a crime that should be a felony. It shouldn't be placed on the same level with reckless driving. Somebody who actually, and that's what this does, actually, with the intent to transmit HIV or syphilis or hepatitis, actually infects their partner intentionally, we're saying that's the equivalent of reckless driving. Second, with respect to downgrading it to a misdemeanor, understand before, there had to be a criminal investigation. It was a felony. As a misdemeanor, a mad ex-boyfriend or ex-girlfriend, all they have to do is walk into the magistrate's office, swear out a warrant, and the charges are issued. Okay? Think about the damage that that's going to do to somebody's reputation. There's no investigation whatsoever that's done. Second of all, this changes the requirement from knowing that you're infected to having an actual diagnosis. And let's just say that you go get a blood test done. And the blood test comes back showing positive for syphilis, HIV, or hepatitis. But you don't go see the doctor. And there's no diagnosis that is issued. It's not a crime if you intentionally, actually transmit these conditions and diseases to your sexual partner intentionally. Third, it requires an actual infection. So understand this. Right now, it's the intent. And that's what our law is supposed to address, is the intent of the person committing the crime. So right now, if somebody knows that they are infected with HIV or hepatitis or syphilis and intends to transmit it to their sexual partner, but is unsuccessful in that intent, it's still a crime. This decriminalizes that. This says that go right ahead. If you have whatever motivates somebody to intentionally try to infect somebody with one of these diseases, but just is not successful in the transmission, we're decriminalizing that. It's not even a misdemeanor. I would respectfully submit that this does not solve the problem that we discussed at length yesterday. And for that reason, I think this needs to be looked at further. I hope that the members would vote no on the functional repeal. Actually, the complication and hopeless complication of our infected sexual battery statute, I hope we'll vote no on this bill.
For what purpose does Senator from Henrico, Senator Donovan, rise?
I rise to speak against the bill.
Senators, the floor.
Thank you, Mr. President. I feel compelled to say one of the hardest conversations I have to have with a woman is when she finds out that she walked away from a loving relationship with an infection that she may have forever. And it's devastating. And it affects her self-esteem. It affects her feelings about future relationships. It affects her feelings very much about herself. And it is a shockingly difficult situation to be in again and again with women. And I have to say, I believe they deserve the recourse if willfully they were infected with something that they have to seek medical treatment for the rest of their lives, that they ought to have that recourse. And the fact that this bill would take that away from a woman who is injured seems to fly in the face of everything we've been fighting for so long. So I will not be able to support this bill, and I hope that the body will see fit to not pass this bill because I believe women need to have the opportunity for that recourse, especially if there was willful intent, which obviously is hard to prove, but to remove their chance to prove it is not right, it's wrong.
For what purpose the senior senator from Richmond City, Senator McClellan, rise?
Speaking to the bill, and then I have a motion.
Senator, has the floor.
Thank you, Mr. President. Speaking very briefly to the bill, intent today is very difficult to prove. But what the infected sexual battery statute has done is for HIV positive people in particular, it already gives a disgruntled ex a weapon to have someone charged who is HIV positive, who didn't actually infect them, to say, they intended to infect me, and they get arrested. That's happening today, whether that person is actually infected or not. This bill tries to address that. And this bill also takes away the scarlet H that has been put on HIV positive people. The law today punishes someone who knows their status, who gets tested, and yet doesn't punish those who don't know their status. Now, the senator from Henrico, I believe her argument is based over the penalty, whether it's a Class 1 misdemeanor or a Class 6 felony, because again, just proving intent is difficult. And in her case, if someone is actually infected, they still have recourse. I believe her concern is over the penalty. Ms. Chair, my motion is I'm going to ask that this go by temporarily. But I want to be clear, because hopefully when it comes back, we don't have to have an extended floor debate. But I want to be clear that today, this statute is already being used as a weapon for disgruntled exes against a partner who is HIV positive.
Without objection, Senate Bill 1138 will go by temporarily.
Senate Bill 1384, a bill relating to the Virginia Public Procurement Act, local arbitration agreements.
Senator from Eastern Fairfax, Senator Serval.
Thank you, Mr. President. I move the bill pass, and speaking to that motion.
Senator, has the floor.
Thank you, Mr. President. Ladies and gentlemen, I explained this bill pretty much at length yesterday. It is a local option bill. It gives local governments the authority during the procurement process to ask bidders about their arbitration practices when it comes to civil rights disputes and employment disputes, and then for a small subset of contracts that schools can enter into regarding goods or services related to education. It's a shadow of its former self, and it's a shadow of the bill that I introduced last year that passed this body. I would hope the bill could pass, and I'm happy to answer any questions.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1384? Seeing none, the question is, shall Senate Bill 1384 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no, but thanks to the senator for his brevity.
The clerk will close the roll.
Ayes 20, no 17.
Ayes 20, no 17. Rule 36, 1. Senate Bill 1384 passes.
Senate Bill 1105, a bill relating to post-conviction relief, previously admitted forensic scientific evidence.
Senator from Franklin County, Senator Stanley.
Thank you, Mr. President. I now move that Senate Bill 1105 pass. And speaking to that measure,
Senator, has the floor.
Thank you, Mr. President. Members of the Senate, you've seen this bill before, so I will not talk too long because I want to also have the senator from James City County say from that big screen, thanking me for my brevity. But this is what the bill is, and you've seen it before. If you remember, Keith Allen Harward, wrongfully accused and convicted of a murder that he did not commit based on junk science, bite mark evidence. And he served 33 and a half years for a crime that he did not commit. We welcomed him from the floor of the Senate in the gallery last year, and there is a documentary that documents that fact itself. This bill basically says that those people who've been convicted of a crime, and in the main part of that conviction, the evidence was junk science or science that was admitted at the time but later discredited, like bite mark evidence was, then that person would have a right to appeal their conviction, post-conviction, post the 21-day rule, one time to the Court of Appeals. The Court of Appeals would make a review, and it would determine if the cause had merit, then to grant the appeal. And if the appeal was granted, then that person would be entitled to a new trial. This is how we should always be to try to get it right in the judicial system, because we don't get it right all the time. You've heard me say that. And this is just one piece that I think enables those that have been wrongly convicted, like Keith Allen Harward, to get that second chance at life. Keith Allen Harward was only freed because DNA proved him to be innocent. Had that DNA evidence not been present and tested, he would still be in jail serving time for a crime that he did not commit. And for those reasons, Mr. President, I renew my motion that Senate Bill 1105 pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1105? Seeing none, the question is, shall Senate Bill 1105 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye, and I'm equally proud of his brevity.
The clerk will close the roll.
Ayes 38, no 0.
Ayes 38, no 0. Senate Bill 1105 passes.
Senate Bill 1113, a bill relating to communicating threats of death or bodily injury to a person with intent to intimidate. Penalty.
Senator from Northern Chesapeake, Senator Spruill.
Thank you, Mr. President. I move the bill pass. Explain.
Senator's the floor.
Thank you, Mr. President. This bill says that any person 18 years of age or older who communicates a threat in writing to another to kill or to do serious bodily injury to any other person may such threat with the intent to intimidate the civilian population. Without reading the rest out, Mr. President, but also come with a penalty. Those who are 18 years of older with a class 5 felony, and the person younger than 18 years of age who commits such crime will be as a class 1 misdemeanor. I move the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1113? Seeing none, question is, shall Senate Bill 1113 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 32, no 6.
Ayes 32, no 6. Senate Bill 1113 passes.
Senate Bill 1127, a bill relating to charitable gaming, conduct of instant bingo, network bingo, pull tabs, and seal cards.
Senator from Spotsylvania, Senator Reeves.
Thank you, Mr. President. Move the bill passed and speaking to the bill.
Senators, the floor.
Mr. President, when I presented the bill in finance, I apologize for even having to be there. But, Mr. President, I got to tell you, I'm done apologizing for bad players. Mr. President, I want to take you back to your youth for a little bit and remind you about the time when your mother, Mrs. Fairfax, you would hang out with some friends. Maybe some of your friends weren't the best. And you got in trouble. Mr. President, what's the first thing that happened when you got in trouble with your friends? You started pointing at each other. And that's what's going on here, Mr. President. The only difference is, unlike our youth, the finger pointing, the cross accusations are all being flaunted by lawyers and representing the folks that got themselves in trouble. Let me tell you, Mr. President, this is, I need to apologize to my colleagues because I know they've gotten hundreds, if not thousands, of emails and texts by now about this matter. But let me tell you what this matter is about. And I apologize to the minority leader because I'm taking a couple more minutes than I really thought I would. But it's been a long week, and I think I need to kind of clear the air here. This is about money and greed. Ladies and gentlemen of the chamber, we know that our legalized gray machines bring in about $140 million to the Commonwealth. Let me say it again, about $140 million. We don't really know how much our gaming machines are bringing into charities because we haven't regulated that part so much. But I will tell you, Mr. President, this thing kind of reminds me of the opioid crisis, right? We got a company out there making Oxycontin for legitimate reasons, but the truth is we find out later they're all about profit. They knew their product was being pushed onto our streets, and we were creating dependency. Mr. President, our charities are dependent upon these machines in order to survive. They don't really care how they're placed or where they're placed. Mr. President, they've been quoted as saying in an article, and I quote, and I'm not going to say which company said it, but I am going to quote it because it's a factual document. We're not going to be fined. We're not going to have our bank accounts frozen. Nobody is going to jail. We sell machines. That's what we do. We don't control what happens to them after that. I'll further quote, nobody gives I won't say that word. We're not going to run around calling our machines legal when they haven't been regulated, except in Georgia where they are. What I do know, Mr. President, is there's a mass proliferation by questionable charities in our restaurants, bars, strip centers, all under the guise of charity being pushed by gaming manufacturers. That's what this bill attempts to address. So let me tell you what the bill does so all the members want to get a clear idea. It's going to require permitting by all. No exceptions. This will allow VDAC to have oversight. It's going to close the loophole that's been exploited to allow these companies to proliferate in our restaurants, bars, and strip malls. It freezes the current charitable giving amount, sets up a joint subcommittee from the Senate and House respective committees to specifically study the percentage of gross receipts, the regulatory oversight, and necessary safeguards and oversight for conflict of interest of our board members. And lastly, Mr. President, importantly, it sets up an enforcement tool to police manufacturers who violated gaming laws or had their license or permits revoked in any jurisdiction within the last 5 years. Mr. President, I don't want to tell these charities they can't use these gaming companies that have had some abuses in the past, and they have, Mr. President. I have documents that show that. So we put in a little clause that said, we'll give you a second chance, so we're not going to hold anything that you've done in the past right now against you. But by July 1st, 2021, going forward, looking forward, if you get any of those, we're not going to let you do business in the Commonwealth. Mr. President, I think this is probably time we did this. This chamber has been extremely great at solving some of these issues. I look forward to the study this summer, and I hope that the chamber will vote positive or green for this legislation. Thank you, Mr. President.
Thank the senator. What purpose is Senator from Alexandria? Senator Eben rise.
Will the senator from Spotsylvania yield for a question?
Senator Yield?
Absolutely.
Senator Yield, you have the floor.
I'm looking at the engrossed version of the bill, and I wanted to ask the senator, does the engrossed version of the bill put guidelines or limits on how much money, or requirements on how much money the charities must yield from these machines?
Senator's the floor.
Mr. President, I think he is referring to lines in section 182340.26.1. That charity is governed by the charitable board who helps sets that profit margin or how much they share.
Further question?
No, just speaking to the bill.
The floor.
There's a part of this bill that I really admire, but it's changed a lot through the process, and I think there may still be some concerns that I have. So I'm going to abstain on this, but I want to thank the patron for shining a light on the proliferation of these games in places where I don't think they should be. Thank you.
Thank the senator. For what purpose is the senator from Prince William County? Senator McPike rise.
Thank you, Mr. President. Speak to the bill.
Senator's the floor.
Thank you, Mr. President. I appreciate the patrons bringing forward the effort, and as part of the General Laws Committee, we've done a lot of work over this over the last couple of years. I think that the senator from Spotsylvania has identified a number of things that do need to be addressed. The bill, as it is in form, has some imperfections, but I think this conversation needs to continue over into the House, and I think the patron has identified to me that he's still willing to work to make sure that the good actors are not harmed through this, while also moving forward with a framework that does get to the root of the issues. And I think the senator has pointed out, rightly so, that there are likely some folks that have expanded beyond what we have anticipated through the gaming regulations that probably does need to be curtailed some. And I'm willing to vote for this. I know some need to abstain or to probably put some red because of the local concerns, which I also appreciate. But I do support the senator's effort so we can continue this work over in the House to get this piece of legislation in a little bit better position. If it's not, by the time it comes back, I'll put red up on it. But I believe in the senator's ability to work some of these issues out. Thank you, Mr. President.
Thank the senator. For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
Thank you, Mr. President. Will the gentleman from Spotsylvania yield for a question?
Will the senator yield?
Absolutely, Mr. President.
Senator yield. You have the floor.
Thank you, Mr. President. I asked my very good friend. We've all received a lot of emails and calls from Elks Lodge, Moose Lodge, et cetera, and I'm myself am a member of FOP Lodge number 9 in Chesapeake. In speaking with the gentleman, is it true that those types of organizations would be exempted from the tenets of this bill?
Mr. President, I would tell the senior senator from Chesapeake, absolutely, they are excluded, and we haven't touched them other than they will have to have their permits as they have had in the past. This just takes every one of them to allow VDAC the opportunity to have some oversight, and that's been part of the challenge, Mr. President, is getting oversight on these organizations.
I thank the gentleman.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1127? Seeing none, the question is, shall Senate Bill 1127 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 29, noes 7, Rule 36-3.
Ayes 29, noes 7, Rule 36-3. Senate Bill 1127 passes.
Senate Bill 1196, a bill relating to teachers and other licensed school board employees' cultural competency.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. I move that the Senate Bill 1196 pass, and speaking to that.
Senator, the floor.
Thank you, Mr. President. Senate Bill 1196 implements the key recommendation of the African American History Education Commission, prioritizing cultural competency as a key skill for educators, and ensures Virginia's complex history is taught holistically. This proposal sets out several new training and professional development requirements that will equip all Virginia educators with the skills necessary to sustain culturally responsive classrooms. This legislation also aims to ensure that history and social science teachers have the specific content knowledge to teach African American history with sensitivity and confidence. With that explanation, Mr. President, I move that SB 1196 pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1196? Seeing none, the question is, shall Senate Bill 1196 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote? Senator Norman, how do you vote?
Senator Norman votes aye.
Senator Chase, how do you vote?
Senator Chase votes no.
The clerk will close the roll.
Ayes 22, no 16.
Ayes 22, no 16. Senate Bill 1196 passes.
Senate Bill 1201, a bill relating to tax exemptions for energy storage programs, systems.
Senator from Fairfax City, Senator Peterson.
Thank you, Mr. President. First of all, I want to thank Senator Deeds for putting this on the contested docket. I move to pass speak to the bill.
Senator has the floor.
Mr. President, ladies and gentlemen, usually when you see the words Public Service Corporation and Peterson, you get some inflammatory speech from me. This is the exact opposite. This is basically a cleanup bill to make sure that those energy storage facilities that are over 25 megawatts that are not owned by public service corporations but are independently owned still come under the jurisdiction of the State Corporation Commission. There was a revenue sharing component in there, I believe, that was negotiated with VML. Or one of the municipal advocates. But the bottom line is nobody was opposed to it, and it snuck through, and if not for Senator Deeds, I would never have had to explain it. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1201? Seeing none, the question is, shall Senate Bill 1201 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 38, no 0, Rule 36-1.
Ayes 38, no 0, Rule 36-1. Senate Bill 1201 passes.
Senate Bill 1226, a bill relating to the Compensation Board determining staffing and salaries for an attorney for the Commonwealth.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. I move the bill pass. Speaking to the bill.
Senator's the floor.
Thanks, Mr. President. This bill has gone through it has gone through 3 committees, 2 of them unanimously, the Judiciary, the Commerce and Committee on Local Government, and then in Finance Committee, it got the clause put on it and garnered 2 no votes. This is a bill that would look at the current funding formula for the Commonwealth's Attorney's Office. We know that as it stands now, they usually rely on felony indictments and sentencing as the basis for assessing their workloads to determine the allocation of the state funding. This is a bill that I'm bringing up as a request from Fairfax County that would look at including things like the diversion programs and the specialty dockets as a way of incorporating how our offices are staffed. Specifically, there is language in my bill and in the budget amendment that said adequate funding should be provided to the Compensation Board in fiscal 22 to implement the change appropriately to fund Commonwealth's attorneys' offices while ensuring that no Commonwealth's attorney's offices loses funding as a result of this new formula. And I hope the bill pass.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Good morning, Mr. President.
Morning, Senator.
Mr. President, speaking briefly to the bill in support of the measure.
Senator has the floor.
This bill also recognizes that Commonwealth attorneys spend a considerable amount of time in drug courts and in mental health dockets, which we've expanded throughout the Commonwealth. And unless there's a formula that takes into consideration the amount of time and effort and resources and talent into those dockets, then the Commonwealth Attorney's offices aren't suitably funded. This bill does that, and I urge the body to support it.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1226? Seeing none, question is, shall Senate Bill 1226 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 35, noes 4.
Ayes 35, noes 4. Senate Bill 1226 passes.
Senate Bill 1252, a bill relating to sunset of coal tax credits.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. I move the bill pass, and speaking to the motion.
Senator has the floor.
Thank you, Mr. President. This bill puts the sunset for the state's two coal tax credits in 2022, both the coal employment and productive incentive tax credit, as well as the coal field employment enhancement tax credit. This is a follow-up from last year's JLARC study identifying sort of the challenges around the efficacy of the tax credit, identifying that roughly the yield is 5 cents on the dollar. And so this effort in working through language does a couple things, one of which is clearly the sunset, but also, more importantly, as a part of the enactment, we've put together a work group of stakeholders in Southwest Virginia to come together to look at the future of Southwest and future economic opportunities with both the Virginia Coalfield Economic Development Authority, other stakeholders throughout Southwest, and report back to the General Assembly. As you may know, both tax credits, both the metallurgical has a 3-year claim, so the liabilities of outstanding credits will still continue within our appropriations through FY 25 and 26, as well as the other sort of a 10-year accumulation. So this is still a tax credit that will continue to be claimed for years to come, even with the sunset provision in 2022. Through the process, we did work out language with some of the existing producers as identified in committee. The language is revised in the Finance Committee substitute, resolved the opposition that had initially been received. In fact, we had no opposition speak to the bill in committee, Mr. President, and renew my motion that the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1252? Seeing none, question is, shall Senate Bill 1252 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 22, noes 17.
Ayes 22, no 17. Senate Bill 1252 passes.
Senate Bill 1257, a bill relating to standards of quality.
Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that we reconsider the vote by which Senate Bill 1257 was ordered to be engrossed and advanced to its third reading.
Thank the senator. The question is, shall the vote by which the bill was ordered and engrossed in advance to its third reading be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 38, noes 1.
Ayes 38, noes 1. The motion is agreed to. The Senior Senator from Richmond City, Senator McClellan.
Mr. President, I move we waive the reading of the floor amendment.
Thank the Senator. The question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The reading of the floor amendment is waived. The Senior Senator from Richmond City, Senator McClellan.
Mr. President, I move the floor amendment be agreed to, and speaking to that.
Senator, is the floor.
Thank you, Mr. President. The substitute to this bill that was adopted by the Senate Finance Committee, rather than adopting the full bill and the full recommended SOQs from the Board of Education, honed in on those what are currently considered support personnel that I think we would all agree are very critical we get back into the school building, and that is nurses, social workers, and mental health professionals. As the bill came out of the Finance Committee, it removed those personnel from the definition of support personnel, so they'd be considered separately, and recommended that each school division have 2 of some combination of that group. In consultation with school divisions and Senate Finance staff, we felt it was more appropriate and frankly more needed to have 3, which will likely be funded in the budget on Sunday. With that, I move the floor amendment be adopted.
Thank the Senator. Question is, shall the floor amendment be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The floor amendment is adopted. Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move the bill pass. And speaking to that.
Does the Senator
no.
first?
First,
Okay.
I need to
Yes.
move that it be engrossed and advanced to its 3rd reading.
Thank the Senator. The question is, shall the bill be engrossed in advance to its 3rd reading? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The bill is engrossed in advance to its 3rd reading. Senior Senator from Richmond City, Senator McClellan.
I move that we suspend the rules and dispense with the 3rd constitutional reading.
Thank the Senator. The question is, shall the rules be suspended and the 3rd constitutional reading be dispensed with? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 38, noes 0.
Ayes 38, noes 0. The rules are suspended and the 3rd constitutional reading is dispensed with. The Senior Senator from Richmond City, Senator McClellan.
Mr. President, I move the bill pass. And speaking to that.
Senator, the floor.
Thank you, Mr. President. Again, I wish we could pass this bill as originally introduced, because that is what we need, according to the experts, to provide a high-quality public education to all students in Virginia. That is about $1 billion a year, and unfortunately, that's just not going to happen this year. But I put the bill in part so that everyone knows that is what we need to do to fully meet the needs of our students and provide them with the high-quality public education. But part of a loaf is better than none. And as we've heard on this floor from both sides of the aisle, this crisis is affecting our children. And you can't learn if you're sick, if you have mental health conditions, or that are impacting your ability to learn and concentrate. And mental health professionals and social workers and nurses are just as critical to teaching our children, especially now, as teachers. And so this bill at least gets more of them in the school buildings. And with that, I hope we pass this bill.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 1257? Seeing none, the question is, shall Senate Bill 1257 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? All the senators voted. Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 37, noes 2.
Ayes 37, noes 2. Senate Bill 1257 passes.
Senate Bill 1261, a bill relating to the Court of Appeals jurisdiction, number of judges.
Senator from Roanoke City, Senator Edwards.
Mr. President, I move that Senate Bill 1261 pass. And
Senator's the floor.
Speaking to the bill, Mr. President, this expands the Court of Appeals of Virginia from 11 to 17 judges. In addition, it provides for automatic right of review, right of appeals in all civil cases as well as criminal cases. This may be the most important bill we're passing this year, Mr. President. The Judicial Council studied this for about 2 years and unanimously recommended, these are the judges of Virginia and some others, unanimously recommended that we expand the Court of Appeals and also grant an automatic right of review in all cases, civil and criminal. Mr. President, Virginia is the only state in the country that does not now allow an automatic right of review in civil and criminal cases. The only state in the country that does not have an automatic right of review in all civil and criminal cases. And Mr. President, all bar-related groups and all business groups support the automatic right of review in all civil and criminal cases. Indeed, it is universally recognized, Mr. President, that the model of justice is at least one appeal of right in all civil cases and in all criminal cases. And currently, we don't have that. Currently, all civil cases go to the Supreme Court, bypassing the Court of Appeals, and you have to have a hearing with a writ panel to decide whether or not your case is even going to be heard by the Supreme Court. That's not an automatic right of review by the Supreme Court because it bypasses the Court of Appeals. This would expand the jurisdiction of the Court of Appeals to handle civil cases as well as criminal cases. Even in criminal cases, Mr. President, while the Supreme Court of Appeals has jurisdiction over the appeal of criminal cases, there's no automatic right of review. You have to go to a single judge who decides whether your case will even be heard. If the single judge says, no, your case is not going to be heard, you can appeal to a three-judge panel. And the three-judge panel then will only decide whether or not your case will even be heard. And so there's no automatic right of review in either civil or criminal cases. Mr. President, it's universally recognized that the model of justice is an appeal of right in all civil cases and in all criminal cases. Mr. President, the expansion to from 11 to 17 judges still would not put Virginia in the status of having as many judges as most states that have the same similar population of Virginia. For example, in New Jersey, there are 37 judges on the Court of Appeals, Intermediate Court of Appeals. New Jersey has about 8.8 million people. Virginia has 8.5 million people, Mr. President. Washington State has 22 judges, yet they're slightly smaller than Virginia. 7.6 million people, 22 judges of the Court of Appeals in Washington State. Arizona has 7.2 million people. They have 22 judges on the Intermediate Court of Appeals. Massachusetts, 6.8 million people. Smaller than Virginia, they have 28 judges on the Court of Appeals. This would only go from 11 to 17, so we're way lower than any other state that has courts of appeals. Mr. President, the expansion of civil law is particularly important because and also the almost automatic right of review in criminal cases as well is important because otherwise, Mr. President, the trial judge basically has the final word in any case, civil or criminal, as a practical matter. One of the issues that was looked at by the working group and worked on by the Supreme Court as well has to do with the right of oral argument. You have the right to have your panel, your brief and the appendix and the record reviewed by a three-judge panel on the Court of Appeals, civil and criminal. The question now is whether or not you're entitled to oral argument. We worked it out in the following way, and I think most everybody agrees, including the Supreme Court. And that would be, you would have the right to have oral argument on your brief before a panel of 3 judges, except in the following situations. One, that the panel of 3 judges, having reviewed the record and the briefs, decides that it's wholly without merit, or in the situation where the dispositive issues have been authoritatively decided by existing case law, and the appellant has not argued that the case should be overturned, extended, modified, or reversed. Let me repeat this. You would have the right of automatic oral argument on your case before a panel of 3 judges, unless the panel unanimously concludes the oral argument would not be necessary because of either one of 2 things. The appeal is wholly without merit, or the case law has been authoritatively decided, and the appellant has not argued that the existing case law the appellant has not argued that the existing case law should be modified, overturned, extended, modified, or reversed. So therefore, Mr. President, in almost every case you would get oral argument, as well as writing the opportunity to have your brief being considered on the merits by a panel of 3 judges. So, Mr. President, as I mentioned, this is extremely important to Virginia, for the economy of Virginia, for equality in Virginia, Mr. President. And I urge the body to vote yes on Senate Bill 1261. Thank you, Mr. President.
Thank the senator. For what purpose does Senator from Rockingham, Senator Obenshain, rise?
Mr. President, I rise to speak the bill.
Senator, the floor.
Mr. President, members of the Senate, this is not just a lawyer bill, and let me explain. Senator from Roanoke did an outstanding job of laying out the arguments in favor of this. I just want to toss out a few considerations for you as you cogitate over this. You know, first of all, Senator from Roanoke indicated that every judge and every level of judicial authority in Virginia is for this. Well, you know, I've been around for long enough to know that there's never been an agency of government who has not supported getting bigger, okay? Never. So that comes as absolutely no surprise. I remember when the Court of Appeals was created, and there was great consternation over whether we're just creating another level of judicial bureaucracy that's going to extend the period between filing suit or charges being made and final resolution. Because we all know the adage that justice delayed is justice denied, and that's very true. And we were assured as Virginians that this is not just another level of judicial bureaucracy. We're going to carefully cabin the jurisdiction of the Court of Appeals and ensure that it just addresses a certain kind and certain number of cases. So don't worry. We're not creating another level of judicial bureaucracy. We just heard that this is not the end. This is hardly the end. We heard about states with Massachusetts with 28 judges on their Court of Appeals, other states with 30 plus. You know, we're going to be back, we're going to be back, and we're going to be back, hearing about further expansions of our Court of Appeals. I want to tell you, I do civil litigation. I don't do criminal litigation. And criminal litigators, they can explain how this would affect them. But everybody gets a hearing before a Court of Appeals. Everybody. There is not a single case that does not get screened on appeal. You may not get your appeal granted. You may not win your appeal, but everybody who goes through the court system has a right, whether you start at General District Court, you get an appeal to the... Hello, Siri. Everybody gets an appeal. If you start at the General District Court, you get an appeal to the Circuit Court. Then you get an appeal, depending on the type of case it is, to the Court of Appeals or the Supreme Court. and you get to argue your case before judges of the Supreme Court or judges of the Court of Appeals. I tried a case a year ago last December, in Fairfax County. And it wasn't until November of this past year, 11 months after the trial, that I even heard whether the appeal that had been noted was going to be granted or not. 11 months after the trial, that's 24 months after the case was filed, and it will be nearly a year further before the case is decided. That adds up to about 3 years, and you add another level of judicial appellate work to this process, that's 4 years, potentially. 4 years between filing of a suit and resolution. When you look at what effect this is going to have on the level of litigation, I think that there are serious concerns about whether, given the expansion of the jurisdiction of the Court of Appeals, whether even this number of judges is going to be adequate, or whether there's going to be a further backlog of cases. And those of us like Senator Peterson, Senator Servell, and I, and Senator Lewis, who do a lot of civil litigation, we're going to be at the back of the stack. We're not going to be the one. We're going to be the ones who are not going to be able to get our cases advanced from beginning to end as fast either. And you wonder why that might be. Well, there's going to be a huge increase in the number of criminal appeals. How many, you might ask? A lot, because the accompanying budget amendment that goes along with this asks for, how many judges was this? This is 7 new judges. It asks for 50 new attorneys in the Attorney General's office. 50 new attorneys are going to be necessitated in the Attorney General's office to be able to handle all of these appeals. So as you consider this, I know that all the bars have asked for it. I know that the courts have asked for it. The Senator from Roanoke has done an outstanding job of making the case, but I just toss those few considerations out for your cogitation as you decide whether to vote for this or not. I'm going to vote no, and I hope a few other folks will cast a red vote as well.
Thank the Senator. For what purpose does the Senator from Fairfax City, Senator Peterson, rise?
Speak to the bill.
Senator's the floor.
Mr. President, I'm going to vote for this. I'm going to give it a light green, and let me tell you why. First of all, I like the fact that there's going to be an appeal of right in criminal cases. That's something we absolutely need to have in Virginia. I like the fact we're adding appellate judges. The senator from Rockingham made the correct point that it takes too long to have your appeals heard in Virginia. But one of the problems is we don't have enough appeals judges. So we don't have enough appellate judges, and it's taken too long to get appeals heard finally and get finality. Then there's the issue of civil appeals. And this is where I tend to join hands with the senator from Rockingham that to date, the way civil appeals works is you file in the Supreme Court, and you have to have a petition to get a writ. And if you do get a writ, then you finally get in front of the whole court. But it's a two-part process, and it is basically stacked against appellants. Now, if I won the case at the trial court, I think it's a great system. If I lose the case, I'm not so happy with it. The bottom line is you ask the senator from Rockingham where this ends, how many more judges? It's going to end as soon as Senator from Eastern Fairfax has one of his jury verdicts vacated by the Court of Appeals. Then it's going to end. Till that time, we're going to be in favor of it. Thank you.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 1261? Seeing none, the question is, shall Senate Bill 1261 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 1261 passes.
Senate Bill 1262, a bill relating to redistricting license, restricted licenses, payment of fines and cost.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I hope that this bill doesn't raise as much of a storm as a previous one. This is a very simple and practical bill. It eliminates the requirement for a defendant to prepay all fines and costs before he is otherwise eligible to receive a restricted driver's license. That's it. Currently in Virginia, individuals who are eligible to receive a restricted driver's license are required to pay those fines and costs. Last year, you recall, we passed a law that said if your license that stated you did not have to pay fines and costs before you get a license. This, I think, slipped through the cracks. It allows somebody who is eligible for a restricted license to get it. And we all know what this means. A restricted license allows you to drive from point A to point B. It's often point A is your home, point B is your work, allows an individual to continue work, assist his family, and at the same time not be susceptible to being charged with driving on a suspended license for doing just that. I'd ask that the body pass the bill.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1262? Seeing none, question is shall Senate Bill 1262 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 28, noes 11.
Ayes 28, noes 11. Senate Bill 1262 passes.
Senate Bill 1278, a bill relating to charitable gaming regulations, Texas Hold'em poker games.
Senator from Loudoun County, Senator Bell.
Thank you, Mr. President. Move passage of the bill and speaking to the motion.
Senator, has the floor.
This bill provides some clarification. We did pretty broad legislation in this area last year. It basically clarifies the Department of Agriculture Consumer Services will have authority to regulate and approve operators of Texas Hold'em poker games, and also clarifies and differentiates between tournaments and table games. This bill also has a reenactment clause, so it would have to be passed again during the 2022 session for it to go into effect in lieu of some of the other discussions we've had in this area. With that, I renew my motion for passage.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1278? Seeing none, the question is shall Senate Bill 1278 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 34, noes 4, Rule 36-1.
Ayes 34, noes 4, Rule 36-1. Senate Bill 1278 passes.
Senate Bill 1282, a bill relating to greenhouse gas emissions inventory.
Junior Senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I move for the passage of SB 1282 and speaking to the measure.
Senator, has the floor.
Mr. President, members of the body, you recall that during the 2020 session, the General Assembly passed legislation related to Virginia's energy policy and certain objectives. One of those objectives was to reduce greenhouse gas emissions to net zero by 2045. The current law does not provide DEQ or the Air Board with the authority to gather the necessary data to develop a robust inventory or a database of emissions. This bill does the following. It directs the Department of Environmental Quality to develop a comprehensive greenhouse gas emission inventory and provides the State Pollution Control Board with the authority to develop the regulations for same. With that explanation, Mr. President, I'd ask that the body pass SB 1282.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1282? Seeing none, the question is, shall Senate Bill 1282 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 22, noes 16.
Ayes 22, noes 16. Senate Bill 1282 passes.
Senate Bill 1284, a bill relating to the Commonwealth energy policy.
Senator from Arlington, Senator Favolo.
Thank you, Mr. President. I move that the bill pass, and speaking to that motion.
Senator has the floor.
Thank you, Mr. President. What this bill does is it streamlines and takes out some redundancy in a measure that we passed last year. It is the Commonwealth's energy policy and energy plan. I'll just highlight three things in the bill. First, it articulates again that the greenhouse gas emissions, we need to reach a net zero with greenhouse gas emissions across all sectors by 2045. It does do a better articulation of stating that our state agencies will be acting aggressively to reach this goal, as well as the other sectors of our economy. Most importantly, the stakeholders who have endorsed this bill are wide-ranging, from the environmentalist community to all of the industry stakeholders. We did emphasize language in this bill that says, quote, "Nothing in our sections shall preclude reliable access to electricity and natural gas during the transition to renewable energy." So we do acknowledge that we are in a transition period, and we have to take measured approaches to get to our ultimate goal. Having explained the bill, again, I ask that the bill pass. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1284? Seeing none, the question is, shall Senate Bill 1284 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 1284 passes.
Senate Bill 1289, a bill relating to health insurance, career business practices, provider contracts, carrier business practices, provider contracts.
Senator from Eastern Fairfax, Senator Sarvell.
Thank you, Mr. President. I move the bill pass, and speaking to the motion.
Senator's the floor.
Thank you, Mr. President. Senate Bill 1289 is yet another one of my bills, which is a shadow of its former self. The original bill was a reprise of a fight that Senator Barker tried to engage in last session that got bollocksed up in the Herc, and that's pretty much what happened with 98% of this bill. There was one little piece that the health insurance carriers and the hospitals agreed with, and that is to include provisions in their contracts prohibiting doctors from discriminating against car accident victims if they have health insurance. And that's something the carriers already do anyway, so it wasn't a big deal to anybody, and this just confirms that existing practice. So I'd hope the bill would pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1289? Seeing none, the question is, shall Senate Bill 1289 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. Senate Bill 1289 passes.
Senate Bill 1301, a bill relating to correctional facilities' use of isolated confinement.
Junior Senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I move that Senate Bill 1301 pass, and speaking to the motion.
Senator, has the floor.
Thank you, Mr. President. Mr. President, this bill prohibits the use of isolated confinement, more typically known as solitary confinement, in state correctional facilities, in juvenile correctional facilities, and there are exceptions. Currently in Virginia, there is nothing preventing DOC inmates from being incarcerated for actually years. One DOC prisoner was incarcerated in solitary confinement for 16 months. There is empirical evidence that shows that after a certain number of days, there are very debilitating mental and physical effects on an individual. There are alternatives that can be used. They're spelled out in the bill. And for those reasons, Mr. President, I'd ask that the body pass SB 1301.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1301? Seeing none, the question is, shall Senate Bill 1301 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 23, noes 15.
Ayes 23, noes 15. Senate Bill 1301 passes.
Senate Bill 1310, a bill relating to the employees providing domestic service, the Virginia Human Rights Act, application of laws applicable to employee safety and payment of wages.
The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that Senate Bill 310 pass, and speaking to that.
Senator, has the floor.
Thank you, Mr. President. When most of the worker protection laws were passed across the country, including here in Virginia, certain employees, certain workers were excluded. And in most of those cases, these were jobs that at one time were done by slaves, and then were only jobs available to African Americans. That was the minimum wage bills, workers' comp, the Human Rights Act, unemployment insurance, many worker protections that other workers take for granted. We have made progress over the years, removing some of these Jim Crow era exclusions. Last year, specifically for domestic workers, we removed the exemption from the minimum wage. What this bill does is remove the exemption for the Human Rights Act and for the Department of Labor and Industry's health and safety standards. It codifies what DOLE already does, but makes clear they have the authority to do. And with that, I move the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1310? Seeing none, the question is, shall Senate Bill 1310 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 1310 passes.
Senate Bill 1315, a bill relating to criminal proceedings, consideration of mental condition, and intellectual and developmental disabilities.
Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that Senate Bill 1315 pass. And speaking to that.
Senator's the floor.
Thank you, Mr. President. Senate Bill 1315 would mitigate some of the challenges that individuals with mental health conditions and intellectual and developmental disabilities face when they get ensnared in the criminal justice system. Currently, there is nothing short of pleading not guilty by reason of insanity, but for many of these individuals, they do not have the capacity to have the intent for the crimes charged. There is no ability for them to provide any evidence of that at the guilt or innocence phase. There is no ability for a judge to consider their condition in making bail determinations or in sentencing. This has hit individuals with autism particularly hard. And last year, when an effort to work with the Supreme Court and the Secretary of Public Safety to make accommodations for these conditions was unsuccessful, I worked with a group of UVA law students at a clinic for state and public policy where they researched this issue and came up with this bill with input from disability experts, defense attorneys, and this bill will now allow that evidence can be presented on their condition at trial and can be considered for bail determinations and sentencing. And I ask the bill pass.
Thank the senator. For what purpose is Senator from Northwestern Fairfax? Senator Boysko rise.
Thank you, Mr. President. To briefly speak on the bill.
Senator's the floor.
I just want to express how grateful I am that we have this bill in front of us today. I have worked with a number of my own constituents who have family members who have been caught up in the criminal justice system with individuals who have really no idea what they had done wrong and were never given the opportunity to really have the education or have someone with them to help manage this situation. I'm just so grateful that we have this opportunity to vote for it today, and I urge the bill's passing.
Thank the senator. For what purpose is Senator from Hanover? Senator McDougall rise. For what purpose is the senator from King George? Senator Stewart rise.
Mr. President, would the gentlelady yield for a question?
Will Senator yield?
I yield.
Senator Yield, you have the floor.
Thank you, Mr. President. I'd ask the gentlelady, you are aware that we passed a bill a couple years ago that I sponsored and worked on for a long time to give these folks the ability to have cases taken under advisement by a court for exactly the same reason that you've expressed regarding this bill. And I apologize, but I missed this bill somehow up until now. Does this in any way conflict with that, or would it in any way restrict those defendants' ability to have that case taken under advisement? They already had the ability to introduce evidence to this as you would give them in this bill, and that law we passed gave children with autism or adults with autism or those on the autistic spectrum and others as defined the ability for the judge to actually take the case under advisement and dismiss it.
Senator's the floor.
Mr. Chair, I would say this complements, it does not conflict or take that away. And unfortunately, I would love for the gentleman's bill to have been enough to address these situations, but it's not. And one piece of the bill I did forget to mention, it also provides training for judges and other individuals in the system on these types of conditions. What the bill would allow is not just can you take the case under advisement, but can you take evidence or even consider these conditions for bail determinations, which the gentleman's bill didn't address, for sentencing, which the gentleman's, if you are found guilty, and whether or not you have the requisite mens rea. And I'll give you, if that does not answer the gentleman's question, I can give him some examples of where judges felt they could not take this information into consideration at all.
Mr. President.
Further question?
I do not oppose the bill. Don't misunderstand what I'm saying. I support this type of effort. I think it's very important. I've worked with these defendants before. I have personal experience with children with autism, having one. I just want to make sure that you setting this out in specificity does not in any way limit what they, because there was no limit as to what they could do before. So that's all I'm asking. Thank you, Mr. President.
Thank you. Senator. What purpose does the Junior Senator from Richmond City, Senator Morrissey, rise?
Speaking to the measure, Mr. President.
Senator's the floor.
Mr. President, the gentleman from King George was absent from judiciary that day, but I can assure the gentleman that his bill passed a couple of years ago that I was not in this body at the time. This bill would not detract one iota from the judge being able to take the matter under advisement. Here is the problem. This is just an app. Somebody earlier said that this might be the most important bill this session. I think it was the chairman of Judiciary, Senator Edwards. But this bill is crucial, Mr. President. Right now, there is a huge chasm, a divide between I'm not guilty versus I'm not guilty by reason of insanity. And so often, a defendant wants to get in evidence concerning his mental health condition. And the judge says, did you, and the prosecutor's going to object. Senator Sproul, the prosecutor will object and say, no, they haven't pled not guilty by reason of insanity, and the judge must sustain that and won't let any evidence come in regarding the defendant's mental health condition. On Chamberlain Avenue in this city, there are a lot of group homes where the city or the state pays a certain amount of money for the people to stay. And those individuals walking down there, they hear voices. They talk to people that aren't there. Where we might see a police officer, they see Darth Vader attacking them. There are some mental health deficits that are clear. But you want to get that in a trial? You're not going to be able to do that unless you plead not guilty by reason of insanity, and there are a lot of hurdles until you get to this point. This bill is so necessary. I really hope that not only will the senator from King George support it, but those nays in judiciary, that they also have a change of heart and realize the necessity of this very important bill.
Mr. President.
Thank you, Mr. President.
Would the senator from, junior senator from Richmond yield for a question?
Senator Yield.
I will.
Senator Yield, you have the floor.
Mr. President, I wanted to get your interpretation, because I think where some of us have some concerns is the definition. As you go back through the new code section, you can get in evidence tending to show the defendant did not have the mental state required for three things. If there's a developmental disability or intellectual disability that's already defined, which I think most people are comfortable with, autism spectrum disorder as defined on the Diagnostic and Statistics Manual, which I think most people are comfortable with. But then the other item is mental illness as defined earlier in that definitional section. And Mr. President, I ask the gentleman, as you read that definition of mental illness, it means any disorder of thought or mood. So any depression, any anxiety, anything of thought or mood can now be introduced at a trial. And Mr. President, I would ask the gentleman, does that code section give you any cause for concern that somebody could be having a bad day, a disorder of thought or mood, and now all of a sudden we're going to be introducing that into a criminal trial of whether they had the mens rea to commit an offense?
Senator, the floor.
Mr. President, I would tell the gentleman that it gives me zero concern for the following reason. I think there is a big difference between a mental health issue versus having a bad day. I absolutely believe that whether it's something as small as depression or otherwise, if there's a mental health issue, that should be allowed in the defendant's case in chief. Now, let's be clear. A Commonwealth attorney, a zealous Commonwealth attorney, is going to attack that defense. But I absolutely believe if there's a viable mental health issue, that you ought to be able to bring that in front of the fact finder, the judge or the jury, and then be allowed to say, judge or jury, my client did not have the requisite mens rea, the scienta, the criminal intent to commit the crime. I know that the prosecutor may rebut that, but right now I would tell the gentleman from Hanover, you can't get into any of that. I'm not just talking about a bad day, but a viable, measurable, determined, assessed mental health deficit cannot come in front of that fact finder. That's wrong.
Further question?
Just speaking to the bill.
Senator's the floor.
Mr. President, I certainly understand the gentleman's thoughts, but I think that the way this is worded is much broader than that, because it says disorder of thought, mood, emotion, or perception. And Mr. President, it could be ADD, ADHD, certainly things that are more significant than that, but it could be any of those things. And Mr. President, as we look now at how we're going to handle cases, you're able to argue that because of that condition, even though the act might have been committed and there's no disagreement about whether the act committed, whether you should be culpable or not. And Mr. President, as we go down through this conversation, I think that we should be more specific as we're looking at that in making determinations of whether we think something on that mental illness should be a reason, a trier of fact, should be able to not hold you liable for an act that everybody agrees was committed. I think this code section with that particular item, mental illness as broadly defined as it is opening Pandora's box as we go through this process, and we're going to see some issues as we come back. So, Mr. President, I'm going to vote against this statute because that particular section is in place, and I do not think we have defined it as succinctly as it needs to for it to move forward.
Thank the Senator. For what purpose, Senator from Henrico? Senator Donovan, rise.
Mr. President, with respect to the patron, because I do have a desire to resolve some of these problems, I wonder if this could go by temporarily.
Senior Senator from Richmond City, Senator McClellan.
Yes, Mr. President.
Without objection, Senate Bill 1315 will go by temporarily.
Senate Bill 1316. A bill relating to child care providers, background check portability, subsidy pilot program report.
Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. Senate Bill 1316 is a bill that will help begin to stabilize our child care and early childhood education system, which has been devastated by COVID. Before COVID, we already had a shortage of high-quality child care, particularly infant care, in the Commonwealth. And since COVID, over 30% of our child care facilities remain closed, and over 1,000 have closed permanently. This bill starts to address that in two ways. First, it allows portable background checks for teachers and the employees at these centers. Currently, you have to have a background check every time you apply for a job at a center. If you're applying for 3 jobs at one time, that's 3 background checks, because the background check doesn't follow you as the employee. It follows the place where you are employed or applying. This changes that to say once you get a background check, which is good for 5 years, that's current law, and you change jobs, that background check follows you, and the employer just will have a certificate. You provide the employer basically a certificate that shows you have that background check. The bill also starts to address how child care is funded. Currently, federal subsidies are used based on attendance in a child care center, not enrollment. But that provider has to make staffing and equipment decisions based on the number of kids enrolled, because they have no idea on any given day how many might attend. So this creates a pilot program where the Department of Social Services can contract with providers to begin to use those funds based on enrollment and based on some factors on what is equitable and quality care and employment. And finally, it creates a work group between the Department of Education and the School Readiness Committee to evaluate that program and how other strategies for how we can begin to change how we fund child care and early childhood education to shift to a model that makes it easier to provide the quality service with very highly qualified professionals and yet not price child care out of the reach of so many Virginians. With that, I hope the bill passes.
Thank the senator. For what purpose does the senator from Roanoke County, Senator Suterline, rise?
Thank you, Mr. President. Will the senior senator from Richmond yield for a question?
Senator Yield?
Yes.
Senator Yields, you have the floor.
Thank you, Mr. President. I have been reading too many things on electronic devices, and so I would like some clarity on, it's on page 10, section lines 572 to 594. The explanation there about the background check portability. Could you speak to the discussion of a complaint of child neglect in there and in which regard that is? Is that something that was found previously or there can't be an active one? If you could just clarify that for me.
Senator, the
floor. Appreciate it.
Mr. President, I believe based on the line numbers he gave me that he is talking about currently. This does not change what barrier crimes would prevent you from being a child care employee. All this is dealing with is the actual check, whether you have to get one every time you apply or not, whether it follows you or not. So I'm not sure I understand the gentleman's question.
Further question?
Yes, I'd like to perhaps ask my question in a different way then.
Senator Yield? Senator from Richmond City?
Yes.
Senior Senator? Thanks. Senator Yields, you have the floor.
Thank you, Mr. President. The question is regarding if there's a current complaint against the person. Is it that they are exempt provided that 5 years ago in the check that was done sometime between present and 5 years ago that there was not a complaint of child neglect? Or is there some way that it could be checked that it currently is out there? And I'll just speak to the concern is under the current law a few years ago in the Roanoke Valley, we had an issue with a worker that in this field who had a complaint out that was unknown to their employer, and it was only discovered because things weren't going well there, and they said to one of the parents, "I'm sorry, I'm under great distress because I lost care of my child recently." which of course put those parents in even greater distress because there was already an issue. And so I'm just trying to square where we are here.
I understand the question now.
Senator's the floor.
Thank you, Mr. President. So the way this, that would, if there is something that happens, the employer could find out. So the way this works now is when you get a job at a provider, you get your background check when you apply. And that background check is good for 5 years. And you don't get another background check unless it's 5 years later or you leave and go apply to work somewhere else. What this bill does is say you get your background check, and then when you apply for a job, you essentially have a certificate of qualification, for lack of a better word, a certificate that you have passed a background check that you have to provide when you apply for a new job. So if something happens since you've had your background check, the Department of Social Services has that and will notify either your current employer or when you apply for a new job. So I think hopefully that answers the gentleman's question.
Mr. President, I thank the senator.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1316? Seeing none, the question is, shall Senate Bill 1316 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 38, noes 0.
Ayes 38, noes 0. Senate Bill 1316 passes.
So it was announced earlier today that we are communicating in batches with the House. So I'm supposed to announce that we will send a batch of what we have passed at 1:00 p.m. If anyone would like us to hold a bill, let us know now. So if there's something in this batch that has passed and you want to hold it to reconsider, see Nathan. Otherwise, it's gone.
Senator from Fauquier, Senator Vogel.
Thank you, Mr. President. Going back to page 13, Senate Bill 1301, having voted on the prevailing side by which we passed Senate Bill 1301, I would like to ask that that bill be reconsidered so one of our members may vote. Thank you, Mr. President.
Thank the senator. Question is, shall the vote by which Senate Bill 1301 passed be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 38, noes 0.
Ayes 38, no 0. The motion is agreed to. The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I move for the passage of SB 1301 and speak to the measure.
Senator's the floor.
Mr. President, for reasons that were previously articulated a few moments ago, I'd ask that the body support and pass SB 1301.
Thank the senator. For purposes of the senior senator from Fairfax, Senator Sasslaw, rise.
Would the senator from Richmond yield for a question?
Senator yield.
Excuse me, I yield.
Senator yield. Yield the floor.
This has been through various forms. Does this ban this confinement in all circumstances?
No, sir. I would tell the senator, Mr. President, that no, it does not ban it in all circumstances. In fact, on lines 26 and 2040, it's what I would call a safety valve, which allows for solitary confinement to be imposed under certain circumstances.
Further question? Further question?
Further question.
Senator Yields? Senator from Richmond City?
I do yield, yes, sir.
Senator Yields, you have the floor.
And that's without a time limit?
Without a, excuse me, Mr. President, without a what?
Time limit?
Without a time. Yes, it was amended because at first it said after 48 hours, and then it was in a change to say an additional 48 consecutive hours or longer if necessary in order to complete the investigation.
Thank you.
That was inserted at the request of DOC, Mr. President.
Okay. Thank the gentleman.
Thanks, Senator. Question is, shall Senate Bill 1301 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 23, noes 16.
Ayes 23, no 16. Senate Bill 1301 passes.
On page 16, we don't have a bill. On page 17, Senate Bill 1318. A bill relating to Environmental Justice Interagency Working Group.
The senior senator from Chesterfield, Senator Hashmi.
Thank you, Mr. President. I move that SB 1318 pass, and speaking to that measure.
Senators, the floor.
Thank you, Mr. President. SB 1318 is directed towards environmental justice. This is the Virginia Environmental Justice Act. Last session in 2020, we passed the definitions of what we mean by environmental justice within this Commonwealth. This bill seeks to formalize that process, to establish the working group as an interagency working group that assesses the processes and the resources that are required for all state agencies to adopt agency-specific environmental justice policies. It is bringing together all 10 secretariats of the administration to cooperate in addressing the issues of environmental justice throughout the Commonwealth. And with that, Mr. President, I move that the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1318? Seeing none, the question is, shall Senate Bill 1318 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 22, noes 17.
Ayes 22, no 17. Senate Bill 1318 passes.
Senate Bill 1326. A bill relating to local cigarette taxes, regional cigarette tax boards.
Senator from Augusta, Senator Hanger.
Thank you, Mr. President. Having voted on the prevailing side whereby that bill was engrossed and passed a third reading, I move that we reconsider that vote.
Thank the senator. The question is, shall the vote by which the bill was engrossed in advance to its third reading be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The motion is agreed to. Senator from Augusta, Senator Hanger.
Thank you, Mr. President. With the bill now being on second reading, I'm awaiting an amendment that will hopefully make this an easy vote for the members, so I move we pass it by temporarily.
Thank the senator. Without objection, Senate Bill 1326 will go by temporarily.
Senate Bill 1333, a bill relating to pharmaceutical processors' cannabis products.
Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, I move that the bill pass.
Senators, the floor.
Second, please. Could that go by temporarily, Mr. President?
Without objection, Senate Bill 1333 will go by temporarily.
Senate Bill 1339, a bill relating to expungement and sealing of police and court records, expungement fee fund created, protection of public record information, penalties.
Senator from Eastern Fairfax, Senator Servo.
Thank you, Mr. President. I move the bill pass, and speaking to that motion.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen, this bill has a little bit of complexity to it, and I hope you'll indulge me while I just explain to you what it does. It's a bill that basically completely revamps our expungement and record sealing system for people who are either acquitted or convicted of crimes. First of all, it expands our existing expungement system to allow people to expunge underage alcohol convictions or deferrals. Same thing for underage marijuana possessions or deferrals or underage tobacco convictions or deferrals. It builds on our existing system for that. Secondly, it creates a small automatic sealing program. Senator Lucas has been a leader on this issue, carried a bill during the special session and also this year, which has rolled into this, which was recommended by the Crime Commission. This is a smaller version of that, but it basically allows the automatic sealing of class 3 or 4 misdemeanors where nobody was arrested. Class 3 and 4 misdemeanors don't carry jail time, but every once in a while somebody gets arrested. Traffic offenses and all, it allows for automatic sealing of those. The big thing it does is that for convictions, either class 1 or 2 misdemeanors, undefined misdemeanors, or class 5 or 6 felonies, it allows somebody after a period of time and showing good behavior and showing they've been rehabilitated and showing and also just not having certain types of convictions to petition to a judge with a notice to the Commonwealth Attorney and after an evidentiary hearing to have a conviction sealed up to 2 in their lifetime. DUIs and domestic violence convictions are excluded from this pursuant to an amendment you all made yesterday. There are restrictions on the time frames within which you can petition for this based on the nature of the crime. For example, moral turpitude crimes or the level of the crime, you have to wait longer for the more serious the crime is. And in order to get a record sealed, you have to show there's a manifest injustice, and you have to show you're no longer addicted to drugs or alcohol. What it does is it injects discretion into this type of system. So it's not automatic, it's discretionary, which is very important. That's the way it's done in most of the states that do this. In terms of one of the things that we heard during the process was that people were concerned that a petition process would limit access to record sealing. So we created a court-appointed attorney fund, which is funded by the expungement costs that are paid on sealing, the fees that are paid on sealing petitions. So every time somebody files a petition to seal, that money is put in a fund which pays for court-appointed people who would otherwise qualify for court-appointed counsel. The second thing we did is we created a process by which when a charge is dismissed, the lawyer, while standing there, can ask for an expungement. If the Commonwealth Attorney does not object, the charge can be expunged right there on the spot for dismissals. And that's important for some reasons I can get into if anybody wants to talk about it. Another thing, the way this differs from other bills, is that this allows people who are hiring people for certain jobs to access sealed records with the consent of the person applying for the job, and they can ask for it depending on the nature of the job. There's a list of different employers which are included on that list, and also the state police is given discretion to promulgate regulations to greenlight certain employers to ask about criminal convictions that have been sealed. For example, anybody who's applying for a job that requires a federal security background clearance, the federal government can see everything, whether we seal it or not. And so it's important that employers know that they're not hiring somebody that's going to fail a background check. The next thing it does is we took the language from Senator Lucas's bill about data brokers and we incorporated it into this bill. We made some slight modifications to it. Both my original bill, Senator Lucas's bill, and this bill contain a private right of action against data brokers. That's been in all three bills from the very beginning. The amendments we made in the Finance Committee simply added a cure process, which is a more business-friendly approach to the matter. The reason it's important to have data broker liability is because we can seal or expunge things all day long. But if private corporations continue to publish information about charges that have been expunged or sealed, the expungement or the sealing is completely worthless. It'll continue to show up in an employment background check or a landlord-tenant screening or an insurance screening. Or there's these other services that just sell information if you want to check out your neighbor, who are completely unregulated right now. The last thing, Mr. Chairman, Mr. President, is the bill has a 3-year delayed enactment clause, which is necessary to implement the computer infrastructure to get this done. It also creates a working group to talk about ways to better refine the record-keeping process to see if there's ways we can sort of destroy records instead of keeping them sealed. There's some offenses where we probably don't even need to keep the records, but basically, right now, all we do is seal them, and under this, all we'll do is seal them and sort of park them in a file cabinet. But it's a pretty complicated bill, Mr. President. I'm happy to answer any questions anybody has, but that's sort of a summary of what it does. Hope we can pass it.
Thank the senator. For what purpose, Senator from Rockingham, Senator Obenshain rise.
Mr. President, rise. Ask the senator from Eastern Fairfax if he will rise to answer a couple of questions.
Will Senator yield?
I'll yield for a couple of questions.
Senator yields for a couple of questions. You have the floor.
Mr. President, I would ask the gentleman, yesterday, as I was listening to the explanation of the substitute that was laid on the table and submitted, my recollection was that it was described as essentially addressing the sealability of records related to DUIs. But in going through the bill, I see sections E and F on lines 658 through 676. Are those new provisions that were not taken up in Finance or any other committee?
Senator, has the floor.
No.
Further questions?
Mr. Chairman, I'm happy to elucidate further, but the only thing in the amendment yesterday, and I can cite you to the exact lines if you want to know them, was that we excluded DUIs and domestic violence convictions from the ambit of the bill. That's the only thing the sub that yesterday did, and I give you the line numbers if you want to see them. The bill that came out of the Judiciary Committee had a private right of action in it, and the only thing that was added in Finance relating to that section was we created an opportunity for the company that sued to make a cure offer so that they could say, hey, I'll fix this problem and you can't sue me. And that was what was added there. I would note that the only other thing that was added in the Finance Committee as part of those amendments was the right of the consumer to request a copy of their own report. That was requested. And there was also a provision added that requires the state police to confirm the identity of the data screening company before releasing a list of expunged charges to them, which is critical because there are these fraudsters in other countries that want to get their hands on this data to put it on the internet and extort people. And so it just requires the state police to confirm they're dealing with legitimate companies when these lists are given out of very sensitive information. That was the only things that were added in the Finance substitute.
Right. Mr. President, speaking to the bill.
Senator, the floor.
You know, in going through this, this is a complicated bill, and these data companies are data companies that many businesses rely on for information that they get in background checks on people who are applying for jobs. And I know that we are providing for the expungement of certain offenses, but what this bill also requires is that these data companies go back and after they have already collected this information about criminal offenses, it requires them to purge that from their records, which is fine, and it's a policy decision that we may have made, but we're asking a lot of these companies. And the bill, as it existed, it allowed for the Attorney General's office to essentially pursue complaints and pursue remedies against these data companies if they fail to purge their records and take out expunged offenses. And it provides for up to $2,500 civil fine against these companies. And it put that squarely in the Attorney General's lap. What sections E and F on line 658 to 676 do is something dramatically different. It creates an individual cause of action. So if I've been convicted of or if I've been had an offense expunged from my records, yet ABC Corp, which collects this data and provides it with consent, my consent, to potential employers, hasn't deleted it by accident or intentionally or otherwise. This gives me the ability to make a complaint, to allege that that's a violation of this statute, to sue ABC Corp for violating this statute. The remedies are not capped at $2,500 as the Attorney General's remedy is capped, but it is the greater of $1,000 or actual damages. So, heck, if I don't get the job, I'm going to claim it's because of that information that was in the report. And I'm going to claim that I've lost $100,000, $200,000, $300,000 from my inability to get that job. So it's the greater of $1,000 or actual damages, but that's not all. It is also attorney's fees and costs on top of that. But as Senator from Eastern Fairfax points out, it does have the letter of cure, which sounds good, but it's not so good. It's what federal rules of civil procedure call an offer of judgment, basically, pursuant to which ABC Corp can say, all right, Obenchain, I know, we screwed up. We forgot to purge that out of the records. We're going to make an offer of judgment to you of $1,000 or an offer of cure. And I can accept it or I cannot accept it. And they would be excused from paying those attorney's fees, but only if the judgment that comes in is less than $1,000. If it's more than $1,000, they get tagged for everything. So, this goes well beyond expungement. This goes well beyond what I think that the committees took up, or at least what the Crime Commission took up. But then again, I wasn't in the Crime Commission. I don't think anybody on this side was on the Crime Commission, had an opportunity to participate in that. But I just caution the members that this is opening Pandora's box. It's creating a big new remedy for a big new statute, which already had enforcement provisions, and it's creating this brand new large lawsuit without even figuring out first whether the executive or administrative enforcement provisions are even going to work. So I would suggest that members vote no.
Thank the senator. For what purpose, Senator from Hanover, Senator McDougall rise?
Thank you, Mr. President. Mr. President, speaking briefly to the passage.
Senator's the floor.
Thank you, Mr. President. Mr. President, yesterday I asked the senator from Eastern Fairfax if this legislation enabled you to have your record sealed for embezzlement. And I think I asked him about a specific term, and he indicated yes. Mr. President, I think that some of the items in this bill are really important, and we could all coalesce around there are a number of misdemeanors that we could coalesce around being expunged and or having your record sealed. But Mr. President, when we move forward to things, employers have a right to know if somebody has been convicted of grand larceny, which means they stole over a certain amount of money, or embezzlement from another employer. And Mr. President, as we move forward in this continued discussion, I will be voting no on this legislation, but I hope as we go forward, there will be a recognition that there are some offenses that the public has a right to know if you've been convicted of them. And particularly, employers have the right to know before you would be employed if you embezzled money from a previous employer.
Do any senators other than the patron wish to be heard regarding Senate Bill 1339? Seeing none, Senator from Eastern Fairfax, Senator Searville.
Thank you, Mr. Chairman. So let me just try and assuage your all's concerns about a couple things. First of all, as I said earlier, employers, if they're hiring for certain jobs, are allowed to ask about charges that have been sealed, like embezzlement. They're allowed to ask if they're in a certain category. And if there are other employers that don't feel like there's a category in the code that, as written that applies right now, they can ask the Virginia State Police to include them in the regulations that are going to be promulgated. But we dealt with that, and that's how it's dealt with in most states. If you're concerned about the absolute expungement of larceny offenses, I would suggest that you vote against the version that the Crime Commission recommended that might be coming over, because that one automatically expunges petty larceny and grand larceny convictions. Automatically. This one requires you to go in front of a judge and show that you've changed your ways, that you're not still breaking the law. And so if you have one that's 10, 15, 20 years old, I would think you'd be able to show that if you lived a good life after that. That's what this one does. It injects discretion in the system. The second thing, in terms of the Attorney General authority, the AG's authority and the private right of action have been in every single bill that was introduced this session. It's not, the private right of action is not anything new. And so I would also note that it's not clear to me that folks understand what the current state of the law is. Since 1993, when the Fair Credit Reporting Act was adopted, and then when it was amended in 2005, whenever you do a background check for employment, or whenever you do it for housing, whenever you do it for insurance, there's liability under the Fair Credit Reporting Act for publishing inaccurate background checks. That's been the law in the United States of America now for 2 decades. And so if a background check company publishes an expunged charge, right now, today, you can sue them. If a landlord gets an inaccurate report, you can sue the background check company. That's the law today. What this bill does is it gets to the companies that are selling the data to the screener companies, because you cannot sue the companies that aggregate the data and keep these massive databases about all 39 of us and then sell it around. They are the source of the problem, and they have escaped liability under federal law so far. This goes after that. It also goes after a second thing, which is there is a class of unregulated data providers. For example, if anybody would like to see, I've been collecting these. I have a whole series of emails, solicitations from this company called My Life. And about every other day, they send me an email that says, Scott, negative items on your reputation profile can affect what people think of you. Look up your profile now. And every day, they send me... Yeah, and every day, about every week, they send me emails telling me, hey, I can also look up my dad and my brother because there's bad stuff about them. They also say, hey, look, here's your neighbors, and you can look up stuff about them. And because you're not pulling that data for an employment report, because you're a landlord-tenant situation, or because you're pulling it for an insurance policy to get some economic benefit, it is totally unregulated data. So these companies are currently allowed to put out all kinds of inaccurate information about you with zero liability. This bill is also designed to affect the proliferation of inaccurate information about every person in this room and every Virginian. So that is what it's aimed at. The employer situation was just described is already covered. The landlord situation is already covered. This gets at the people who are causing the problem. So, Mr. Chairman, this is going to be probably the first of, who knows, probably 4 or 5 times you're going to vote on this bill before it gets to the end between conference reports and everything else. I would just ask you to keep an open mind about it and keep this process going, and we're going to get a better product when we get to the end. I hope we can pass it today. Thank you.
Thank the senator. Question is, shall Senate Bill 1339 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 21, noes 17.
Ayes 21, noes 17. Senate Bill 1339 passes.
Senate Bill 1341.
Senator from Spotsylvania, Senator Reeves.
Mr. President.
Okay.
Having
Senator from Fairfax City, Senator Peterson.
Having voted on the prevailing side, I move we reconsider the vote for SB 1339.
Okay. Sorry, we're going to pause one second. So it looks like, just to update everybody, Senator Reeves' voting machine was not working. Senator Peterson was going to reconsider. We're just going to pause really quickly so the system can reset. Senate will briefly be at ease. Senator from Fairfax City, Senator Peterson.
Thank you, Mr. President. Hopefully you're referencing my past motion, which is to move to reconsider our vote for Senate Bill 11339.
Yes. Thank the Senator.
I so move. I haven't voted on prevailing.
Good. Question is, shall the vote by which Senate Bill 1339 passed be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 38, noes 0.
Ayes 38, no 0. The motion is agreed to. Senator from Eastern Fairfax, Senator Surville.
Thank you, Mr. President. I move the bill pass for the reasons having been previously explained.
Thank the Senator. The question is, shall Senate Bill 1339 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 1339 passes.
Senate Bill 1341, a bill relating to Health Insurance Association health plan for real estate salespersons.
Senator from Southern Fairfax, Senator Barker.
Mr. President, I move passage of the Association Health Plan for Realtors. And speaking to that measure.
Senators, the floor.
Mr. President, I first want to start by thanking the body for the support that you provided last year with overwhelming vote for this similar type of bill that would have allowed realtors to be able to establish their own health plan. In reality, the issue that's before us this year is very, very simple. If this bill is enacted, there will be a reduction in the number of Virginians with no health plan. Realtors, because of the very nature of the job and how they are employed, they're 1099 contractors. They are not able to receive, and most of them are not able to receive health insurance through the real estate company itself. 20% of them are uninsured, even though that by and large the income levels are not bad. However, if you vote against this measure, there will not be such a reduction. So we will continue to have many people who are realtors and who otherwise would be participating in a health plan that will be uncovered and at the vagaries of what might happen in that situation. As I mentioned yesterday, there are two significant changes that were made to the proposal this year. One is to limit it specifically to realtors, so there's not any other potential players that would come in and be able to establish such a plan, except for the Realtors Association doing it for the realtors across Virginia. Secondly, it reduces the age bands from 5 to 1, which is the norm in the private sector market, to 4 to 1. What this does is it provides more benefits to older workers than if this were a standard private insurance plan where that standard is a 5 to 1 ratio. So we have responded to some of the concerns that were made last year, expressed last year, and have addressed those, and I think have made this an even better bill this year. However, it's frustrating in the sense that opponents are continuing to misspeak and to mislead. There was a paper that was put out just recently that said codifying this would undercut ACA patient protections. That is simply untrue. And it's been repeatedly made, and we have basically made the point that that is not the case, that this plan, as well as the bill last year, provides the ACA patient protections have to be incorporated into the health plan. And the health plan would also be fully insured and have only one pool, a statewide pool, that provides further financial protections not always available for other plans that do meet ACA rules. So this plan is not a cheap, skinny plan. This is a plan that provides comprehensive quality coverage there. Some of the opponents have also speculated that having a health plan for realtors would increase costs for people with other health plans. That would be possible only if realtors were largely very young and healthy people. Now, despite the youth and vigor of the senators from Roanoke County and Augusta County, realtors are not disproportionately young. There is no evidence that this plan for realtors would have significant negative effects on anybody else. Some of you also may have heard an assertion that this plan is not health insurance coverage, and provided that as a basis for challenging this. Let me explain the situation. There is a federal law that provides a definition of health insurance. This is not something that was enacted as part of the ACA. It's a long-standing law. Over the decades that this law has been in place, the situations and the products for health coverage, as for many other things, have changed. Rather than making amendments to or rewriting the federal law to respond to this evolution, states across the country, who are the principal regulators of insurance, have developed exceptions to the federal provisions in that particular law. I'll give you examples. Banks and credit unions, including here in Virginia, combined to have a combined insurance plan that is provided across multiple companies, which is a violation of the federal law, because the federal law provides only for companies to be individual companies to be covered. But this has been approved and is operating in Virginia as elsewhere as an exception to that. In many states, although there may be few, if any, of these in Virginia, there are also labor unions that negotiate contracts with different companies for a common union health plan. That is, again, something in which it is done only as an exception to the federal law. And recently, 4 states have developed health plans for farmers and agricultural workers, even though the individual farmers are regarded as self-employed, which would not be authorized under the federal law. So 4 states have done that recently. We are mimicking the type of things that have been done in this bill here, but with some significant differences, and doing this as an exception to the federal law. The plan here would still be regulated by the SEC. That's been specified in the bill. And there is a requirement that the protections of the ACA have to be incorporated in this health plan. Let me repeat the issue based upon where we started out here. Do we want to get more Virginians covered in quality, comprehensive health plans, or do we want to leave them uncovered? I renew my motion for passage of this bill.
Thank the senator. For what purpose, Senator from Arlington? Senator Favola, rise.
Thank you, Mr. President. Speaking to the motion.
Senator's the floor.
Thank you, Mr. President. I have the greatest respect for my colleague from Southern Fairfax, and we have worked together on many health policy issues, and most of the time we're on the same page, sometimes we're not. I do want to say we're on the same page regarding the goals of this bill. We both absolutely want to reduce the number of uninsured individuals in the Commonwealth. And we know that those who are self-employed have fewer options than those who are working for a company where the employer could actually purchase the insurance. I just believe that we need to find a more secure way of providing insurance to these folks. As the senator from Southern Fairfax mentioned, that there is the federal law in the ACA actually prohibits individuals from participating in a large group plan, and that's what this bill is. There's a flat-out prohibition. Now, under the Trump administration, they had issued an executive order to sort of get us down this pathway, to provide for sole proprietors, if you will, to participate. However, there was a lawsuit, there always are, and so I appreciate our lawyers, but this lawsuit in New York actually said you cannot violate the ACA and ruled and just made a definitive ruling. The Biden administration in January 28th came out with an executive order that in effect rescinded the Trump executive order and reiterated the need to stay within the confines of the ACA. These are all very technical arguments, and I'm sorry I have to bore you with them. But my real concern as a policymaker is there's actually language in this bill. It used to be on between lines 182 and 185. I don't know where it is in the substitute that actually says it's not an insurance plan. It looks like an insurance plan, feels like an insurance plan, walks and talks like an insurance plan, and the courts have been ruling on the content of whether or not it's an insurance plan. Just because we say it's not an insurance plan doesn't make that so. And I know there's a lot of consternation on the part of our regulators about how they would regulate this, and the concern that, in fact, a carrier could come into the Virginia market and then be slapped with significant federal fines. So this is the most creative thing I've seen in a long time from the senator from Southern Fairfax, and I really appreciate your effort here. But it's just, to me, it's putting a square peg in a round hole, and I can't get there. I think for those of you who are going to vote for this, I completely understand. I've had many conversations with the realtors and their representatives. I just am in a different place right now. And for those reasons, I just wanted to explain why my vote is going to be red. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Bedford, Senator Newman, rise?
Mr. President, speaking to the motion.
Senator's the floor.
Mr. President, I want to thank the gentleman from Southern Fairfax for the amount of work that he's put into this. For those of you that don't know, realtors are in an odd position in that they are independent contractors, and many of those individuals do not currently have insurance. That's a problem. Now, there's some technical items in this bill that people can struggle with, I suppose, but the fact is that I don't know what more the gentleman from Southern Fairfax could possibly do to this bill to make it any better. There have been objections that have been brought up, and year after year, in some form or another, he's fixed them. And once again, he does what he does best. He fixed problems. This bill is about as clean as I think someone could possibly get. And if we really are concerned about, not about the political aspect of health insurance, but if we are concerned about people having insurance, I think you vote for this bill, Mr. President. Thank you, sir.
Thank the senator. For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
Speak to the bill.
Senator's the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I can only echo what the senator from Bedford has just said, and I also thank Senator Barker for his work on this bill. I've been contacted by a bunch of realtors in the Hampton Roads at the Hampton Roads Realtor Association, or like they like to call themselves, hurrah, have come out strongly in support of this. The fact is these folks are independent contractors, that they don't have the ability to get insurance at a reasonable rate right now. So this bill is critically important to them. So I hope that we'll all support the bill.
Thank the senator. Do any senators other than the patron wish to be heard on Senate Bill 1341? Seeing none, Senator from Southern Fairfax, Senator Barker.
Just very briefly,
Senator's the floor.
Mr. President. It's nice if we have common goals, but the difference is what we do to achieve those goals, and this bill moves us in the direction that we want to go.
Question is, shall Senate Bill 1341 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes a healthy aye.
The clerk will close the roll.
Ayes 38, noes 1.
Ayes 38, noes 1. Senate Bill 1341 passes.
He's gone. Senator Saslaw, we have a House communication. The last one.
Senior Senator from Fairfax, Senator Saslaw.
That's pretty good news, but I'd still move that we waive the reading.
Thank the Senator. The question is, shall the reading of the communication from the House of Delegates be waived? All in favor of waiving the reading will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 30, noes 9.
Ayes 30, noes 9. The motion fails.
Made me do it. Mr. President.
Need 32. Senator from Fairfax City, Senator Peterson.
Having voted on the prevailing side on that for the first time in 18 years, I move that we reconsider that vote.
Thank the Senator. The question is, shall the vote by which the waiving of the communication from the House of Delegates failed be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 38, noes 1.
Ayes 38, noes 1. The motion is agreed to. Senior Senator from Fairfax, Senator Saslaw.
Once again, I would move we waive the reading of the communications from the House of Delegates.
Thank the Senator. The question is, shall the reading of the communication from the House of Delegates be waived? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 35, noes 4.
Ayes 35, noes 4. The reading of the communication from the House of Delegates is waived.
Senate Bill 1350, a bill relating to transportation projects resiliency.
Senator from Accomack, Senator Lewis.
Mr. President, move the bill pass. And speaking to that motion,
Senators, the floor.
Mr. President, members of the body, 1350 tries to do about three things, and really, fundamentally, what it tries to do is introduce the two concepts of resiliency and transportation. I likened it in front of committee as sort of a first date between the two. The original iteration of the bill was a little more ambitious and actually sought to introduce resiliency into the smart scale evaluation process. This does not do that. And the senator from Bedford in committee had some concerns about that, but the Deputy Secretary of Transportation was able to alleviate those concerns, I think. So what this bill does now is just three things in regard to resiliency and transportation, Mr. President. The first thing it does is require, when the Commonwealth Transportation Board is about to put forth its list of projects for the 6-year plan, it adds resiliency as to what goes out on the public website in regards to those projects. Whether a project has been designed to be resilient is part of the disclosure there that occurs before they vote on the respective projects to go into the 6-year plan. The second thing it does is it includes resiliency in the Commonwealth statewide transportation plan. That's the plan that's required to be done every 4 years. It takes a 20-year tour of the horizon of transportation in the Commonwealth of Virginia. And so now, in addition to accessibility for people and freight, intermodal connectivity, transportation modes, it also adds resiliency. And finally, in the enactment clause, the Commissioner of Highways shall ensure resiliency is incorporated into the design standards for new construction projects. So if you live in Hampton Roads, if you live in coastal Virginia writ large, if you live in any one of the many areas of this Commonwealth that are incurring increasing problems with recurrent and significant flooding, resiliency is important. Transportation projects considering and discussing resiliency is important moving forward to ensure the long-term viability of these very expensive transportation projects. So that's what the bill does, Mr. President, and with that, I renew my motion that 1350 pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1350? Seeing none, the question is, shall Senate Bill 1350 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, noes 0. Senate Bill 1350 passes.
Senate Bill 1362, a bill to require employers to report outbreaks of COVID-19 emergency.
Senator from Accomack, Senator Lewis.
Mr. President, I move that 1362 pass. And speaking to that motion,
Senators, the floor.
Mr. President, members of the body, I don't think it's any secret that at the outset of the pandemonium in March, that my district was at the pointed end of the spear for a number of nail-biting weeks as we tried to get our arms around the enormity of this oncoming problem. You may recall that we had a couple of large congregate setting outbreaks in Accomack County, centered around primarily 2 of our poultry houses there. And let me at the outset state that once we got our arms around, again, the enormity of this impending crisis, those folks stepped up and implemented procedures that really ameliorated the problem within those 2 facilities. And by the time we had the second wave in this past fall, the poultry houses were no more worse than any of the other, than any place. They had no outsized number of outbreaks because of those procedures that they had implemented. But what Senate Bill 1362 seeks to do is provide some transparency in the time of this COVID crisis. And what it does is fairly straightforward and fairly simple. It requires employers 50 or more, with employees of 50 or more employees, to disclose when they have a worksite cluster, and that is defined in the bill as 5 or more case illnesses onset or initial positive within a 14-day period. Now, the second paragraph is the really important paragraph because that provides some guardrails. I worked with some of the large employers and stakeholders to try and, again, put some guardrails in this bill. I'm not saying that they're necessarily thrilled with it or that they support it, but that we worked with them to achieve this guardrail position, this guardrail paragraph here. So if you look at the second paragraph, it provides that a worksite cluster means 5 or more cases with illness onset within a 14-day period, but it also says a likely epidemiological linkage between the cases. Goes on to define what that linkage is, and you see verification by the department that the confirmed cases were in close proximity in the same work setting for a sufficient time period, that the timing of the contact fits within the likely timing of the exposure, and that it is more likely than not that the work site was the source for identified cases. So you see likely is used several times in there in order to make sure that the workplace was the scene of the focus of the spread and not community spread necessarily brought into the workplace. So I think that's a very important consideration. So what we're trying to do here, again, is provide transparency to the public. We saw hysteria break out as these cases continued to rise. Our 40-bed hospital was overwhelmed. They were able to decompress by sending patients over to Newport News facility there. But it was a very tense time. It also enables the workers to make choices, to give them the notifications, the necessary information, and to make the necessary choices about their own health, their own safety. And again, I think it also encourages employers to take the measures that are necessary to alleviate and ameliorate the outbreak at the particular employment site. And I'll also point out that the provision also has an all clear in here. That you notify the public of the outbreak on the health department website, but you also notify them when it's been resolved, and I think that's equally important as well. And this act only lasts in so long as the governor's declaration of emergency asks, and that's in the enactment clause. So again, I think this is an important measure in these uncertain times to provide the transparency, to let people make decisions and to give people knowledge. Knowledge is always power, and I think this provides that, but I think it does so with due consideration to the employers. So with that, Mr. President, I renew my motion that the bill pass.
Thank the senator. For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
Thank you, Mr. President. Will the gentleman from Accomack rise for a question?
Senator Yield.
Yes, I yield.
Senator Yield, you have the floor.
Thank you. This is a friendly question, by the way. I would ask the gentleman, is there still an emergency clause attached to this bill?
Senator,
yes.
the floor.
Yes, there is.
One question.
Would the senator yield for one final question?
I yield.
Senator Yield, you have the floor.
So how many positive votes do you need to have to make this bill pass?
My keen mathematical talents tell me 27.
Thank you, sir.
Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 13?
Mr. President, I've told I've been misinformed. It's 32 for an emergency?
It is 4/5.
I apologize to the gentleman. I know, right? I know.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1362? Seeing none, the question is, shall Senate Bill 1362 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 29, noes 10.
Ayes 29, noes 10. Senate Bill 1362 fails.
Mr. President.
The senior senator from Chesapeake, Senator Cosgrove.
Thank you, Mr. President. Having voted on the prevailing side where Senate Bill 1362 did not pass, I ask that we reconsider that vote.
Thank the senator. The question is, shall the vote by which Senate Bill 1362 failed be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote? Senator Chase.
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The motion is agreed to. Senator from Accomack, Senator Lewis.
Mr. President, could that bill go by temporarily while I try to find 3 people? or why 3 people leave. I'll take it either way. Thank you, Mr. President.
Thank the senator. Without objection, Senate Bill 1362 will go by temporarily.
Senate Bill 1363, a bill relating to State Board of Local and Regional Jails, membership powers and duties.
Senator from Western Fairfax, Senator Marsden.
Thank you, Mr. President. Mr. President, I move that Senate Bill 1363 pass, and speaking to that.
Senator's the floor.
Thank you, Mr. President, members of the Senate. This bill restores oversight of state correctional facilities to the existing Board of Local and Regional Jails. The board will have regional representation as well as at-large members who represent knowledge of correctional practice and concern. The board will reflect the gender, race, and ethnic diversity of the Commonwealth. I believe we have a well-administered Department of Corrections, but we need citizen oversight of an agency that exercises such total and complete dominion over the lives of Virginia citizens who may be incarcerated, and I reiterate my motion that the bill pass.
Thank you. Senator, do any other senators wish to be heard regarding Senate Bill 1363? Seeing none, the question is, shall Senate Bill 1363 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 28, noes 11.
Ayes 28, noes 11. Senate Bill 1363 passes.
Senate Bill 1380, a bill relating to electric utilities, electric school bus projects report.
Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Move that the bill pass.
Senators, the floor.
Yes, sir, Mr. President. I think people have heard this bill more times than they want to. And but what this bill does, it provides for our local schools to be able to utilize the electric school buses. And what's going to happen here is that the buses will be owned by the schools and the batteries will be owned by the electric company. And that pretty much sums up the bill.
Thank you, Senator. Do any other senators wish to be heard regarding Senate Bill 1380? Seeing none, question is, shall Senate Bill 1380 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 33, noes 4.
Ayes 33, noes 4. Senate Bill 1380 passes.
Senate Bill 1382, a bill relating to purchase, possession, or transportation of firearms following conviction for assault and battery on family or household member penalties.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. I move that the bill pass. In speaking to that motion,
There's the floor.
Thank you, Mr. President. What this bill does is it takes a federal law and put it into state statute. And I think it's a really important bill, and I'll continue to explain it. So for somebody who is actually convicted of an assault and battery, of a misdemeanor, of a household member, using the federal definition of a household member, which is narrower than the Virginia definition, that person would lose their firearm. I also have language in here that directs the Crime Commission to study the possibility of restoring the rights to bear firearm and to come back to the General Assembly with options. The intent of this bill is to keep household members safe from folks in their own household who obviously have anger management problems, who have violent tendencies, and unfortunately, in those situations, data tells us that violence always escalates. Oftentimes, an individual has been battered many times before they actually go to the police or can even find the courage to testify, so a conviction is granted. I will say that women in the United States are 21 times more likely to die by a firearm homicide than women in other high-income nations. And also, households where there are firearms have a tendency for suicide rates that are actually in the 30% range. This is not a large step. This is about protecting family members, This is something that we should embrace. We should want our homes to be a safe haven. We should want to prevent other violence. The crime for not turning in a gun or for possessing a gun under this statute or my bill would only be a Class 3 misdemeanor. No jail time and a fine of up to only $500. Many folks believe that that's pretty weak, but that's what it is. I'm trying to find that balance. 32 states and the District of Columbia already have this law on their books. I'm hoping we'll be willing to join Alabama, Louisiana, Texas, and Tennessee, among many other states, to get this bill passed. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Spotsylvania, Senator Reeves, rise?
Thank you, Mr. President. Speak to the bill.
Senator, the floor.
Mr. President, several years ago, we had a long discussion in this chamber about gun shows and concealed carry and some of these other things. And I remember sitting down with Governor McAuliffe at the time talking about what progress can we make on domestic violence. And this chamber decided that if you were going to have a permanent protective order issued against you, that you shouldn't have access to firearms. Mr. President, I still stand by that. I think that's worthwhile, and I think that's important, because if you are a victim of domestic violence and that person has done something that maybe was a malicious wounding that was pled down to assault, I don't think you should have that. But that's when a protective order is issued. Mr. President, make no mistake, this is a bill that could potentially have someone's Second Amendment right taken from a he said, she said warrant or a simple assault. I think it's one step too far. I think there are protections in place, as I just articulated. And with all due respect to my colleague, I disagree with her on this. And somebody who has had to go to multiple domestic incidences as a police officer, I understand how touchy some of these can be, and I'm sure some of the trial attorneys in here can also testify as to things aren't always as clear as they seem to be, especially when it comes to relationships and domestic violence situations. Mr. President, I would encourage this chamber to really look hard about what we're about to do if this bill were to pass. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Fairfax City, Senator Peterson, rise?
Thank you, Mr. President. Speak to the bill.
Senator's the floor.
Mr. President, ladies and gentlemen of the chamber, I actually am somewhat disappointed in Senator Favola, but not for the reason that she thinks. I was prepared to speak against this bill because the original version was one that I could not support, because to me it swept up people due to their status. In other words, people that had committed a crime years ago could get swept up unintentionally and basically placed in criminal jeopardy for doing nothing wrong. But the substitute, I think, cures that, and I think actually the substitute could potentially be, and I'm not saying it is right now, but could potentially represent not just a validation of public safety concerns that the senator articulated, but also constitutional rights. And let me explain why. Right now, the senator's right. This is the federal law. Now, federal law is not enforced frequently because you don't have very many federal prosecutors who are going to chase this crime down. For every federal assistant district attorney, or excuse me, assistant U.S. attorney, you have probably 50 Commonwealth attorneys or assistant Commonwealth attorneys. So these laws aren't very well enforced. And as a result, people aren't very aware of them. People are aware, of course, if you're a felon, you can't possess a firearm, but they don't typically think of that as extending down to a misdemeanor. And so people that have been convicted maybe in the 70s, 80s, or 90s, or didn't show up for a charge, and by the way, a lot of people that are convicted of domestic assault are women. That may not be too well known, but anyone who's been in GA and DR court knows that. They could get swept up into this unintentionally, but Senator Favola's bill, I think, makes a critical distinction. She didn't mention this in her remarks, but I'll mention it. The offense has to occur after July 1, 2021. So we're not going to reach back and sweep up people, and that was my biggest concern. We've done so much good work in criminal justice reform, so much good work in expungement. My biggest concern is we were going to undo a lot of that by making people vulnerable for being criminalized just because of their status. This is working forward that from July 1, 2021. So therefore, the word needs to be in the community. If you're charged with a domestic violence misdemeanor, you better lawyer up. because if you get convicted, you are going to lose your Second Amendment rights if this bill passes. Now, Senator Reeves is exactly right. That's not a minor loss of liberty. But I think the third part of this, and this is where Senator Favola, I think, is on the right track, is we need to look at restoration of rights. We need to look at somebody made a mistake. We know they made a mistake. Is it possible for them to basically redress that? Is it possible for them to show that they've gotten those anger management issues under control? Is it possible for them to show that level of responsibility, just like we restore people's rights to vote, to serve on juries? The Second Amendment is also a constitutional right. So I want to thank Senator Favola. I had practiced a speech against this bill. I had been in my basement, working on all these great things I was going to say, but I actually think it's a pretty good piece of legislation, so I'm going to vote for it. And that's all I have to say. Thank you.
Thank the Senator. For what purpose, Senator from Lynchburg, Senator Peake Rise?
Yes, sir. Thank you, Mr. President. Speak to the bill.
Senator's the floor.
Thank you, Mr. President. And I understand the Senator's intentions in bringing this bill, and we all want safety with our families. But as a lawyer with 25-plus years of experience, I don't think most people realize how easy it is to be convicted of assault. And the statute says assault and battery. There's no distinction. It's assault and or battery. Well, you didn't touch them. You can still be convicted of an assault. The statute number is the same, and this bill would forever deprive someone of their Second Amendment rights. And to think about this, just think about what the senator from Fairfax, who's brought so many bills this session and so many amended bills and so many substitute bills this session, when he was amending the bill about assault on a police officer, what did you hear? Throwing a French fry can get you convicted of assault. Dropping something near someone can get you convicted of assault. I had a case, it was not a family member, but this is a very recent case. A man was sitting in his car. He received a parking ticket. She placed it on his windshield underneath the windshield wiper. He was mad. He cussed at her. She's standing up at the front of his car. He flings open the door to get out. And she says it scared her. Didn't touch her, didn't really come close to touching her, but it scared her. He was convicted of assault in General District Court without a lawyer, in Circuit Court with a lawyer, and on appeal was denied a writ because the trial judge says she was scared. If that's a family member, he's deprived of his Second Amendment rights forever, unless something happens, he can get it expunged or whatever. Another case, man at home, in his kitchen, his wife starts belittling him, various things. He is livid. She is livid, belittling him. He's embarrassed. He wants to leave to get out of the situation. She blocks the doorway, stands in the doorway, the only entrance in and out of the room. And so he goes to get out of the house to avoid it, but he has to touch her to get out of the room to escalate the situation. He is guilty of assault. That's how easy it is. And rest assured, anybody who's ever handled a domestic case, if anybody has a lawyer, they know how simple it is to get the man kicked out of the house and to get sole possession of the house for them and their children. Or the woman, the man knows the same thing. He has a lawyer as well. All they have to do is go to the magistrate, say he touched me, she scared me, she threatened me, get an assault. He gets convicted, and that's what happens. And I know there are terrible situations where there's a real battery, real assault, real domestic abuse. But to take away somebody's Second Amendment rights based on this is just not appropriate. I ask you to vote against this bill.
Thank the Senator. For what purpose, Senator from Franklin County, Senator Stanley Rise?
Thank you, Mr. President. Briefly speak to the bill.
Senator's the floor.
Thank you. Mr. President, members of the body, we just talked about an expungement bill, but I'm sure that the expungement bill will not have this as a part of an automatic expungement. And the sponsor of that bill shakes his head. No, this will never be expunged. This will always be in your record. So now we've gone from what we always understood, that you lose your liberty, you lose your Second Amendment rights when you're convicted of a felony, but now we're having a deprivation of a constitutional right, your Second Amendment right, for conviction of a misdemeanor, misdemeanors as described by the senator from Lynchburg. And quite frankly, the senator from the city of Fairfax might be heartened to know that, oh boy, in this bill we talk about someday we're going to talk about restoration, but there is no automatic restoration or process in place for that restoration. We're just going to talk about it. Talk about it. Sure. I believe you. Kind of like the federal government, if you really think about it. Federal government has this bill, this law in place. Now, the senator from Fairfax City said there's just no way you get that right back. It's gone. Might have been him, might have been somebody else here, but that discussion has been made. But that's wrong, because there is a mechanism in the federal government law for restoration of rights. But they've never gotten around to have that discussion to fund it. So you can't get your rights back because they said, they promised that there would be a way to restore your rights, but they never acted on it. Fool me once, shame on you. Fooled me twice, government, shame on me. Pardon me if I don't trust it as much as I love the senator from Arlington and respect her. So what you're doing is you're making a forever. This is like a tattoo. It doesn't come off. And what you're doing is taking away a constitutional right. We've now lowered the bar from felonies to misdemeanors. Next thing you know, it's going to be when you're holding your cell phone in your hand, you're going to lose your gun rights. But we'll talk about you getting back that phone and that gun later. Vote no on this bill. Very bad bill. If you want to have something like this, then have some automatic restoration in it. Have some process, some due process to getting your property back. Because the government is now taking your property. Say you can't have the property. What do they do with it? Sell it? Destroy it? Hold it until you get your rights back? When we finally figure out how to do it? I dare say no. And so you should vote no. Thank you.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Good afternoon, Mr. President, and thank you.
Afternoon, Senator.
Would the gentlelady from Arlington yield for a question?
Will Senator yield?
Yes, I will yield.
Senator yield. You have the floor.
I would ask the gentlelady, we had a brief discussion yesterday about who is caught up under this legislation, and I asked you, not totally tongue-in-cheek, so if the Gronkowski brothers got into a dust-up, little scuffle, and one takes a charge after the other, would that count? And you told me, no, it can't be brothers. And that's correct, as set forth in the legislation. Is that right?
Yeah, that is correct, Senator.
The floor.
Well, let me ask you this. What about the following situation? Because I'm looking under domestic violence, and whenever we hear about domestic violence, we always think of the man battering the woman, but I'm worried about the group of people that may be caught up in this.
Okay.
The 19-year-old college student who comes home and sees her mom and her stepfather, and he doesn't want her to go out with a certain individual, and they get into a minor tussle, pulling at each other, or maybe pushing, and one or the other takes a warrant out against the other. Is that caught up in it?
Senator's the floor.
Thank you, Mr. President. Okay, so I'm just reading from the federal code, which mine should have. It must have an element of physical force or threatened use of a deadly weapon. So,
no, well, I would point out to the gentle lady, if you look at 98, line 98, there's no mention of a weapon. It says...
No, this is part of, this would be a definition of the assault.
So I'll ask
Further
this.
question?
If there is a assault and battery.
Mm-hmm.
Assault and battery is set forth in line 98 between that 19-year-old college student and her either mother or stepfather, and one of the other is charged with assault and battery. Would that person lose their rights to possess a firearm in the future?
Senator's the floor.
Thank you, Mr. President. So your situation is, and again, this would be decided by a court. So I can only speak to the framework that is in this bill. I don't know exactly how a specific case would be determined. That's why we have judges and juries who can consider all the information and mitigating circumstances. But it looks like, from the federal definition, the person whom the victim shares, they share a child, they have cohabitated, or they may have cohabitated with the victim, has a spouse, parent, or guardian. So if you were speaking of a child to a parent, I suppose that might be covered.
Further question?
Further question.
Senator Yields? Senator from Arlington? Senator Yields?
Yes, I do yield.
Senator Yields, you have the floor.
There's a couple, a wife and a wife. Two women are arguing over their child, as might happen with couples.
Might happen.
Never with me. But the couple, the wife and the wife argue, and one pushes the other and charges the other with assault. Is that situation, that instance of domestic violence, caught up in your bill?
Senator's the floor.
Thank you, Mr. President. Again, that case would have to be taken before a judge. It'd have to demonstrate proof. So it's a conviction. This is not just, oh, well, this happened. Somebody has to be convicted of this misdemeanor, of this sexual, would be assault and battery misdemeanor. Again, this is federal law. So if a federal official, a federal law enforcement officer, was frequently around, they could enforce this. But I guess they have other things to do. So it's what I'm saying is this did pass with bipartisan support in Congress because there was a value placed, again, on keeping people safe in their homes. So I'm taking the federal law and merely putting it into statute, the state statute. Asking me about specific cases is, I think, really complicated because, as you all know, cases differ. That's why we have lawyers.
I thank the senator, Mr. President. Would the gentleman from Fairfax City yield for a question?
Senator Yield?
I yield.
Senator Yield, you have the floor.
First, I'd ask the gentleman, was he listening to the colloquy between the senator from Arlington, the gentlelady from Arlington, and myself a few moments ago?
Senator's the floor.
I would say I was.
Thank you. I'd ask the gentleman the following question, if he yields.
Senator,
I yield.
Senator Yields.
I yield.
You have the floor.
I want to, because I really am trying to determine how far and who is captured under this statute. I want you to assume that there is an assault and battery charge, they go to court, and there's an assault and battery conviction.
Yes, sir.
I simply want to know if wife and wife get into a dispute and there is a pushing, and a battery, and a conviction is secured, would that person be barred from purchasing a firearm going forward?
Senator's the floor.
The answer would be yes, if it would be a family or a household member under the definition in subpart B, lines 99 to 104.
And that covers, further question.
Further question. Senator
I yield.
Senator Yields, you have the floor.
And that subsection includes spouse, doesn't it?
I yield. Yes, it does.
Similarly,
answer
under
the
that,
gentleman yes.
Yes. Further question.
the gentleman yield for another question.
I yield.
Senator Yields, you have the floor.
A family member in the same section also includes a person's parents or step-parents, correct?
Senator's the floor.
I yield, and I would answer the gentleman yes.
Further question.
Would the gentleman yield for a further question?
I yield.
Senator Yields.
So my question is, 19-year-old college student comes home and announces to mom and stepfather that she is going to date somebody. Mom and stepfather don't like it. Perhaps he's older. They don't agree, and there is a dispute between the 19-year-old and stepfather, resulting in a battery.
Further question.
And there's a conviction. Is that person, whether it's the 19-year-old daughter or the stepfather, are they permanently barred from purchasing a handgun?
Senator, has the floor.
Well, I would say, first of all, it's prospective from July 1, 2021, so it would not apply to any past events.
I understand that, and I'm serious about the question.
Yes, sir,
I would
and
ask the gentleman to yield.
I yield.
Assuming that this took place on the 4th of July weekend, and the same scenario.
Yes, sir.
The college student gets into a very minor offense with stepfather or with mother, resulting in a misdemeanor assault and battery conviction. Is either one thereafter prevented from purchasing a firearm?
Senator, has the floor.
Yes.
Right. Speaking to the measure.
Senator, has the floor.
I can't tell you how much I respect the chairman of Rehab, Mr. Speaker, Mr. President, but I'm concerned about any legislation that is too expansive and catches people that we don't want to. And in these day and age, when we talk about domestic violence, it seems to be a catch-all for the situation that we normally think of domestic violence, the abusing husband and the abused wife. But in this legislation, it catches too many people. That's the problem that I have with it. And as much as I appreciate the spirit of the legislation, we are making a new class of individuals, family members, barring them from purchasing a gun down the road, and we're expanding the number of defendants that can be caught instead of what I thought we were doing in this General Assembly session, and that's criminal justice reform. So for that reason, I'm not going to support the measure. Thank you, Mr. Speaker. Excuse me, I'm sorry. Thank you, Mr. President.
Thank the senator. What purpose, Senator from King George, Senator Stewart, rise.
Speak to the bill, Mr. President.
Senator's the floor.
Mr. President, I'd like to echo the concerns of the junior senator from the city of Richmond. He's exactly right. And as I was looking through the bill, I was concerned about those same things. But practically speaking, I just want to point out something to this body. If you are convicted of felony domestic battery, which is after the second time I believe we changed it, we've adopted legislation, special session and this session, or at least will, where you certainly won't have a minimum mandatory anymore. If you go to jail, you can't be put in solitary confinement. You get good time credits, even though you beat the devil out of your wife, and probably can get paroled. And at least at one point, that offense was expungible, if that's a good word. Now, the gentleman says he amended it out, and I take his word for it, but at least one point, you could expunge that conviction. So we don't want to punish a person at all for beating his wife to the extent that it's a felony, but if it's a misdemeanor offense, we're going to say you can never, ever own a gun the rest of your life. Makes no sense to me, and I hope we'll vote against this.
Thank the senator. For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
To ask the senator from Franklin to yield for a question.
Will Senator yield?
Happily yield. Yes.
Senator yields. You have the floor.
Thank you, Mr. President. I've been told by a lot of folks in our JDR court in Chesapeake that if a man and a woman get into an argument, the police are called, and one or the other asserts that there has been an assault or battery, that person is then immediately charged. And even if the person who made the allegation withdraws that allegation, our Commonwealth attorneys are still taking that person to court to press those charges. Is that a usual circumstance?
Senator, the floor.
Mr. President, I'd answer the gentleman and thank him for the question. In practice, it is. In some jurisdictions, some Commonwealth's attorneys, some courts have adopted it if you've got a domestic charge there, because what happens a lot of times, and it comes in different varieties. One is that the charge is a legitimate charge, but the parties have reconciled, or there's pressure from the other spouse to get the complaining spouse to drop the charges. And so they go in there and say, I want to drop the charges. And there have been Commonwealth's attorneys, they may have settled their dispute, or it may be pressure, but Commonwealth's attorneys that just say, we're going to put it on. I don't care what you say. We're going to put this on. And then what you sometimes find, and I would answer the gentleman this way, is that then both, it plays out sometimes both the alleged victim and the defendant asserting their Fifth Amendment rights on the court of law. I had this case right before I came here. So the charge doesn't go forward, but it still takes up the court's time. But yes, it does happen. It does happen a lot, and there are a lot of Commonwealth's attorneys whose policy is, we don't drop them if you say that you want to drop them.
I thank the gentleman. I speak to the bill.
Senator, it's the floor.
I think this bill is well-intentioned, but I believe, as the more knowledgeable people in law have stated on the floor, that this is a net much too wide, especially with the circumstance that I just brought up that the senator from Franklin answered, and I appreciate his answer on that. This is going to hurt a whole lot of people and take away a whole lot of people's rights, especially if there's no remedy there for restoring those rights. Like I said, I think the bill is well-intentioned, but it just goes a step way too far. So I hope we'll very, very seriously consider how you vote on this bill. Thank you.
Thanks. Senator. Do any senators other than the patron wish to be heard regarding Senate Bill 1382?
Mr. President.
Mr. President, Senator Norman.
Senator from James City County, Senator Norman.
Thank you, Mr. President. I've listened very intently to this discussion, and I must say, from a professional perspective, I have been involved in these situations on more than one occasion. First of all, I would say that, like many things we deal with in the General Assembly, there is always a chasm between what some of us think we know vicariously as what some of us know from practicality and experience. Let me make a couple of very brief points. First of all, if in fact the law enforcement officers are dispatched on a domestic assault and battery, our current law requires that that law enforcement officer must mandatory arrest someone. So someone is going to be taken off to jail immediately. Next point, Mr. President. This assault and battery is usually a misdemeanor offense, and we're going to deprive people of their Second Amendment rights on a misdemeanor. We're going to deprive these individuals of their Second Amendment rights on an assault and battery that does not involve a firearm. The nexus between them is a little stretched. I would further say, Mr. President, that I mentioned before that frequently, if not always, on these domestic assault and batteries, there is a protective order that is entered. There is an emergency protective order that is entered by the magistrate where the accused does not even have the right to appear. Immediately, that individual is deprived of his or her ability to possess a firearm. Within a short period of time, the emergency protective order has to be taken before a judge and a determination made whether or not to enter a protective order. If that protective order is entered, then once again, the individual is deprived of their Second Amendment rights. And finally, it becomes a question, I think, of dimension, because that domestic protective order can be extended for 2 years. So for 2 years, that individual, if found guilty of a domestic assault and battery and has a protective order entered against him or her, for 2 years, their Second Amendment rights are deprived. And Mr. President, I just think that's enough. And as the senator from Chesapeake just said, this is a step way, way too far.
Thank the senator. The junior senator from Chesterfield, Senator Chase.
Thank you, Mr. President. I'll be brief with my remarks.
Senator, it's the floor.
Just this past month, in the last couple of weeks, I had a constituent with this very exact issue in which he's actually a police officer, and he was had invited in his home refuge and shelter for another family member, sister and her boyfriend. And he and his wife, or he and his girlfriend, got into a dispute, and the boyfriend called the police. And when they got there, they arrested the law enforcement officer and charged him with assault and battery. And as a result, he was charged with a misdemeanor. And he lost his ability to provide for his family as a law enforcement officer because the Commonwealth's attorney continued to prosecute the case anyway, even though both parties were going to drop the charges and we're going to be reconciled. So I would say to the patron, well, I'm 100% behind you. We need to do whatever we can to curb domestic violence. I believe this is already on the books. People who commit domestic charges, even on misdemeanor charges, are losing their Second Amendment rights, because I've seen that with one of my constituents in the last couple of weeks, and he was a police officer. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1382? Senator from Arlington, Senator Favola.
Thank you, Mr. President. I've heard the debate and I've listened intently. I do want to note that even the gun safety groups and those who promote, like the NRA and the Citizens Defense League and other organizations that you would say promote firearm rights, have acknowledged that this is preventing domestic violence, protecting individuals in their homes, ensuring that folks are not badgered by assault, is actually a valuable thing. Their issue, as is the issue that's come up, is it's really just we want them to restore their rights. We don't want the firearm taken away permanently. That seems to be the issue. And I understand that. In the state of Washington, for example, allows individuals, again, they have this law on their books, and they allow individuals to petition a court, make sure the individuals complete their sentencing, they go through anger management treatment, and then as long as they haven't committed a crime within a certain period of time, in Washington it was 3 consecutive years, they could get their firearm back. I am very open to that. In fact, there's language in this bill that directs the Crime Commission to come up with options and to report back to the General Assembly. If it is the wish of this body, I will work on restoration language with the senator from Franklin and the senator from Fairfax City, both of whom have indicated that that would be enormously helpful. I would like to get this bill out of the Senate, and I can work on this language when it is heard in the House. That would be my preference. I do think this is a good bill. I think protecting our loved ones is important. Protecting our families and protecting our communities is important. And I just want to note that, again, suicides are much, much higher in homes where there are firearms. Mr. President, I respectfully ask that this bill pass, and I thank the body for its attention.
Mr. President.
Full purpose Senator from Bedford, Senator Newman Rise.
Mr. President, here again, I don't get into criminal matters because it's beyond my pay grade, but I would like to ask the gentlelady a question.
Will Senator yield?
Yes, of course, I yield.
Mr. President, I just don't know where all the code sections are. If an individual is a police officer or a state police officer and they're going through a divorce and they end up with a charge or a spouse or former spouse charges them, does this mean that they cannot carry a firearm as well?
Because you're concerned because it's part of their livelihood? Is that your issue, Senator?
Yes, ma'am.
I will defer to one of the lawyers, but my reading of that is that that would not be an exclusion under the definition of household on lines 99 through 105 or 106. And again, I will ask.
Mr. President.
Further question?
That's what I'm saying. The police officers would not be excluded.
Well, Mr. President.
But again, these are. I'm sorry. Go ahead.
Sorry.
Pardon me.
Right.
I apologize.
Okay.
Mr. President, would the senator from Franklin yield for a question?
Will Senator yield?
Certainly.
Senator Yields, you have the floor.
Mr. President, here again, this is not my section, but I'm just concerned if a police officer or a state police officer, a Capitol police officer had maybe a spouse that determined that they were no longer going to be compatible and determined that they would like to help take away their livelihood, if they were charged under line 96 through 107, would they no longer in their official capacity be able to carry a firearm, therefore not allowed to have their job?
Senator, has the floor.
Mr. President, I thank the gentleman for his question. Everything that I can read here, if you are convicted of the domestic assault and battery misdemeanor, then you cannot possess a firearm. It does not differentiate between John Q. private citizen and Officer John Q. public citizen. So the answer would be to the gentleman, yeah, that would cause the officer, when he possessed that firearm for the purposes of his job, to be committing a Class 3 misdemeanor, and therefore would probably cost him his or her job.
Further question?
No, thank you.
Thank the senator.
Mr. President, Senator Norman.
Senator from James City County, Senator Norman.
Thank you, Mr. President. I would like to respond more emphatically to the senator from Bedford's question. I have defended those exact fact patterns on at least 3 occasions within the last couple of years. And the answer is absolutely that if they are deprived of their ability to carry a firearm under a conviction of even this misdemeanor of assault and battery, their job is seriously at jeopardy. And that would include even if there is a protective order.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1382?
Mr. President, I just have one last point. I mean, I understand the points being made by the senator from Lynchburg and the senator from Bedford, forgive me, and the senator from Franklin. But again, we want individuals who are carrying firearms to be level-headed, to not have anger management problems, to not be involved in assault and battery cases. You know, we're looking at behavior. We're not looking at somebody's profession. Again, 32 states have a bill, have a law like this on their books. I'd really like to join Louisiana and Alabama and Texas and pass this bill. And I promise to work on the restoration of rights language as the bill moves through the process. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Northwestern Fairfax, Senator Boysko, rise?
Thank you, Mr. President. Just a comment on the bill.
Senator, has the floor.
I just want to, bring everybody's attention to the last lines of this piece of legislation, where it directly on 837, Section 3, where it specifically directs the Crime Commission to study and provide recommendations for restoration of the firearms rights for those who are convicted of assault and battery of a family member. And I just want to say, we've heard a lot about protecting these people who are having convictions of domestic violence, and my question here is: do we really want to violate federal law that already is in place? Is that what we're saying here? Because that's the way I'm interpreting this, and I think it's an important bill, and I urge the body to support it.
Thank the senator. Seeing no further debate, Question is, shall Senate Bill 1382 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
16, noes 22.
Ayes 16, noes 22. Senate Bill 1382 fails.
Senate Bill 1392, a bill relating to Consumer Data Protection Act.
Senator from Western Fairfax, Senator Marsden.
Thank you, Mr. President. I move that Senate Bill 1392 pass. And speaking to that,
Senators, the floor.
Mr. President, this is a bill regarding protection of consumer rights of your personal data. The bill provides consumer protection for their data and its privacy. And the most important part of this bill is what it protects for consumers. The right to access their data, the right to correct their data, the right to delete their data, and the right to opt out of collection and sale of their personal data. Now, what this bill also provides for is it exempts organizations that keep limited amounts of data. It also exempts nonprofits. It spells out the requirements of the controllers or the people who owns the data, and it spells out the requirements of those who process the data. It will be enforced by the Attorney General. This is long overdue, Mr. President. This is our constituents' data. It's our data. It needs to be protected. This could be a model for the rest of the country. There's other bodies like this around the country working on this right now. Virginia, 70% of the internet comes through Virginia. It's our turn to lead, and I urge you to pass this bill. Thank you.
Thank the senator. For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
Very briefly speak to the bill, Mr.
Senators, the floor.
Mr. President, I'd urge the members of the body to vote for this bill. The Joint Commission on Technology and Science has been working on this. Senator Marsden has been working with the stakeholders and the lobbying community and all folks involved. This is one of those very odd bills that has a lot of peace in the valley. And you would think there'd be a lot of people up against it, but people like Amazon are for this, and other internet-driven communities are for this bill. They've worked with the patron of both the House and the Senate version, so I hope you'd all support this bill. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1392? Seeing none, question is, shall Senate Bill 1392 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 36, noes 0.
Ayes 36.
And Rule 36-1.
No 0. Rule 36-1. Senate Bill 1392 passes.
Senate Bill 1395, a bill relating to elections, prohibited discrimination in voting and elections administration, required process for enacting certain covered practices, civil causes of action, penalties.
Senior Senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that Senate Bill 1395 pass, and speaking to that.
Senators, the floor.
First, Mr. President, I want to be clear what this bill is not, because we did see a Voting Rights Act bill last year that was very different, and there might have been some confusion, at least in committee. This is not a pre-clearance bill. This is a bill, though, that would enshrine and incorporate elements of the Federal Voting Rights Act into Virginia law. It would require that changes to local voting laws and regulations that could have an impact on the ability of Black, Indigenous, and people of color to vote be advertised in advance for public comment, and that if changes are made, those changes be advertised. In the alternative, a locality could go to the Attorney General's office, have the Attorney General's office review the changes, and provide a certificate of no objection. This is to give communities who are protected classes who have been disenfranchised by changes in voting procedures and voting laws in the past an opportunity to comment and provide input on those changes. I'll give you an example. Here in the city of Richmond, prior to the beginning of early voting, the voter registrar's office, which was the only early voting location for much of the 45-day period, was moved from downtown, where it is on a bus line, has been for as long as anybody can remember, was easily accessible, whether you had a car or not, to a location where 95, 64, and 195 come together, that is not on a bus route, that is a commercial area that not very many people in some parts of the city where they don't have transportation go on a regular basis. Had that been put out for comment, first, a lot of people would have known about the change well in advance before they were going to vote. More importantly, they probably would have commented on the fact that that location was harder to access, and another location could have been found in plenty of time for a move. The bill also expands requirements for localities to provide voting materials in language other than English that meet certain thresholds based on population. This is already a requirement under federal law for federal elections, but this extends this requirement to state and local elections as well. It ensures fair representation in local government by ensuring local election methods do not dilute the voting strength of a protected class. It strengthens protections against voter threats and intimidation so that it's not just at a polling place, but at satellite locations and early voting locations as well, to ensure that every voter can make their voice heard safely. It allows the Attorney General or affected individuals to initiate a civil action in court if the protections are violated, because what we have seen with the gutting of Section 5 of the Voting Rights Act, when you have to initiate, strike that. It allows you to go to the Attorney General or initiate a state civil action if the sections are violated, so that you can get injunctive relief, or in certain cases, you can get a civil penalty that would go, rather than to the literary fund, into a newly created voter education fund that would help to educate voters of their rights and responsibilities, and can be used also to educate election officials on their responsibilities. Virginia would be the first southern state to adopt a Voting Rights Act. I think that's critically important, because in Virginia, about 151 years ago, newly freed slaves and African American men, for the first time, were allowed to vote. And African American men gained significant social, political, and economic power, including electing over 20 to this body 151 years ago. And then after Reconstruction, with changes to our Constitution that included poll taxes and literacy tests and felony disenfranchisement, combined with racial terror lynchings, those men were disenfranchised. And for decades, African American men and women in Virginia, as across the South, fought, marched, protested, died for the right to vote. In my own family, not in Virginia, but it could have been, my great-grandfather had to take a literacy test in 1901 where he was asked questions like, who was the Chief Justice of the Alabama Supreme Court? Who was the Vice President of the United States who was from Alabama? He got all these questions right. And then he had to find 3 white men to vouch for him before he could get the right to vote. My own father, I found among his papers earlier this year a receipt for the poll tax he had to pay in 1948. That's not that long ago. And while the Federal Voting Rights Act made significant changes to end racial discrimination in voting, it was effectively gutted at the federal level in Shelby County versus Holder. And it hasn't been reauthorized. And as a result, a lot of states, and I would argue even here in Virginia, although we've corrected a lot of that, passed laws that, whether intentionally or not, impacted communities of color and language minorities' ability to vote. And when that happens, at the federal level, you have to sue after the fact. And after the fact, your vote has already been disenfranchised, your ability to participate in government taken away, and in many cases, an election already determined. And so this act is to make sure that's less likely to happen here. And for Virginia to be the first state in the South to put this in our state law will be one more moment in our history that we can be proud of, that helps us atone for those parts of our history that still bring us shame. With that, I ask that the bill pass.
Thank the senator.
Mr. President,
Senator from James City County, Senator Norman.
I apologize, sir. I, of course, can't see when somebody logs in. If the gentlelady would be kind enough to yield for a question or two, I would be very appreciative.
Senator Yield.
Yes, sir.
Senator Yield, you have the floor.
Thank you, Mr. President. I would ask the gentlelady, in an earlier version of the bill under the definition of coveted practice, which was started on line 100, down on line 105, it indicated that there could not be a reduction by more than 5 points on proportionality. Does that remain in your current version?
Senator's the floor.
Yes, this is talking about a more than 5 percentage point of the proportion of the jurisdiction's voting age population. Yes, that is still in there.
Mr. President, another question, please.
Senator Yield. Senior Senator from Richmond.
Mr. President, earlier in the session, I asked you a question very specifically. Does your bill mirror the language in the Federal Voting Act? And you indicated yes. Am I correct in stating that the Federal Civil Rights Voting Act does not contain any percentages? And in fact, the Supreme Court has rejected cases that have attempted to encapsulate percentages in statutes.
Senators, the floor.
Mr. President, it is my understanding that this section encapsulates federal case law.
Mr. President,
Further question?
speaking to the bill, sir.
Senators, the floor.
Mr. President, having reviewed the Federal Civil Rights Voting Act, there are no percentages that are memorialized in that federal statute. So what you see under the definition of covered practices is Virginia's version of it and the patron's literary license. I took the opportunity to research a number of cases going back, if you can believe it, to 1964 and coming up into the 2000s. The courts have consistently rejected the memorialization of specific percentages because what they have held is that these districts must be substantially equal, and that is a term of art. And the reason the courts have held that the districts must be substantially equal, and I quote from Reynolds v. Simmons, that is because it is more difficult to balance populations in these smaller districts while at the same time heeding political boundaries such as county or municipal lines. Under the case of Cox v. Larios, and I quote, this was an appeal case whereby, there was an effort to memorialize in a local ordinance that would have been enforced in the District of Columbia. And the court says, the court properly rejects this invitation. Mr. President, I would say that this provision under the definition of covered practice is more restrictive than the federal law.
Mr. President, would the gentleman yield for a question?
Will Senator yield?
Yes, make sure I got the right button pushed. Yes.
Senator yields. You have the floor.
Thank you, Mr. President. I'd ask the senator if he is talking about a deviation of population for redistricting purposes and drawing district lines.
Senators, the floor.
Mr. President, my response is her definition under covered practice.
Further question?
But, Mr. President, I'd ask speaking to the bill.
Senators, the floor.
Unless anybody else wants to speak, I could save this point. But, Mr.
Yeah, we have a couple more if the senator wants to wrap up, or you can go now.
Let me try.
Senator, want to go at the end?
Well, Mr. President, let me ask the gentleman a question. I think we're talking about two different boundaries, and I'm trying to understand what the senator is referencing when he talks about boundary changes. Is the senator referencing statutes and case law around a percentage population deviation for purposes of drawing district boundaries for redistricting purposes? Or is the senator talking about when you are making changes to jurisdictional, a locality changing its boundaries through annexation or something similar?
Mr. President, I would respond to the lady. I am not referencing anything to do with annexation. I am referencing your specific language under what is 24.2-129, covered practices, actions required prior to enactment or administration. Subparagraph 2, any change or series of changes within a 12-month period to the boundaries of the covered jurisdictions that reduces by more than 5 percentage points the proportion of the jurisdiction's voting age population, et cetera, et cetera.
I thank the gentleman. I'll respond to his remarks at the end.
Thank the senator. For what purpose does Senator from Fauquier, Senator Vogel, rise?
Thank you, Mr. President. Speaking to the bill.
Senators, the floor.
Mr. President, I think there's some confusion about what the legislation actually does, and I would like for the members of the body to pay attention and understand what this means for your locality. Understand what you're voting for before you cast your vote on this. In committee, we had just a brief conversation about whether or not this is a pre-clearance bill for Virginia. And while the gentlelady who is the patron said this is a notice bill, it really is adopting a pre-clearance component, or if not real pre-clearance, in Virginia. Because if your locality wants to make any change, whether it's a change to an election location, and there's a number of covered actions that the locality may wish to make in the conduct of elections. If they want to do that, what's now going to be required of that locality is a very, very long, protracted, and cumbersome process that requires a notice, a 30-day period of public comment. If there's a change, then there's an additional period of public comment. It is going to make it an unwieldy, incredibly complicated process, and then it also includes an opportunity if during the pendency of that time, if there's been a change, they can go to court. It is going to require so much litigation for our localities that it is going to cause a tremendous amount of disruption. What localities will end up doing is effectively making this a pre-clearance bill, because what they will have to do is go to the Attorney General, because that's the other option here, is to go to the Attorney General and wait. And it speaks to that point too, depending on how long it takes for the Attorney General to issue you a certification of no objection. And so I just want the members of the body to understand why VML and VACO are so concerned about this legislation. And also why some of our registrars are very concerned about the bill, because it does something else. It subjects them to a civil penalty. And it's very broad language. It's not just them, but it's the electoral board members and it's officers of the election. And it doesn't have a standard. It doesn't say that they have to have willfully or intentionally committed some error or mistake. They can just have committed an error or a mistake. And so, going further than that, anybody who's now been subject to a suit can go to the Division of Risk Management in Virginia, and notwithstanding the amount of damages, Virginia's going to have to pay for this. And just consider what happened in the most recent election, and consider if every locality, for every decision they made, was subject to some kind of litigation and somebody trying to impugn the integrity of their decision-making, it is a full employment act for lawyers. Now, I'm certainly not one to stand here and say that you shouldn't hire an election lawyer. I hope people hire them all day long. But I just want the members of the body to understand what it is that the legislation will do and why it is that we have so many of our localities that are quite concerned about this. And many of those localities who waited a long period of time to get to a point where they could function. And I think we just have to trust that they will act with integrity and with caution and with care. And so with that, Mr. President, I just want the members of the body to know what the bill does. And I would encourage you to think twice before you cast a green vote on this bill.
Thank the senator. For what purpose does the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Would the senior senator from Richmond yield for a question?
Senator Yield.
I yield.
Senator Yields, you have the floor.
I would preface my question by saying I agree with her that Section 5 of the Voting Rights Act was significantly gutted. And I would also acknowledge that the legislation that the senior senator has proposed would prohibit any voting standard or practice that was imposed in a manner that would abridge or deny somebody based on race or color from the opportunity to vote. and I agree with that 100%. Thirdly, I would say I am very much inclined to support this bill, but here's my question. I want to determine what scenarios would be included. If a district with a large minority population was desirous of keeping down the vote or limiting the number of voting polling places, would that be included?
Senator's the floor.
Mr. President, I would answer if by limiting the number of polling places, the polling places that were eliminated were done so in a way that makes it harder for a protected class to vote, it would potentially be covered. For example, if you are closing polling places in predominantly black communities and leaving them open in predominantly white communities, it is possible that would be a covered practice.
Follow-up question, Mr. President.
Senator Yield. Senior Senator.
Yes, I yield.
Senator Yields, you have the floor.
Would a practice or procedure also include that scenario where the hours were significantly reduced so as to prevent that minority population from voting? Would that type of egregious behavior be included under 1395?
Senator's the floor.
Mr. President, I would answer again, if the hours were limited in such a way where a protected class would be precluded from voting, that would potentially be covered.
Further question?
I thank the gentle lady, Mr. President, in speaking to the measure.
Senator's the floor.
Mr. President, to quote a senior member of this body, let me tell you something. I am going to vote for this legislation because I absolutely agree with the spirit of what it's trying to be done. But this is what I really object to. There are often situations where in a minority community, there is a favorite child, somebody who is preferred by the folks in charge. And if you try to come into that circle, you're an outlier, you're an outsider, and you are absolutely discriminated against. Now, it normally doesn't raise its ugly head because it's being done in that minority community. The gentle lady told us that limiting the number of voting places, that could be a situation. Limiting the number of hours, that could be a situation. And we know that this applies not just to a general election, but a primary. So let me give you a real-life scenario. We had an election recently in a minority city, Richmond, that has between 60 and 70 voting places. It was a Commonwealth attorney's race. Now, there was an outsider who wasn't part of the group that wanted to run for that position. And do you know what they had? But she was part of the, I call, elite, the inner circle, the person who the Democratic Party in the city wanted, and whose husband was a congressman and a former member of this body wanted. So we had 60 to 70 polling places. Do you know how many polling places were open? 2. One in one in the city of Richmond, north of the river in downtown, and one voting place in South Richmond, in a ward where there was a white member of city council. The hours? 5 to 6:30 on a Tuesday. But then to be fair, they're going to open them on Saturday from 9 to 11 for 2 hours. So that was the voting. 2 out of 70 voting precincts open, And the hours, not 6 in the morning to 7 at night, but an hour and a half on a Tuesday evening, and then an hour and a half to 2 hours on that Saturday. Because let me tell you what happens, folks. If you're in the inner circle, if you're part of that group, it's to your benefit to keep the voting turnout down. And I have seen it time and time again in other jurisdictions. If you're that person, you're that incumbent, you're that favored child, let's keep the voting turnout down because you'll marshal your forces and get out. And it's so unfair. So all I'm trying to say is I'm going to vote for this bill because I support the spirit of it. But let's not deny the absolutely very real possibility that we do that all the time to limit vote out, limit the number of people that can get there because there's a favored child. Thank you very much. I feel better.
Thank the senator. Do any senators other than the patron wish to be heard regarding Senate Bill 1395? Seeing none, the senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. Speaking to the bill.
Senators, the floor.
First, Mr. President, to address the exchange with Senator Norman, the case, the 5% deviation in the case, Reynolds versus Smith, that the senator from James City County referenced has to do with redistricting and drawing boundary lines for districts, legislative districts, and dealt with whether or not you would have regression with redistricting. That is not what a covered practice is under Section 2 of this bill. That the lines that he pointed to are looking at if you change jurisdictional boundaries, either through annexation or if two localities were to merge, then you would look at what impact that has on the voting population to determine if that is a change that needs to be publicized. So I think we're talking about apples and oranges. With respect to Senator Morrissey's point, this bill is not relevant to what I can tell bothered him a lot, because this bill is dealing with changes to what he's talking about was a party primary and not the regular voting locations and hours for a state or local run election. And those are the changes that are encompassed in this bill, not what a party chooses to do in its nominating processes that are not run by the state or the locality. This bill is about if there are going to be changes made that impact a protected class's ability to vote, they should know about it. They should know about it in advance. They should have the opportunity to comment. They should have the opportunity to challenge it to that locality. Because the inconvenience to our registrars does not outweigh effectively taking away someone's ability to cast their vote. This is a notice bill. But if you don't want to give that notice, then yes, you can go to the Attorney General and have them review it to make sure you are not going to disenfranchise a protected class. And again, ensuring you are not infringing on someone's constitutional right to participate in a government by, of, and for the people. I'm going to fall on the side of protecting that right to vote. I ask that we pass the bill.
Thank the senator. The question is, shall Senate Bill 1395 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 21, no 17.
Ayes 21, no 17. Senate Bill 1395 passes.
Senate Bill 1396, a bill relating to sewage.
Mr. President.
Senator from Northern Chesapeake, Senator Spruill.
Parliamentary inquiry.
Senator's the floor.
What is the inquiry about these cell phones as far as either turn them off or put them on vibrates? That ding is driving my earpiece crazy.
If everyone, I guess, who does have a cell phone could put it on silent or vibrate, that would be very helpful.
Bless your heart.
Thank the senator.
And not talk on the floor.
Right, that too.
Senate Bill 1396, a bill relating to sewage, on-site sewage indemnification fund, wastewater infrastructure policy working group, regulations report.
The senior senator from Chesterfield, Senator Hashmi.
Thank you. Thank you, Mr. President. I move that SB 1396 pass. And speaking to that motion.
Senator has the floor.
Thank you, Mr. President. SB 1396 is the Equity in Wastewater Treatment Act. This legislation establishes as the Commonwealth policy the equitable access to wastewater treatment in order to protect public health, the environment, and also to support local economic growth and stability. This policy encourages education, interagency collaboration, innovative and focused financing, regional solutions and plannings for the effects of climate change. It establishes an interagency work group with the engagement from key stakeholders in order to develop recommended actions for achieving this policy. This legislation is funded in the proposed budget, and it also has the tremendous support from the Southeast Rural Community Assistance Project, Virginia Association of On-Site Soil Evaluators, Virginia Society of Professional Engineers, and a wide variety of other stakeholders. Mr. President, I recommend that this bill pass. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1396? Seeing none, the question is, shall Senate Bill 1396 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
The clerk will close the roll.
Ayes 22, no 16.
Ayes 22, no 16. Senate Bill 1396 passes.
Senate Bill 1401, a bill relating to standards of learning assessments reduction report.
Senator from Washington, Senator Pillion.
Thank you, Mr. President. I move the bill pass.
Thank the senator. You have the floor.
Mr. President, this bill reduces SOL testing to what is required under federal law. School divisions would be required to give an alternative, high-quality, local test that follow DOE guidelines and standards that are already in place.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1401? For what purpose does Senator from Bedford, Senator Newman, rise?
Mr. President, speaking to the bill.
Senator has the floor.
Mr. President, I think it comes as no surprise that I'm very much opposed to this bill, but very much like the senator from Washington. Mr. President, I think I can reasonably say to a number of you that I have been killing this bill for a decade. And I did a pretty good job until now. And, Mr. President, it is here, and I know that times may be changing, but I want to speak to this, understanding that a number of patrons have come in with this bill, and it's very popular within the educrat community out there that has been pushing for this for a good while. Mr. President, I'm here to tell you, though, that this thing has been passionate for me for a long time because I think it matters, and I think history is going to judge us on what we do, not only this bill, but on this topic. Mr. President, there are no advocates in general on this campus, on the previous campus, for high accountability of high quality in public education. It has to be us. There are not lobbyists for that. It's us and parents. Mr. President, I would tell you that this particular bill is the final nail in the statewide accountability coffin for this Commonwealth of Virginia. Mr. President, it's very simple. The standardized tests that have now been dramatically reduced have been done so basically back to math, history, science, and English. Very simple. Mr. President, let me give you a short history in time. Mr. President, back in 1994, we had local assessment tests only. Back in 1994, we all determined that we as a Commonwealth were in serious trouble, and we were. Mr. President, at that time, what was happening? Our reading test, 4th grade, 8th grade, were going down dramatically. The NAAP tests were going down dramatically. The SAT tests were going down dramatically. We were in trouble. We, at that time, put in basic tests for math, history, science, and English. At the time, we came up with, for instance, in science, earth science, and geography, and other items. So it sounded like a lot of tests, but you only had to take one, to be clear. Mr. President, a bad thing happened along the way, and that is that a Republican president put in No Child Left Behind. I've said from day one it was bad legislation. It was testing for testing's sake, and it added way too many tests to the process. Then they added practice tests. Mr. President, that has been basically repealed under the Obama administration, and now we had moved back basically to the minimum testing. Mr. President, during that time, we did appoint a group called the SOL Innovation Committee. They pressed for a dramatic reduction in the numbers of tests. And we did it. We reduced those numbers of tests. And now we are back down to basically math, history, science, and English. Mr. President, we actually, in my opinion, and a lot of people's opinion, went too far with that. We went too far. So what's the results? The results today, 4th grade reading tests before COVID were down. 8th grade reading tests were down. The NAEP tests were down, and the SAT tests were back down. We learned nothing from history. We learned nothing from history. Mr. President, I don't often do this, but I'm going to in this case. Believe it or not, I agree with the Washington Post. I thought you might say that. Mr. President, not only do I agree with the Washington Post, I agree with the Washington Post over and over and over again on this point. I hope on this one point, take a time, maybe while I bore you, to Google the Washington Post on this point. They have been very, very clear about this for years, that Virginia was moving in a position backwards, and it was going to pay as a state. I'm going to just read you, and this one is the most recent one. Actually, there was another one that came out in November. This one is before the pandemic on February 8th. They said the plunge in the reading scores in Virginia in the fourth grade in 1994 on the National Assessment of Education Progress, coupled with decades of decline in the SAT scores, jolted the Commonwealth into recognizing the need for more rigorous standards and accountability. The standards of learning were put in place and set minimum expectations for what students should be able to do. Jumping down, it says, after 15 years of bipartisan consensus around high standards and accountability, the State Board of Education and General Assembly started in 2004 to begin to ease the rigor. Some of the critical SOL tests, such as the fifth grade writing, were eliminated. Score standards that were adopted to make it easy for a student to pass, and changes in accreditation regulations left schools off the hook even if they were failing. Little wonder then that the results from the latest national testing last year from NAEP showed significant drops in reading for both fourth and eighth grade in Virginia students. There was also a steady decline in the past few years on state reading assessment tests, and unfortunately, Richmond officials appear to respond like they are not responding like their 1994 counterparts with a return to vigor. Some lawmakers even push for a further weakening of the system. It goes on to talk about the fact that there is a push, or was last year, for 17 tests, and it speaks of what those tests were. But it says that, education advocates opposed the measure with fear there would be an effort to slip language into the appropriations language. Virginia officials have long boasted about requiring more of their students than what is mandated by federal law to take strong tests. Their constituents should be asking them, should they adopt this principle today? Mr. President, not only do I agree with the Washington Post, they were prophetic. One day, we would not only do away with those final few tests, but one day we would actually cede our authority to the federal government. And Mr. President, that is exactly what this bill does. If the federal government, and this may matter, if the federal government decides to eliminate the only last two tests, we will eliminate our tests. Mr. President, I have great concerns about that. Mr. President, there's going to be some discussion, I know it's coming, about local assessment tests. Mr. President, that's exactly what we had before. There's going to be some arguments that there are too many tests, and I would tell you that because of former Senator John Miller, those were dramatically cut back, and other legislators in here. We have now dramatically reduced the number of tests. Mr. President, I'd just like to say something about social studies. Some of us care about social studies and history. I know many of you do. I fought for 10 years to save social studies to be a metricable test, and I was very, very, very disturbed when they whacked that. I even put it in the budget. So many of you helped me do it, and they still got it. They still got it. This would make that permanent, Mr. President. I know there's going to be some that will indicate that some don't take tests well, and I get that. But if they are done correctly, they can be very, very helpful for us understanding. Mr. President, I would tell you this too, that some would say that they are high-stakes tests. But yes, when you get down to basic math, it is, do you know the answer or not? Mr. President, let me just mention one other item that I think is important. A few years ago, we had the opportunity, and it was Republicans and Democrats, we happened to be in charge, to identify through these tests that Petersburg was in trouble. I'll tell you this, it told us that Lynchburg was in trouble too. But Petersburg was in particular problem. And what did we on that education subcommittee do, Republican and Democrat? We stepped in and we helped. We sent them a new leader. We sent them a hoard of money. We helped them. Mr. President, if you do this and you take away any metricable test, we will never know, you will never know, we will never know that what the Washington Post has been telling us will occur, occurred. Mr. President, I fear that this is very well intentioned and just the latest version, but I feel that this is a failure-oriented strategy. We're planning to fail. And I know we stand on this floor, we talk about we love the children, that type of thing, and I get it, and I believe that most of my colleagues here do, or all. Mr. President, this is not loving the children. Taking away the last vestiges of accountability testing, the metricable test. If you don't like the test or they're too hard, let's once again take a whack at them. But let's don't get rid of them, the metricable tests that we have in this state. If we do, Mr. President, I think the science is clear. We will repeat history. Mr. President, I think this bill, if it passes and passes in the House of Delegates, will be just the final sad capstone on the death of our accountability of quality in public education. And I would mourn that. I would just urge some of you, and I know there's a lot of passions on things like this, some of you to join me and don't wave the white flag on metricable quality. Mr. President, for that reason, I hope some will vote no to this bill. Thank you, Mr. President.
Thank the senator. For what purpose does the senior senator from Chesterfield, Senator Hashmi, rise?
To speak to the bill, Mr. President.
Senator has the floor.
Thank you, Mr. President. Mr. President, I think this is a good bill. I think it helps us move forward in Virginia in addressing the needs of how do we really teach our students, how do we assess their growth, how do we assess their learning. The senator from Bedford is quite right. Reading skills have been declining in Virginia. As a college professor, I saw a huge transition of reading skill capabilities across the 30 years that I taught in college. The essays, the texts that I once could assign to students in 1995, I could not assign to them by 2015. Their skills had shown significant decline. But I would argue, Mr. President, that the decline in reading, the decline in writing, the decline in mathematics skills is not because we're testing less. It is because that our students are now spending fewer hours actually reading, actually spending time developing those critical and necessary skills. We need to invest in our children in a wise and deliberate manner. We need to listen to our educators who ask for a different way of supporting their students and of supporting their assessment processes. We have to assess learning through formative measures. We have to assess learning as the students are developing their skills, and also through summative assessments that really teach us and help us to understand what is working and what is not working in our classrooms. Mr. President, the students that I began to see in 2010, 2015 lacked critical thinking skills. They lacked the ability to read critically, write critically, and the ability to actually be informed and have information literacy. There are significant gaps in education. Testing in the manner that we have been doing is not accomplishing what we need to do in order to have skilled and critically capable and educated individuals coming out of our public schools and coming into our colleges and universities and joining our workforce. Mr. President, I urge that we pass this measure. Thank you.
Thank the senator. For what purpose, Senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. Speak to the bill.
Senator's the floor.
Thank you, Mr. President. I first wanted to give compliment to the senator from Bedford. I think I carried this bill 5 out of the last 6 years, and he successfully killed that effort 5 out of the last 6 years. So I think he's absolutely right. He's done this for a better part of a decade. But I'd also have to compliment his intentions are, I think, well placed because it's his love and concern of education, which I think we all share. I would submit, though, I was also a member of the SO Innovation Committee, that the composition and membership over those years did a number of really important things. One of which was to direct the Board of Education to develop the profile of a graduate. And through that process and public process, they developed the 5 C's: critical thinking, creative thinking, collaboration, communication, and citizenship. I'd remind the body that as a part of any diploma requirement, history is still a core competency. And again, citizenship is reflected in those 5 C's. This is something that is not going away, and I think is very heartfelt at the Board of Education, the board members, and the public process that went through. If we think about the continuum of where we invest, it's very clear that the data shows us the earlier we help kids to learn to read, they begin to reading to learn. And so the early investment in childhood education, we know that the data tells us that drives early success. The more confidence we build in pre-K and early investments, that's where we have faltered over many, many years, and we're just beginning to start to catch up. The idea or argument that if the federal government tests went away, we would be wandering in the desert is, I think, a little bit misplaced. We still have verified performance assessments. We still have the graduation requirements. We have a very well laid out plan and requirements from our Board of Education. I think it's time that this bill pass. It's long overdue. Our parents, our teachers, our students are tired of the high-stakes testing environment that has persisted for way too long, and would urge the body to vote for the measure. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Western Fairfax, Senator Marsden, rise?
Thank you, Mr. President. Speak to the bill.
Senator's the floor.
Thank you, Mr. President. Started a detention home in Fairfax County in 1982. And we ultimately ended up winning a National Association of Counties award for the program that we put in place. And the reason is that traditionally in detention homes, we'd kind of run ding-dong schools, make it easy, make it fun, don't challenge anybody. But we stopped that. I had a lead teacher who was responsible for all that, and she made sure, and this is before computers or anything else, that those kids' books came from their home school. Their assignments came from their home school. They stayed connected to their home school, and they started to put in the work. And we had parents coming in saying, gosh, can my kid stay here? Can he come home, and can I bring him here for school every day? Because there was a challenge going on. There was, as we adopted some learning tests, the teachers became competitive, and they started teaching the kids rather than entertaining the kids. I think we've gone far enough with reducing the testing environment. I think it's a little risky at this point. I would identify with the comments of the gentleman from Bedford, and I would ask that we defeat this bill. Thank you.
Thank the senator. For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
I speak to the bill, Mr.
Senator's the floor.
Thank you, Mr. President. I'm looking at the impact statement for this bill, and I'm seeing the tests that are being eliminated. Virginia Studies. And the next one is critical. Civics and economics. Now, in a time when most kids can't tell you the 3 branches of government, they can't tell you who their U.S. senator or their U.S. congressman is. They don't have any economic education whatsoever. They can't balance a checkbook. They don't know about interest. They don't know about bank accounts. We're going to eliminate that. World history is going to be gone. End of course world geography. Where's Nepal? Where's Ecuador? I bet you most kids can't tell you that. End of course Virginia history and U.S. history. Now, we make a big deal about STEM education, or at least we talk a big game about STEM education in the Commonwealth of Virginia, but guess what else is being eliminated in this bill? End of course earth science, gone. End of course chemistry, gone. These are critical areas of education. math and reading is critical as well. And I talked to a lot of university engineering teachers, and they will tell you that a lot of the kids coming out of school now have to go to remedial math before they can be admitted into the engineering schools in the Commonwealth of Virginia. I think it's short-sighted, and I think the gentleman from Bedford eloquently explained why we need to defeat this bill. And one last anecdote, Mr. President. I coached rec league football when my kids were growing up. And I had a mother that had recently moved from Massachusetts. And SOLs were in place there, and she was just ecstatically happy. She said, you know, Massachusetts doesn't have anything. Those kids aren't learning anything. Here in Virginia, at least I know they're learning something. So we've reduced the number of SOLs that are required now. But to decimate the SOL system with this bill, I think would be a real disservice to the children who are trying to get an education in the Commonwealth of Virginia. I urge you, please, to not vote for this bill.
Thank the senator. For what purpose is the senator from Eastern Fairfax? Senator Servell rise.
Speaking to the bill.
Senators, the floor.
Thank you, Mr. President. You know, this is now, I think, my 12th session. And usually I think I get it right, but every once in a while I take a vote that I have some second thoughts about. And back in, I think it was 2013, Governor McDonnell proposed this idea that we put grades on our schools based on people, on different schools' results on these scores. My memory is that I believe that law lasted about 6 months before we had second thoughts about it and came back and repealed it the very next session after I was one of the Democrats that crossed over and voted for it. And, you know, one of the reasons that I've had second thoughts about is these tests, as they're applied, they're not really fair to the schools or to the neighborhoods that they often end up reflecting. For example, you know, I represent an area, 200,000 people, where there's a lot of apartments, there's a lot of rental property, a lot of people moving around. And when you have a situation where the population is very transient, and also where you have high English as a second language issues, the schools end up being judged for students that are moving around, coming from other places, being taught by other teachers, and it's not really fair to the school. It reflects poorly on the school. And it's not really the school's fault, but it seems like it is. And what ends up happening with that is I think one of the unintended consequences of all this data we're putting out, that data is then taken, it's published and put out to the public, then people start making judgments about the quality of the school, the quality of the teachers, and they also make judgments about the quality of the neighborhoods. And from my point of view, all of this data and information that's out there, which is not actually reflective of the quality of education being delivered in the building, ends up, in a lot of ways, I think, contributing towards what the resegregation of society that we're starting to see, which has been well documented. And I mean, I think these things are very well intentioned, but they don't work. They don't achieve their objective. And the reality is they also send our teachers the message that we don't trust them as professionals. They're licensed professionals. We don't trust them, that we don't think they know how to do their job, and so we need to tell them how to do their job. And whenever I go to a school and speak, I guarantee you, I present these resolutions in schools every once in a while on their anniversaries. I often get a standing ovation from kindergartners through sixth graders when I stand up and say we're going to get rid of some of these. These tests are not popular. I've met very few people in the areas that I represent that think they work. And I think it's time that we sort of look back and reevaluate why we're doing it and what we think we're seeking to accomplish with it, because from my point of view, it hasn't achieved what I think we intended them to achieve.
Mr. President.
Senator from Bedford, Senator Newman.
Would the gentleman yield for a question?
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
President, I have so much respect for the gentleman's intellect and capabilities. So a couple questions. One, would the gentleman agree with me that there is no SOL test in kindergarten or those early grades.
Senator, the floor.
I'd agree there's not one in kindergarten, but the elementary school kids that are in there with the kindergartners certainly appreciate it, and they all start, cheering each other on.
I understand. Mr. President.
Further question.
Further question.
Further question.
I'll yield.
Senator Yields, you have the floor.
Mr. President, would the gentleman agree that really what we're talking about when we're talking about schools getting stigmatized, which I understand the gentleman's talking about, we're really not talking about the student assessment portion. We're talking about accreditation and the advertising of accreditation. Is that correct?
Senator, the floor.
Mr. President, what I would say is that I think that the data that is plowed in, that's part of it. I mean, I think these real estate websites that take this data and this information, they base it on many different variables, but the SOL scores play a part in accreditation as well, and so I think it all kind of ties together.
Mr. President, just a final question.
Senator Yield.
Mr. President, would the gentleman agree?
Senator Yield, you have the floor.
I'm sorry. Pardon me, Mr. President.
No, Senator, the floor.
Mr. President, would the gentleman agree with me that currently, basically, we lost accreditation a while back? Everyone basically is accredited or provisionally accredited, no matter what's happening with the individual tests for the individual students that we're talking about now, because it is a path to improvement. So it really, those stigma items that used to say, this one's accredited, that one's not accredited, this is A through F, all that's gone. And really what this bill is talking about is student achievement.
Senator, the floor.
Mr. President, what I would say is that I have, not being on the Education Committee, I don't do deep dives into this stuff, but I've noticed in the last 12 years that I've served that the number of accredited schools in my district has vanished. There used to be a lot, and now there's none. And so that seems to be the trend. I couldn't speak to exactly why that is, but I know that there's still data out there about each of these schools, and these real estate websites put out that data and those numbers as a means of asking people to consider those numbers when they're trying to decide whether to buy a house in a particular school district.
Mr. President, I thank the gentleman.
Thank you. Senator. For what purpose is the senator from Hampton, Senator Locke, rise?
Thank you, Mr. President. Speaking to the bill.
Senator's the floor.
Thank you, Mr. President. Like the senior senator from Chesterfield, I also teach at the collegiate level and am running into students who lack basic skills. They lack critical thinking. They lack analytical skills. They lack basic writing skills. And these are students who have come through the No Child Left Behind era. And sometimes it's their expectation that I'm going to teach to the test. As I move them through, every class, that somehow I'm going to teach them the test. And as I try to explain to them, that's not my ministry here. My ministry is to teach you information, and you need to learn this information for the test. And I remember being in a classroom of 8th graders once, and as I was talking to them, one child raised his hand and he said, "Is this going to be on the SOLs?" And it was basically like, if it's not going to be on the SOLs, I'm not interested in anything you got to say. And it was, the whole basic concept that, anything that's being said has to be in the context of teach me what's going to be on SOLs. And that's what SOLs have become, teaching to the test, rote memorization. And like the senator from Bedford, I am very, very passionate about civics, social studies, because, that was my major. So I certainly don't want that to go away, but there are other methods for measuring that and other methods for assessing that. And hopefully, as we start to figure this out, SOLs aren't it. And we can figure out other ways, to teach, geography, to teach civics, to teach social studies. But even if you have SOLs in place, students are still not going to know the 3 branches of government. They don't know it now. And they don't know where you can find Alabama on a map. They can't figure out where you can find Virginia on a map after taking SOLs. Because what they say is, that was on last year's SOL. I don't need to know that anymore. So, we simply need to move forward with this and figure out better ways of assessment for our students. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Roanoke County, Senator Suderline, rise?
Speak to the bill, Mr. President.
Senator, has the floor.
Thank you, Mr. President. I so often agree with the senator from Bedford, but this is something we see differently, and I have to take a special exception to the way he approached this, because Southwest Virginia, we don't have as much representation right now since the loss of Senator Chafin, and instead of directing his questions at the senator from Washington, we had to hear even more from the senator from Eastern Fairfax, and that wasn't great. But I bring a little different perspective. I know the senator from Roanoke City enjoys when we get to visit schools together, which we, in years without COVID, we do frequently. But I know he doesn't enjoy getting to hear over and over again about I'm being the only senator that's actually taking a standards of learning exam. And I hope that was going to change after the last election, but unfortunately it didn't. But having taken it, it's not a great approach to actually trying to learn. I can tell you I didn't learn government and civics because of anything on a standards of learning exam. And I think it's unfair to criticize the current situation and say that we don't have enough civic knowledge amongst the young public and saying that's why we need to keep the system the way it currently is. I don't think that that works. And I think that what we know is that when the standards of learning exams came out, it was significant progress. But there are other ways now that work very well. And what we need to do is continue to pursue a model like we continued on the path earlier today when we passed the Senator from Henrico's bill, having growth measures during the school year. It makes far more sense to assess students throughout the year with local information that you actually have quickly, rather than waiting till months after the school year ends to get the information and find out how students did on an exam. That makes very little sense. And it's not that great to say, oh, you passed the exam, but you're a pretty high-performing student, whereas if we have the growth measures throughout the year, we can say, you're a high-performing student that's only about a little above average now. Why are you actually declining? And also the students that are significantly behind that may not pass the standards of learning exam at the end of the year either way, but we took you from almost no performance to low performance, and we're going to try to get you to be proficient. And we can actually measure the students in a much more meaningful way. So with that, that's my perspective as having taken the exams. I did not think that I benefited or my then colleagues in public schools and senator from Fairfax City's district benefited. But I hope we will pass the senator from Washington's bill.
Thank the senator. For what purpose is the senior senator from Richmond City, Senator McClellan, rise?
Thank you, Mr. President. I speak very briefly to the bill.
Senator's the floor.
I just want to reiterate that in eliminating the standardized SOL test, we are not eliminating the underlying standards that must be taught, nor are we eliminating assessment to determine if the course matter is being learned. Under current law, there's still an assessment. There's an end of course assessment. There's an end of year assessment. The Department of Education has to work with the localities to determine they're actually assessing what the students know. What we are eliminating are timed, computerized, multiple choice tests that assume all kids are proficient at timed, online, multiple choice tests, and they're not. And not only are they not, but many of them get so tied up in knots preparing for these tests, they spend more time stressing out and preparing for the test than they do learning the content, especially our young kids. 3rd grade is where you first take the SOL tests. Now, subject to check, I saw a statistic where 1 in 5 of our school students have some form of ADHD, ADD, anxiety that impacts their ability to do well on these tests. For those students, and for many students, these tests are not accurately telling us whether they can read or have learned the content. I've seen that with my own son. I've seen that with my son, who in 3rd grade, his 3rd grade teacher said, the things that he can do with math, the way his brain works, he's advanced. He is more advanced than what a 3rd grade student should be with math. That didn't show up on his SOL test. That did not show up on his SOL test because as he saw the timer go, he started to panic. I agree we need to teach civics. I agree we need to teach history. I agree we need to make sure kids can read, because if they can't read, they're not going to learn anything else. But what these tests have done is fundamentally changed our education system, where it is rote memorization in a classroom to prepare for a test. And as a result, we've gotten away from when you stop to figure out, I'll take history as an example. Teaching history in Virginia have become more about, have you memorized these dates? Do you know what happened in 1607? Do you know what happened in 1619? And not, can we talk about and think critically about why what happened in those dates mattered? And as the senior senator from Chesterfield alluded to, we've got a generation of people who didn't learn critical thinking in school. We got to change that. Getting rid of these multiple choice tests is not going to be the rise and fall of our education system, but it is going to shift us to a system that actually looks at, have these kids learned the content in a way that truly reflects whether or not they've learned it. Thank you, Mr. President.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1401? Seeing none, the question is, shall Senate Bill 1401 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 26, noes 12.
Ayes 26, noes 12. Senate Bill 1401 passes.
Senate Bill 1406. A bill relating to marijuana, legalization of simple possession penalties.
Senator from Alexandria, Senator Eben.
Thank you, Mr. President. I move the bill pass, and speaking to that motion.
Senators, the floor.
Our Commonwealth's prohibition on cannabis has clearly failed. We've had hundreds of thousands of Virginians branded as criminals and disadvantaged in a myriad of ways. And the war on marijuana has disproportionately targeted and impacted Virginia's communities of color. That's why I believe that last year the body decriminalized possession on a bipartisan basis and enacted in-depth studies on the legalization of cannabis from both JLARC and from an executive work group of policy experts and secretariats from the governor's office. This bill, based on these in-depth studies, has now been vetted by nearly 20 hours of subcommittee work and 3 full committees of the Senate. It is a forward-thinking, deliberative approach to create a regulated adult-use market for cannabis, which will reform our criminal justice system and begin the long process of undoing the harms of prohibition. It's focused on the following guiding principles: social, racial, and economic equity by undoing the harms of prohibition, by funding and creating a process for expunging marijuana-related offenses, promoting diverse participation in newly created industry, reinvesting in the communities harmed by prohibition. With an eye to public health, it creates substance abuse prevention efforts significantly in schools and communities, and establishes a framework to prevent harm and reduce abuse. It provides some protections for young people with a 21-year-old age limit, mandatory ID checks, and education campaigns. And in all parts of this bill, provides for data collection and legislative oversight. It will ensure that Virginia collects appropriate and ongoing information on safety, health, and equity, and establishes a joint commission on cannabis oversight composed of equal members of the House and Senate to oversee the process of legalization. It starts by repealing the penalty for possessing less than an ounce of marijuana this summer, creates an independent agency, the Cannabis Control Authority, beginning this summer, begins petition-based expungement July 1st, with automatic expungement to follow in coming years as systems are developed, provides for 5 types of business licenses: cultivation, processing, retail, testing, and equity licenses, establishes a preference for social equity qualified candidates in the licensing process, and dedicates low or no interest loans for qualified applicants, discounted or waived fees for social equity qualified candidates. It remains an offense for underage consumption under this legislation. Public consumption has a fine attached to it, and there's some safety precautions with tamper-evident packaging, child safety mechanisms, clear information on potency, and warning labels. Dedicates the revenue in the following ways: 40% to pre-K for at-risk 3 and 4-year-olds, 30% for an equity reinvestment fund, 25% for addiction prevention and treatment services, 5% for public health. The tax structure for the legislation sets an excise tax at 21%. It allows localities an additional 3% tax on retailers on top of, in addition to retail sales tax. It allows, when sales are legalized in January of 2024, for each household to grow up to 4 plants for personal use if they're hidden from public view. It provides some element of local control with an option for localities to opt out of allowing retail stores by referenda. Limits on advertising to not appeal to children. Sees that retail cannabis cannot be within 1,000 feet of schools or child center facilities or substance abuse training centers. There's an enactment clause that calls for an advisory referendum in this November's election to let the public weigh in on this significant policy change. There is a reenactment clause on the most detailed portion of the regulations, and though the Cannabis Control Authority would begin working on regulations July 1st, they would not become effective until 2024 after a second vote of the General Assembly as this legislation stands. So that's the explanation of the bill. I renew my motion that the bill pass, and I'm available to answer questions.
Thank the senator. For what purpose, the senator from Lynchburg, Senator Peake, rise?
Yes, sir. Thank you, Mr. President, to speak to the bill.
Senator's the floor.
Thank you. And I rise to speak against the bill. I think this is a bad idea, and I especially think it's a bad idea since we just decriminalized marijuana last year, and that bill went into effect July 1st, decriminalization. I think it would be a wise decision to wait and see what effect decriminalization had before we went ahead with full legalization. I was at the Judiciary meeting on Monday when this bill came through, and the senator from Bath noted that he's been in the General Assembly for 30 years, and this was the largest bill that he has ever seen. It's 280 pages with over 13,000 lines. And after we left that meeting, I was talking with someone that I respect greatly, who happens to be a Democrat involved in the political process. And he said to me, you know, I wish the administration had spent as much time on the coronavirus as they have on this marijuana bill. And it got me to thinking, and I thought about it a little bit, and started looking around, and I said, you know, that's a pretty good point. And so I've got a little compare and contrast things that I want to point out to the body. I know some of these might be more appropriate for a point of personal privilege, but I think it's best just to go ahead and do it and compare and contrast some of the things with the vaccine with what we're doing in this marijuana bill. I'll try and be fairly brief, but I appreciate your indulgence as I stray a little bit from the marijuana bill. But the senator explained a lot of it, of what is going on in this bill. And we go back to June of 2020. I think that's when the JLARC study came out. We're in the midst of the pandemic at that point. The JLARC study came out in favor of marijuana, and the governor touted the report and got all on board, and then started working June of 2020, in the middle of the pandemic, full speed on getting this marijuana legalization bill together and getting it in front of the General Assembly and getting it passed as soon as possible. And among the things that strike me, especially when you compare it with the response to the pandemic, are the focus towards the minority community. This bill has the Cannabis Equity Reinvestment Board, the Cannabis Social Equity Liaison, the Cannabis Social Equity Support Team, and the Cannabis Equity Loans Business Provision, and various other provisions, all designed to get marijuana into minority hands, into minority businesses, and ultimately into the minority community. I refer back to the olden days, back when I was in school and we still had civics and social studies. We had George Orwell's Animal Farm, 1984, and Aldous Huxley's Brave New World, where the government kind of fed drugs to the population to make it easier to govern. Today's marijuana is nothing like the marijuana back when the senior citizen senator from Fairfax was a hippie. It was 2% to 5% THC back in the 70s. Today's marijuana is anywhere from 20 to 25% THC. Studies have shown that especially among teenagers, that level of THC has caused an inordinate amount of depression, anxiety, schizophrenia, and memory effects. Nevertheless, we're going full steam ahead. And I know it's only supposed to be 21, but you know how that works with alcohol and everything else. It's not going to stay with 21-year-olds. It's going to affect our youth. And let's look at what we've done with vaccines. And the comments that my Democrat friend in the political community made to me on Monday. During this week, Richmond Times-Dispatch did an article talking about vaccines in the minority community. In Richmond, in one minority zip code, there are 8 times more coronavirus cases than there are in a more exclusive zip code just 5 miles away. In 4 zip codes in Richmond with 60%, they have 60% of the Richmond cases of the coronavirus, and those zip codes have 54% to 80% of Black Latino population. Of the first 500,000 doses of the vaccine that were administered, this administration did nothing to track what ethnic or race groups they were going to. When we got here, January 13th, there was absolutely no plan from this administration, no bill, no law about administering vaccines or response to the coronavirus. In fact, the senator from Henrico put together a bill, 1 page and into about 13 lines onto a second page, emergency bill that we all signed on to address the deficiency of the coronavirus vaccine program that was going on in the Commonwealth. Back to marijuana. Back to marijuana. I told you I'd link it up, and I am. I find it inexcusable that this administration has devoted more time and energy and effort in getting THC into the bloodstreams of our minority community than it has in getting the coronavirus vaccine into the bloodstreams of our minority community. It is a gross failure. We need to step up and talk about it. And in fact, in the governor's press conference today, 11 months into a declared state of emergency, he said, we're going to update our window so that we can now track what ethnic groups are getting the vaccine. And we're going to get more callers on the call centers so people can get lined up to get the vaccine. I don't think it's a good idea to put THC into our community, to make it legal. I think it's a very bad idea. Think about the long term. Oh, I forget, we are getting $300 million. Oh, if I forgot about that, we're getting $300 million. At what cost to our future are we getting $300 million? What's it going to do to our youth? What's it going to do to our safety, people driving on the road? What's it going to do to our workforce? What's it going to do to our health? So when you start thinking about that $300 million, think about what it's going to do. And I thank you, and I hope you'll vote against this bill.
Thank the senator. For purposes, Senator from Portsmouth, Senator Lucas rise.
Thank you, Mr. President. Speaking in favor of the bill.
Senator has the floor.
Mr. President, all of my life I've heard justice delayed is justice denied. And the entire time that the senator from Lynchburg was speaking, those words kept rolling around in my head. From 2015 to 2019, over 23,000 Virginians were arrested for simple possession of marijuana. That's nearly 5,000 Virginians a year. Black Virginians are more than 3.5 times as likely to be arrested for marijuana despite using at similar rates as white Virginians. JLOC found that racial disparity was true in localities across the state in every region. The General Assembly acknowledged that injustice last year when we decriminalized simple possession. It was a good first step, but more is needed. The bill is the next step. It lays out a 3-year path to create regulatory and licensing structures that promotes diversity participation in the industry, ensures that the product is for sale for consumers, and updates the criminal code to reflect legalization of marijuana for adults over 21. It also creates an expungement process for marijuana-related crimes. That's right, the injustice of prohibition, and let's vote right now and make Virginia the 16th state to legalize sales in Virginia. And with that, Mr. President, I'm going to turn it back over to my co-patron of this bill, and I also move passage of the bill.
Thank the senator. The senator from Alexandria, do you want to go last? There are a number of other senators who want to speak. Okay. For what purpose, senator from Hanover, Senator McDougal, rise.
Thank you, Mr. President. Mr. President, would the gentleman from Arlington, Alexandria, yield for a question?
Senator Yield.
I yield.
Senator Yield, you have the floor.
Mr. President, I'm going to try to focus my questions because I know we still have a lot to get through. Mr. President, I'd ask the gentleman in the final version, at what date will the authority to regulate the legal sale of marijuana be in place?
Senator's the floor.
Thank you, Mr. President. They'll begin promulgating regulations after July 1st, but they won't be able to take effect until a second vote of the General Assembly. It's anticipated that would be January 1st, 2024, that it would actually be available.
Mr. President, would the gentleman yield for a further question?
Senator Yield.
I yield.
Senator Yield, you have the floor.
And Mr. President, I'd ask the gentleman, so legalization of marijuana will begin on what date?
The
Senator's the floor.
penalty currently in place for marijuana would be repealed July 1st.
Mr. President,
The legal product would be available, as I said, in 2024.
Further question?
Mr. President, I ask the gentleman, with the penalty being repealed on July 1st of this year, so in a few months, what is the maximum amount of marijuana an individual can possess before there will be a penalty?
Senator's the floor.
No more than an ounce.
Further question?
Mr. President, I ask the gentleman additional question.
Senator Yield.
I yield.
Senator
Mr.
Yield,
President,
the floor.
at one point the version had a higher amount from that. Has that was up to 5 pounds before there would be a penalty?
I
Senator's the
believe
floor.
it's an ounce is the July 1st limit. If he wants to point me to a line number in the bill, I can check, but otherwise it's an ounce. That's my intent. 11,000 what?
Mr. President, with 11,000 lines, it might take me a few minutes to find the line if the gentleman is not aware of where it is.
Further question?
No, Mr. President.
Thank the senator. For what purpose does the senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. Speaking to the bill.
Senator's the floor.
Thank you. We got to love a debate on cannabis that starts at 4:20 in the afternoon. A couple of things I wanted to appreciate. First off, the level of collaboration through subcommittees and committees that has occurred on a bipartisan fashion, even though I think there are still some differences. I think there's a lot of construction and constructive dialogue along this way. I think the bill still has a journey as it obviously goes through the House and likewise the House version over to the Senate. I'd like to just point out a couple things from a very pragmatic standpoint. In addition to what the co-patron, Senator Lucas, indicated in terms of the disparity of arrest rates, which is very clear in the JLARC report, I think there's also a very pragmatic point to be made in terms of concerns over product safety. What this actually does is provide a framework for a regulatory framework that gives you an ability to regulate the amount of THC. Not only that, the product quality, ensuring that contaminants, pesticides, and the rest of it are not in the products. Without that, you have product that we know that's on the streets right now that has contaminants that might be laced with something else. So this is, from my standpoint, understanding that this occurs in our community. People consume different forms of cannabis today. Moving forward with this new independent regulatory agency, we'll provide safety factor, testing factors, and the rest of it to provide a safe product. And again, you can limit the amount of THC within those products. So I think there are some upsides in addition to the efforts on public health in terms of the revenue dedication, the Cannabis Equity Fund, and several other efforts which I think are critical. So I hear some of the criticism from the senator from Lynchburg. However, I think there are some due considerations on the safety and product safety factor which are important to this debate, and also ask that the bill pass. And I think we'll hopefully see this bill improve as it continues through the process. Thank you, Mr. President.
Thank you. Senator, for what purpose does the junior senator from Virginia Beach, Senator Kiggins, rise?
Mr. President, would the patron yield for a question?
Senator Yield. Senator Yield, you have the floor.
Thank you. To ask the patron, what consideration, if any, has been given just to ensure that no harm is done to the medical cannabis industry, given their important role just with providing medical product to patients? And a lot of those guys have just opened their doors. For example, the medical dispensary that serves the Hampton Roads region has only been open for 5 weeks. So just out of concern, could you just specify what's protective in the bill?
Sure. I thank the senator for the question and for the concern for the burgeoning medical providers. The bill allows for the medical providers to have as many as 5 retail licenses each, in addition to the licenses that they already have to produce the product. So I don't see any harm done to those medical providers, and it's our intention to do all we can to see that they're not harmed.
Further question?
Thank you to the patron. Just to speak to his point,
Senator's the floor.
I just want to raise the point of being mindful of this new, developing industry that we have just recently set all of the rules and regulations in place. These guys are now opening their doors. There's 4 open and 1 more up and coming medicinal marijuana dispensary. I have toured one of them and was skeptical going there, but the security, the cleanliness, the safety, the science behind what they're doing, and then just seeing the other side and how I know patients that benefit from this type of treatment. People that are under 21 have access, children who have cancer, children on hospice, people on long-term care who can't get to some of these other venues. They have access to this pharmaceutical product. So I just think we need to be mindful of being protective and asking ourselves a question of what this type of legalization of adult recreational marijuana is going to do to that industry. So in 2016, Oregon, for example, who's kind of on the spearhead of this adult legalization, they had over 400 medical dispensaries for medicinal marijuana. After they legalized their adult use product, which was legal in 2014, they are now down to only 1 in the state of Oregon. There is only 1 medical dispensary left in Oregon. And we have spent so much time and so much money and, again, made so many rules and regulations, and I feel like they're doing it right. And for me to say that, I had to see that with my own eyes. But I want that industry to succeed, to be there for the patients who need it, to be there for the hospice people who need it for seizures, for epilepsy, for cancer pain, people who are in long-term care facilities. So I think that we need to let that succeed and let that industry grow. And I just worry that we're doing too much too soon. I wish we would slow the roll with this whole rollout process. I understand the rationale behind it, but we have just a new fledgling industry that I think is a lot of potential, and I would like to see the benefits to the healthcare industry. And so I just worry that what we're doing is too much too soon. If I could ask one more question to the patron.
I yield.
Senator Yields, you have the floor.
Could you also just clarify what exactly is in this bill about driving safety protocols as well and educating the public, specifically younger people, about driving safety?
Senator's the floor.
Yes, one of the enactment clause calls for public safety campaigns to begin at least 6 months before legalization. Further, Senator Lucas and I have put budget amendments in to train officers in advanced techniques to deal with people who are impaired when they drive. They have a program now that does that, but we want to be able to train more officers starting with this year's budget.
Thank you to the patron. That's just an important piece I want to make sure is in place. So just in closing from me, I sat in the subcommittee as well in 11 hours on a great education on this whole adult rollout program. And there were many times, I could probably count on both hands, the number of times the question when we didn't know exactly how to refine the code or how to tweak the bill, the question was asked, well, what do we do in Oregon? What do we do in California? And we would look and mimic a lot of the times what's going on there. So I just want to pose that question as well. We're Virginia, we're the Commonwealth of Virginia. We're not Oregon, we're not California. I have some concerns about going there too fast, too soon. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Arlington, Senator Favola, rise?
Thank you, Mr. President. Speaking in favor of the bill before us.
Senators, the floor.
Thank you, Mr. President. I just want to note for the body that at least in the Rehabilitation and Social Services Committee, we had 8 hours of testimony. We had a subcommittee that met twice and for 3 hours each time, and then the full committee met for, we had a 2-hour block of time where we really delved into this proposal and took public comment. And there were significant points made about the need to set a framework that would establish a rational way for allowing marijuana into the marketplace, that we would consider social equity, but we would consider a limited retail composition or retail concentration, so we would not overwhelm any one geographic area. I think as we now have it, localities will opt out. Is that correct, to the senator from Alexandria? So that probably will ensure that most localities will participate. And I believe that they have the option of holding a referendum. So there's yet another opportunity for public comment. We focused a lot on the safety of this. This is adult use marijuana. I know that the proposal that the governor put forth had an education campaign. It had significant protections in there. And just as with the sale of alcohol, the sale of marijuana to a minor would have up to a $2,500 fine or 12 months in jail. It would be treated very seriously. Enforcement would be taken very seriously. And the regulatory process will start July 1. And again, the regulatory process is going to be a very open process. The stakeholders will have to convene, get together, comment. Regulations will be revised again. And then, of course, the actual sale, I think we have for January 1, 2024. So this is a framework, is my message here. We think we've got some of the key factors in place to ensure that we have a fair market. We allow some integration where we need it. We allow social equity. We focus on adult use. And then, of course, we have other protections. I know the Judiciary Committee worked extensively on the expungement piece. So because you haven't read the 250-page document, I wouldn't let that alone concern you. I would just go through the sections that we outlined and highlight the areas that you feel more work needs to be done. And I think that we certainly can ensure that the regulatory process fleshes out the detail. I think this proposal is a good proposal. I believe the time has come, and I would like to see it move forward. So with those comments, Mr. President, I again move that we pass the bill.
Thank the senator. For what purpose, Senator from Henrico? Senator Donovan, rise.
Thank you, Mr. President. I rise to speak to the bill.
Senators, the floor.
I want to echo the comments of the junior senator from Virginia Beach. What we have done with medical cannabis in Virginia is really important for the patients. And I will point out it took us 5 years to get there. From the first time that bill passed, it was really more than 5 years before the pharmacies opened. And so I see this bill as a starting point, especially when we look at the process of the pharmaceutical processors that are already in place, and that there's a lot of details that are going to be worked out to make sure this is done in a very reasonable and rational way that takes into consideration all of the different important aspects of decision making that we need to have going forward. And I'm pleased to say the regulations are not even enacted until a year from this July. So they'll be worked on. So we have plenty of time to work on this bill. And I think adult regulation is a way to make sure we have control over the products that our community is being exposed to, and that's really important because of the comments we've had about the concentrations, especially in the marijuana that's sold illegally, and in the polypharmacy that our children are exposed to from dealers that kind of have free reign right now. And so I like to look at this as adult regulation, and I think it's a starting point for us to go forward. Thank you, Mr. President.
Thank the senator. For what purpose does the senior senator from Fairfax, Senator Saslaw, rise?
Mr. President, I was not here at the time that in 1968 when they put the referendum, liquor by the drink, but I served with plenty of people who did. And they told me about all the arguments against it. And quite frankly, I'm hearing, from what they told me, I'm hearing a repeat of it for today, almost identical arguments. We're not ready for it. We need more time to do this. Those were the arguments they used against liquor by the drink. And in 1979, when I changed the ratio, I changed the words food to meal, meal to food. And to give you an idea of how absurd some of these laws were, if you served a hamburger, that was not considered a meal, but if it had lettuce, tomato, and French fries, it was. You could count that in your ratio. And the ratio then was 50% meals and 50% alcohol, and if you went above that, you would lose your license. And to give you an idea of how easy it was to have this happen, with the advent of the popularity of wine, let's suppose that Janet, Senator Howe, and I go into a restaurant, we each order a $20 meal and a $40 bottle of wine, and Senator Lucas and Senator Ruff go in and sit down and they have the same meal but order a $60 bottle of wine. If more people do that than what Senator Howe and I did, they would lose their license even though they serve no more alcohol. Then we had to do, when I went up to see if Governor Dalton would sign the bill, he told me the worst vote he cast in his entire career was against liquor by the drink. And over the years, these are some of the changes we had to make. For instance, if a table had 4 sides, it was for 4 people, and a 5th person sat down to drink, one of the 4 at the table would have to give up their alcohol. If I wanted to walk from just here to where Senator Newman was, a waiter or waitress had to carry that wine. I couldn't do it. Then we passed a bill called Stand and Sip. You couldn't stand at a bar. Then we changed that from walk and sip to stand and sip. You can't believe all of the laws that we had to go through over the years. You're worried about waiting more time. It took us 20-some years to get it right. And there's no sense spending 20 years hoping that you can start with perfection. And it won't be perfection, but it's clear where the rest of the country is moving, and that's where the country was moving when we enacted liquor by the drink. Everybody else was doing that. So I've heard all these arguments before on another product, and quite frankly, the time has come. I don't want to be a wise guy and say it's high time we did something about marijuana, but the fact is the time has arrived for us to start this movement. Will it be perfect? No, it won't. Will it have problems? Yes, it will, but we'll get it straight. It won't be the end of the world.
Thank the senator. For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
Speak to the bill
Senator, it's the floor.
So before I do that, I'd ask the gentleman from the senator from Rockingham if he would rise for a question.
Senator Yield.
I yield, dude.
Senator Yield, you have the floor.
Gnarly. I'd ask the gentleman. I really object to outside influences on our deliberations here in the Senate. I would ask the gentleman, what was the name of the soup that you had for lunch today?
Senator's the floor.
Mr. President, I don't know who set the menu, but I believe that Merriweather's was serving healthy doses of herb soup today.
That's what I thought. Thank you, gentlemen. And also, one more comment, thank you, gentlemen. One more comment, Mr. President. If Senator Saslaw gets up here and actually makes the assertion that Senator Ruff would spend more on a bottle of wine, he's already been doing something.
Thank the senator. Do any senators other than the patron wish to be heard regarding Senate Bill 1406?
Mr. President.
The junior senator from Chesterfield, Senator Chase.
Thank you, Mr. President. Just one last comment here. I want to talk about four numbers: 24, 20, 21, and 18. Those are the ages of my kids, Melanie, Joseph, Timothy, and Daniel. You know, this is a very personal issue, not only for me, but for many parents of young adults across Virginia who are out on their own for the first time and making these decisions for their own. And I just think that we need to, while we're all grown adults in this room, we have kids out there who are young adults who are spreading their wings for the first time. My kids have all moved out of the house, except for one who's in college. What message are we going to be sending with this bill to our young adults? It's okay to do marijuana now. You know, Mr. President, I've visited the jail here in Chesterfield County. I've met with a lot of young men, young women who are sitting in those jails, and they're there for various reasons. And one of those that came up, one of the issues that came up was, how did you get here? And it all started with they decided to smoke some marijuana. That was their gateway drug that led to where they were now, smoking other types of drugs. I think we really need to think, I mean, this bill is, got a lot of complicated elements to it, but forgive me for breaking it down to something so simple as what message are we sending to our teenagers? What message are we sending to young adults with this bill? Because I can tell you that the message that's going to be sent is that it's okay now to do marijuana. We're going to take away that stigma and say, you know what? Marijuana is okay now. I've yet to see a study, and please produce it if you've got the study and you're holding out, on one test or one study that shows that using marijuana is going to increase the test scores for our kids in schools, because I've yet to see it. Not one. I've never seen a study that shows kids that smoke marijuana, or teens or adults, because they're going to get it, whether it's for adults or not. Just like the senator from, I don't have my list in front of me, Senator Saslaw mentioned, it started with alcohol. We can see exactly what's going to be the path for legalization of simple possession of marijuana. It's going to be the same path that alcohol has taken, where we have kids that have overdosed, mothers against drunk driving, because of the issues that alcohol and under influence has created. And I just think we're going down a dangerous path today. And we really need to think about our kids and the next generation. What does this mean for our kids? What message are we going to send today with this vote? Thank you, Mr. President.
Thank the senator. Senator from Alexandria, Senator Ebbett.
Yes, speaking to the
Mr. President, I wanted to speak before the wrap up.
Okay, sorry, get the senator from James City County, Senator Norman.
Thank you. Excuse me for interrupting you.
No, Senator has the floor.
Let's Senator Evan wanted to wrap up. First of all, let me say I have not read the 250 some pages or the 11,000 lines, but I did attend a 3-day conference out in Denver, Colorado, dealing with the legalization of marijuana and what their experiences have been, both from a usage standpoint, a marketing standpoint, and a regulatory standpoint. I was amused at my dear friend, Senator Saslaw, who always is so accurate in recalling the chronology of various bills. And he shared with us liquor by the drink and how that has evolved over the years. I understood his point that this legislation will have to evolve over the years. Huge difference, huge difference. When we were doing liquor by the drink, it was against the law in the Commonwealth of Virginia for anyone other than the regulated industry to manufacture liquor commonly known as moonshine. As Colorado went through it, and as Virginia is moving in that direction, it is going to authorize the legal raising of marijuana plants in your backyard. And I understand the various stages that it has to go through and the monitoring on the THC. But if you think for a second that young people are not going to be tempted with the immediate proximity of marijuana plants in their backyard to partake of it, I think you're very naive. Mr. President, if Senator Evan would be so kind to yield for a question or two.
Senator Yield.
I yield.
Senator Yield, you have the floor.
I would ask the senator to explain for me, because I have noticed that some euphemisms have been absolutely pervasive during this session and in the special session that we have. Would you please define for me so that in my very simplistic mind, I can understand what the euphemism of social equity means in this legislation?
Senator has the floor.
Sure. In a larger sense, the message of social equity is that we don't penalize black and brown adults over fear of a plant. But in terms of specific actions, there are 3 ways that social equity is in the bill. We expunge past marijuana misdemeanors and allow for petition expungement for other marijuana crimes. We provide funding to go into some of the communities that have been harmed by the war on marijuana for things like reentry, scholarships, job training, and lastly, we don't limit this industry just to big business, that we allow for some who've been harmed by marijuana to actually participate in this new industry.
I appreciate the gentleman's response. If I could follow up on that, and once again, I am never ashamed to admit my own ignorance in this. It's because I haven't read the entire bill. Is there any preferential treatment under the licensing provisions to any particular population in the Commonwealth of Virginia as it relates to those licenses?
Senator Yield, you have the floor.
I yield, yes. There are social equity licenses for a variety of people to try and create diverse ownership, whether it's people who attended a historically black college or university, people in a jurisdiction that the board has determined is economically distressed, or that it's disproportionately been policed, or someone who's actually been charged with a marijuana offense. Those are among the social equity licenses that would be fleshed out by the board.
Mr. President, another question.
Senator Yield.
I yield.
Senator Yield, you have the floor.
So I understand one of the criteria for preferential treatment on the issuance of a license is an economically disadvantaged community. So we're going to give that economically disadvantaged community preferential treatment on receiving a license? Is that what you just told me?
No.
There's the floor.
Yeah, I yield. No, Mr. President. It would be people who had resided in that community for, I think, 3 of the last 5 years.
Further question?
It's not to
Mr. President, another question.
Senator Yields.
Don't you, Mr. President, I'm sorry. The actual issuance of the license, can there be a absentee individual who maybe resided in that economically deprived community 5 years ago, but who has enjoyed economic success and that he or she doesn't currently live there, but they can get a license and legally dispense marijuana in that economically deprived community?
I would state that first they would have to have lived there for 3 of the last 5 years, and further that the license, the geographic location of the license is not tied to the community itself.
Further question?
No, sir. Speaking to the bill.
Senators, the floor.
Mr. President, as the patron knows, I actually started the advocacy on the decriminalization of marijuana and welcomed his insight and advocacy. And initially, I was supportive of the approach that is encompassed in this bill. I have been persuaded not to support it for a couple of reasons right now. First of all, I've got to say I was shocked when it was referenced the length of the bill and the number of lines, and the comment was made, don't worry about reading it. Don't worry about reading it. We're going to get it straight. That almost is an echo in my mind about what happens in the United States Congress, and specifically on 15,000 pages on Medicaid expansion. Just vote for it, and then you can read it. I pray, Mr. President, we are not starting to legislate like that in the Commonwealth of Virginia. Second point, Mr. President, I certainly am amenable to being educated by some of my friends in a private setting, but I just don't accept this social equity set aside on the issuance of licenses. We don't do it for alcohol. We don't do it for other matters. And I just am perplexed. Thank you, Mr. President.
Thank the senator. For what purpose does Senator from Hanover, Senator McDougal, rise?
Mr. President, just to speak briefly to clear up
the
the question. Mr. President, after talking to all the attorneys, just want to clarify the penalty. As of July 1st, there will be no penalty for simple possession of marijuana. The statutes that are in place now in the Code of Virginia that are not being repealed are for distribution of marijuana. So those statutes, if you distribute marijuana, there will be no penalty. There will be a penalty, and that penalties are at different levels. But if you simply possess marijuana up to any amount with no distribution, there is no penalty at all.
Thank the senator. Senator from Alexandria, Senator Eben.
Yes, speaking to the bill, just to close out a few comments, responding to some of the other thoughts that senators had. First, I don't want to dwell on this, but the administration has certainly spent a lot more time on the coronavirus than on this bill. We directed them to come up with a study, a responsible course, and they did that, helmed by the Department of Agriculture. This is not related to vaccines at all. The bill has pages and pages of safeguards. I encourage people and welcome them to read the bill as it continues through the process. I've read this whole bill. I know that the gentleman from Prince William has, and it's resulted in informed consideration and some good points. I want to thank particularly the junior senator from Virginia Beach. I'm happy to work with her over the interim to address any concerns about how we can continue to see that our medical dispensaries thrive They're each, though they only have one geographic location open now each, they're each entitled to open, I believe, 5 additional over the next few years. And just to emphasize what the senator from Prince William said, there are limits on THC levels in the bill and the amount that can be sold. There's testing of the product to make sure it's not contaminated with other drugs. To me, that is very, very important. We don't want people getting laced with products that they're not expecting and that would serve them poorly. The illicit market will suffer as the legal framework is launched, helping us to keep this away from children. There are penalties for people under 21. So with that, I renew my motion that the bill pass.
Thank the senator. For what purpose does the senior senator from Virginia Beach, Senator D. Steph, rise?
Mr. President, first of all, I apologize to the body. I truly did not want to stand up and talk on this bill. I had not intended on it. But will the gentleman from Alexandria yield for a quick question?
Senator Yield.
I yield.
Senator Yield, you have the floor.
Mr. President, I've been thinking about this, and I've thought long and hard, and not just today. Can the gentleman answer me, how can you provide preferential treatment for one class or group of citizens over another without diminishing the rights of another group or class of citizens?
Senator's the floor.
Well, I would say that just in terms of the equity license applicant category, there's a variety of ways to get an equity license. Not every license that's granted, in my opinion, will be an equity license. So there will be ability for all to apply for licenses, but the first stage is for the equity applicants, in addition to the already existing people with pharmaceutical licenses.
Mr. President, will the gentleman, actually, Mr. President, speaking to the bill.
Senator's the floor.
Mr. President, the true answer is you can't. You can't provide preferential treatment to one group or class of citizen without diminishing the rights of another. That's referred to as discrimination. Everybody in this chamber went through training on discrimination. You can't do it. You cannot provide preferential treatment lifting up one class or group of citizens over another without diminishing the rights of the other class or group of citizens. What we're trying to do here is perpetuate the same thing we're trying to stop. And I'll tell you, I've done a lot of reading, I've done a lot of studying on this, and it's really easy. You can't discriminate or fix discrimination by discriminating. And I've had the conversation in here before when somebody pointed it out or said something that was somewhat that I said or had, where I had an American flag on the back of my pickup truck. They said I was racist. I said, well, you can call me anything you want. Call me a patriot, call me a nationalist, but you can't call me a racist. I believe we're all brothers and sisters. I believe we're all children of God. I believe we're all brothers and sisters of humanity. I believe we're all red. When you cut us, we all bleed red. And Mr. President, you can't provide preferential treatment to one group or class of citizen without diminishing the rights of another. That's racism, that's discrimination, and that's what we're supposed to be here to stop. And when you provide preferential treatment to one group or over another, that's eliminating or perpetuating what we're trying to stop. Mr. President, there are things I like in this bill and things I don't like in this bill. But when we as a body are starting to discriminate and we're putting it in legislation, I really take offense to that, and I really think we've had enough. Thank you.
For what purpose does the senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. I wanted to address the senior senator from Virginia Beach's question. And
there's the floor.
Thank you. Just to be very brief, the sections written out were written to be intentionally constitutional, that they, in fact, do not discriminate. They could be a white person, Asian, black, any number of categories meeting the definitions under the social equity, based on the multiple layers of definitions within there. There's nothing that excludes different classes of folks from attending historically black colleges, nor growing up within areas that have been highly impacted by over-policing, Mr. President. So I just want to make sure that the body understood and corrected the facts on it. This was reviewed in subcommittee in very much detail, and these questions asked and addressed. This does not, in fact, discriminate. Thank you.
Thank the senator. Question is, shall Senate Bill 1406 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 23, noes 15.
Ayes 23, noes 15. Senate Bill 1406 passes.
Senate Bill 1418, a bill relating to grants from the Commonwealth's Development Opportunity Fund, waiver or reduction of capital investment, and local match requirements.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. Move the bill pass. And speaking to the motion.
Senators, the floor.
Thank you very much, Mr. President. This is a bill that VEDP has been very mindful in watching as COVID has impacted our communities and the increased teleworking opportunities. This tools our telework grant opportunities for areas impacted with the Commonwealth Opportunity Fund, which are primarily South Side and Southwest Virginia, as well as some other areas that have some economic distress, and encourages sort of an allowable grant opportunities for telework with reduced grant requirements, acknowledging that companies of the future may be making different sort of investment decisions, but we still want to draw jobs to impacted communities all across the Commonwealth, Mr. President. And with that, ask the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1418? Seeing none, the question is, shall Senate Bill 1418 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 38, noes 0.
Ayes 38, noes 0. Senate Bill 1418 passes.
Senate Bill 1428, a bill relating to alcoholic beverage control, operation of government stores, sale of low alcohol beverage coolers.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. I move that Senate Bill 1428 pass. And speaking to that motion.
Senators, the floor.
Thank you, Mr. President. Senate Bill 1428 clears up a marketplace issue between the ABC Authority and the wholesalers and retailers it regulates. The bill simply codifies an agreement between ABC and its licensee partners that the authority will discontinue selling low alcoholic beverages no later than December 31st, 2021. With that, I would respectfully ask that Senate Bill 1428 pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1428? Seeing none, the question is, shall Senate Bill 1428 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 36, noes 2.
Ayes 36, noes 2. Senate Bill 1428 passes.
Senate Bill 1442, a bill relating to public defender offices, County of Chesterfield.
Junior Senator from Richmond City, Senator Morrissey.
Good afternoon, Mr. President.
Afternoon, Senator.
Mr. President, I move that Senate Bill 1442 pass, and speaking to the measure.
Senator has the floor.
Ladies and gentlemen of this body, this bill establishes a public defender's office in Chesterfield County. Chesterfield County is one of the largest, although not the largest county in Virginia, with over 350,000 citizens. We established public defender's offices approximately 46 years ago. At this time, we have 26 public defender offices throughout the Commonwealth, representing 54 jurisdictions. I believe the last PD office was added recently in Prince William County. The purpose in having a public defender's office is that you have one cadre of of criminal defense attorneys exclusively performing public defender work. They get specialization, training, supervision, and resources. We have had bipartisan support in this bill, not only in this body, but in the House, and I'm hoping that we can put up not only a majority, but a great number of green votes for a public defender's office that is badly needed in Chesterfield County. Thank you, Mr. President.
Thank you. Senator, do any other senators wish to be heard regarding Senate Bill 1442? Seeing none, question is, shall Senate Bill 1442 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes aye.
Senator Norman, how do you vote?
Senator Norman votes aye.
Clerk will close the roll.
Ayes 37, noes 1.
Ayes 37, noes 1. Senate Bill 1442 passes.
Senate Bill
Mr. President.
Junior Senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, could the Keeper of the Scrolls of the State Senate note that I think for the first time I've gotten both votes from Senator Chase and Senator Norman on a bill that I've introduced.
The Journal will so reflect.
It must have been an accident.
Senate Bill 1443, a bill relating to elimination of mandatory minimum sentences, modification of sentence to mandatory minimum term of confinement for felony offenses.
What purpose is Senator from Roanoke City, Senator Edwards?
Mr. President, I move that Senate Bill 1443 pass.
Senator has the floor.
By way of explanation, Mr. President, this is a bill that deals with mandatory minimum sentencing. It's a recommendation of the Crime Commission. And they won't, with one exception, the substitute does not include Class 1 felonies. These are the 15 or so Class 1 felonies for which the sentence is death or mandatory life without parole. That is excluded, which means that law remains in effect with regard to this bill. The importance of getting rid of mandatory minimum sentencing, Mr. President, is it skews the whole process. The sentencing should be individualized. We have judges and juries to deal with sentencing, and we have sentencing guidelines, which are effective and work quite well. It's important that sentencing be individualized by the people who are in the position to make that decision, mainly the judges and the juries. And the two things that the Supreme Court has said are important in sentencing: one, the nature and history of the defendant, and the nature and extent of the crime. These are the things you look at sentencing. The General Assembly does not know what it is. The General Assembly is not in a position to say, you got to have a mandatory minimum. It doesn't work, and it's unjust. And so, Mr. President, I would hope the body would recognize the importance of this from the standpoint of basic due process, the standpoint of basic fairness, and not straitjacket judges and juries, but rather allow judges and juries to do their job. That's their job, to hear the case, and to hear the case with regard to the nature and history of the defendant and the nature and extent of the crime. And so I would urge the body to vote for the bill and recognize the importance of individualizing sentencing. I might point out that there is an enactment clause here also that the Secretary of Public Safety and Homeland Security will set up a working group to look at evaluating the feasibility of resentencing persons who previously were convicted under mandatory minimum sentencing, and that would be a report due back in November of this year. So, Mr. President, with that explanation, I move this bill pass.
Mr. President.
Thank the Senator. For what purpose, Senator from Rockingham, Senator Obenshain rise.
Mr. President, I would ask before he sits down or gets too settled whether the Senator from Roanoke would yield for a couple of questions.
Senator yield. Senator yields. You have the floor.
I'll be happy to yield.
Mr. President, I would ask the Senator from Roanoke, does this also repeal the mandatory jail time for repeat violators of protective orders?
Senator's the floor.
If it involves mandatory minimum sentencing for time, it would repeal that. I'd have to look at that particular matter. I'm not sure what you're referring to, but if all mandatory minimum sentencing in the code that does not allow the judges and juries using sentencing guidelines to deal with the issue would be repealed, except for Class 1 felonies.
Further question?
Further question.
Senator Yield.
Mr. President,
You got to.
Senator Yield, you have the floor.
I'm sorry. Mr. President, I would ask the senator from Roanoke, does this repeal the mandatory minimum for rape and aggravated rape?
Senator's the floor.
Mr. President, rape is a very difficult issue, and that's why it's important to look at the nature and history of the defendant, as well as the nature and extent of the crime. And that's why we have judges and juries using sentencing guidelines, which we now have. And that's why we don't need the General Assembly to say afar, this is what the sentence should be, mandatory. And so therefore, it would deal with all sentencing that's currently mandatory minimum sentencing in the code, except for Class 1 felonies.
Further question.
Senator Yield.
Be happy to.
Senator Yield, you have the floor.
Mr. President, maybe a less complicated issue. How about the rape of a child? Does this repeal the mandatory minimum for that?
Senator's the floor.
Mr. President, we have guidelines for this. It would be up for the judge and the jury to look at the nature and history of the crime, and nature and extent of the crime, and nature and history of the defendant. And so the appropriate sentencing would be an individualized sentencing based on the facts of each case.
Further question?
Mr. President, I take it that, yes, further question. I take it then that the answer to those questions was yes. It repeals the mandatory minimum for rape of a child, and I would imagine the answer to my next question about child pornography would also be yes. Is that correct?
Senator's the floor.
Mr. President, the judge and the jury with sentencing guidelines would look at the nature and history of the defendant and the nature and extent of the crime. That's true. It all would be individualized. Every case is different.
Mr. President, speaking of the bill.
Senator's the floor.
Mr. President, members of the Senate, we talked the other day about throwing the baby out with the bathwater, about sweeping with a broad brush on criminal justice issues that have taken years and years to evolve. We have debated these issues over and over and have deliberated. The first question I asked was about mandatory jail time for repeat violators of protective orders. I mean, we spent a lot of time working on trying to protect families from household predators, people who were victimizing members of their household, people who were repeatedly violating these protective orders, going in, hurting their families, and we determined that they needed to go to jail. They needed prison. They needed to be separated. You know, we're apparently going to do away with that. We determined that certain offenses like child pornography or rape of a child warranted a minimum sentence. We're going to do away with that. And I respectfully submit that justice in one part of the state ought to be justice in another part of the state. And I'm not suggesting that serious offenses like this are viewed less seriously in one part of the state or another. But what I submit that we're going to see is the balkanization of Virginia when it comes to sentencing. And we're going to see that sentences that are going to be handed down in criminal cases in one part of the state are going to be vastly different from sentences that are going to be handed down in other parts of the state. These sentences, these mandatory minimums are important. And I respectfully submit that we're making a mistake by doing this in wholesale fashion. There may very well be some serious and significant merit in repealing mandatory minimums for individual offenses. But we ought to be doing this in a deliberate way and not in this kind of broad brush fashion. So I would hope that members would take a hard look at this and consider throwing some red up here.
Thank the senator. For what purpose, Senator from Henrico, Senator Donovan, rise?
Thank you, Mr. President. I rise with hesitation to speak on this, but
Senator, the floor.
Thank you, Mr. President. In trying to sort this out and give serious consideration to criminal justice reform, I decided to utilize the resource that I think is perhaps maybe the best subject matter expert in Virginia, and that's the Sheriff of Virginia Beach, who served in this body and passed many of the bills we're debating now, and now continues to serve in his capacity as a sheriff. And if any of you know him, you know that he's very discerning about the truth more than he is about winning an argument. And, you know, I talked to him about this bill because I had a particular interest in looking at mandatory minimum sentencing with a desire to be able to support it. And he explained to me some of the science. I was so validated to know that there's actually evidence and research and science in criminal justice that we should be relying on as we make these decisions, but we seem to be ignoring. And that is evidence that has been vetted over time with the Crime Commission, with the Sentencing Commission, which it is explained to me was set up particularly to make sure that sentencing took into account the avoidance of any injustice based on race. It was the reason the Sentencing Commission was set up, and we probably have some people here that can verify that. And in the process of the body of data that's been developed over this time, I will share with you what this knowledgeable man told me, and that is that we should not have mandatory minimum sentences for felonies if we have truth in sentencing, and that's the balance. You don't tie the hands of your judges to make decisions about mandatory minimums if you know that when a sentence is given, that sentence will be carried out. That's where you trust the discernment of your judges. But that requires that parole be abolished as it was in '94 and is today. But removing mandatory minimum sentences flies in the face of the evidence and data of the subject matter experts that have been working on this for 20 or 30 years. And I'd like everybody to think about that, because I know you're rushing fast, and I know you have an agenda, but you should be informed by evidence and by best practices and by the subject matter experts, which, with all due respect to this body and with all due respect to the legal minds we have here, none of us are. And I am sad that we can't have an authentic conversation about what we should be doing about mandatory minimum sentences, because I think you would find some interest in doing the right thing based on evidence going forward. But again, this bill is not the right thing, and I hope you will vote against it. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Eastern Fairfax, Senator Saraville, rise?
Speaking of the bill.
Senator's the floor.
Thank you, Mr. President. You know, this whole journey we've been on regarding mandatory minimums started probably in the early 90s. There was this guy who ran a commission in Virginia who started our current philosophy. His name was Bill Barr. And in the forward to a report that he wrote for the American Legislative Exchange before he wrote his Virginia report, he wrote that increasing prison capacity was the best way to lower crime. That was the philosophy that underlay this journey we've been on. And it's fascinating to me that the rest of the world, at least the rest of the modern industrialized world, doesn't seem to operate their crime and punishment systems like this. And things seem to work out pretty well. We have the largest prison population per capita, I think, of almost any country on the planet. And these policies are a big part of it. And I would disagree that there is research showing that mandatory minimums work for those of us that have to operate in the system. In my experience, the number one thing that mandatory minimums does is it results in a lot of people who probably have some kind of a defense, when many people are actually innocent, to plead guilty because the consequences of losing are far, 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 far too great. Mandatory minimums give our Commonwealth attorneys, effectively gives them nuclear weapons to use in plea negotiations. When you couple the mandatory minimum sentences with the number of charges that can sometimes be brought, those kinds of stakes are just something that a lot of people can't take, even though they're probably innocent. The senator from Roanoke has already pointed out the fact that you lose individualized consideration of the circumstances of an accused person. You know one other thing mandatory minimums do? They completely prevent the victim from having any input in the sentence. You might have a victim that says, you know what, I don't think that's an appropriate sentence. But you know what? The General Assembly decided that, that's what you got to get, so you got to get it, because we decided that however many years ago. Mandatory minimum sentences also do not deter anybody. Virtually every single person I've ever represented who got charged with an offense that carried a mandatory minimum, when I explained to them what the mandatory minimum was, they said, what? They have no idea. You know what else it does? Mandatory minimums make lawyers a lot of money. Because, when I started practicing law, if you had a high BAC DUI that came across the door, you would just basically work out a plea deal, feel out a way to mitigate the damage, make sure they didn't go to jail, work out a restricted license. But nowadays, if you get somebody who comes in with a 0.15 DUI, 0.16, 0.17, they're terrified of going to jail, and they will pay a lot of money to fight it. Whereas 15, 20 years ago, those folks would you'd take a small fee, plead them guilty, work something out, and be done with it. These things, in some ways, clog our courts depending on the nature of the offense. Mr. President, at the end of the day, what these do is they send a message that we don't trust our judges, we don't trust our system, we don't trust the parole board, which I know some of you don't, some of us do. But we have these systems in place so that we make decisions based on the circumstances of somebody who's accused, the circumstances of the crime, the circumstances of the victim, the desires of the victim, take full community input and render a sentence that's fair. And mandatory minimums don't do any of that. This is a failed policy, and we need to move on from it. The fact that we're going after all of them, nobody here wants to say that we're pro any of these offenses. It's the policy, the way of adjudicating crime needs to change. And that's the policy the Crime Commission endorsed that's reflected in this bill. And I think this bill represents a big symbol that we're going to send that it's time to move on from a bunch of failed policies.
For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Speaking to the measure.
Senator, the floor.
I had not planned on speaking, Mr. President, but when I heard the comments of my colleague and friend from Rockingham, I feel compelled to say a couple of things. First of all, I absolutely disagree with the gentleman from Rockingham who says that if we eliminate mandatory minimum sentences, we're going to have disparate sentencing depending on the geographical location of the Commonwealth. Here's what's going to happen. These sentencing guidelines, folks, are uniform throughout the Commonwealth. So if the sentencing is done by the judge, as it will be because of recent legislation that we passed, the judge will look at those guidelines. Does he have the right to go below it and above it? He does, but in 90% of the cases, he stays within it. You're going to have consistent penalties throughout the Commonwealth. That's the first thing. The second thing is that the gentleman from Eastern Fairfax was spot on. Let me tell you what goes on. The prosecutors use mandatory minimum sentences to force your hand, to force a defendant into a plea, such as, I will indict you for these 6 charges, pick the charge, mandatory minimum of 5 years, you're facing 30 mandatory years, or you accept this plea of 4 years. That's what they do. Third, do you know who dislikes these mandatory minimums more than almost any other group? It's going to surprise you. Judges, because it ties their hands. I can't tell you the number of times I've heard judges say, quote, I don't want to do this, but I have to. I have to give you a mandatory minimum of 5 years on each of 4 counts. They don't like it. The last thing that I'm going to say is, or the penultimate comment is this. You know, mandatory minimums became very prevalent in federal court. And they resulted in judges in federal court doling out sentences that were so far disproportionate to what the actual crime was. And they would speak from the bench about this. Going back to Judge Marriage. Do folks in this body remember the name Kember Smith? Is that name on anybody's radar? Kember Smith was a rich, I believe she went to a local HBCU, and her boyfriend dealt drugs, crack. And on one occasion, she drove him up to where he made a deal. He was arrested. They charged her with distribution of crack cocaine, and because of the weight, she faced a mandatory minimum sentence of 24 years in jail. The prosecutor, the judge said from the bench, I don't want to do this, turned to the prosecutor and said, are you absolutely sure you want to do this? And they did. He had no choice, hands tied, and sentenced her to 24 years. She'd still be in prison to this day unless President Clinton had not pardoned her. And she's now gone on to live an absolute stellar life. But these mandatory minimums are bad. It allows the prosecutors to bully a defendant. And I'll just flat out say it. Bully a defendant into a plea because they are not going to take the risk of decades in prison. It's high time, no pun intended, that we eliminate these mandatory sentences. There's over 223 of them on the books, and we get a good start by doing it today. Thank you, Mr. President.
Thank the Senator. Do any senators other than the patron wish to be heard regarding Senate Bill 1443?
Mr. President, the junior senator from the city of Richmond yield for a question.
Will Senator yield?
I yield, Mr. President.
Senator yield, you have the floor.
Mr. President, I am looking at the list of mandatory minimums from the sentencing guidelines, and I would ask the junior senator from the city of Richmond if he could point to one single crime for which the mandatory minimum is higher than the low end of the sentencing guidelines. Anywhere.
It's not.
Senator's the floor.
I'll address your question. That's not the point. The point is that the prosecutor will charge multiple counts of that mandatory minimum sentence. So if the mandatory minimum sentence is 5 years and the sentencing guidelines call for 5-6 years, the prosecutor will indict him on 6 of those charges. 6 times 5 is 30. Defendant looks at it and says, what do I do? I can't risk 30 years, so I will plead guilty to it. So the issue is not whether one mandatory minimum is less than the guidelines. The issue is how many counts will the prosecutor bring?
Further question?
President, one further question.
Senator yield?
I yield, Mr. President.
Senator yield, you have the floor.
Even if they're charged for multiple counts, those sentences can run concurrently, correct?
Senator's the floor.
I'm going to yield to the gentleman from Eastern Fairfax, but I don't think that is correct. I believe, now, there was a decision, Brown versus Commonwealth by the Supreme Court, but I don't believe they can be run concurrent. I gave you an example the other day of a gentleman getting 33 years, but I'm going to, if I know the answer, I'm going to speak, but if I'm unsure, I'm going to defer, and so I'll defer to the senator from Eastern Fairfax or somebody else.
That's all right. I thank the gentleman.
Thank the senator. The junior senator from Chesterfield, Senator Chase.
Thank you, Mr. President. I would just like to simply ask a question of the junior senator from Richmond.
Senator yield for a question. Junior senator from Richmond City, Senator Morrissey. Does Senator yield for a question?
I'm sorry, Mr. President. I yield.
Senator yields. You have the floor.
Thank you. I want to, this is a case he's probably familiar with back in August of 2018. We had Logan Osborne here from the Chesterfield area who was originally sentenced to 2 years after pleading guilty to having carnal knowledge of his teen victim. There was a man who allegedly sexually assaulted a 14-year-old girl and got no jail time from Chesterfield Circuit Court Judge Haller, who overturned the sentence. That is not the first time we had an issue with this particular judge giving no sentencing. And so my question is this: under Senate Bill 1443, how would a judge like Judge Haller, who seems to have a situation where we're releasing a rapist who eventually went on to kill someone. This is a real issue that's going on in our district. How would those sentencing guidelines apply in that situation?
Senator, the floor.
Mr. President, I would tell the senator from Chesterfield County the following. Please don't conflate a sentence range, say 5 years to life for rape, with a mandatory minimum sentence. A mandatory minimum sentence requires that that judge impose that minimum. There can be no suspension to it. With regard to the situation with Judge Haller, who is now retired, but I thought was a superb is a superb jurist in Chesterfield County, that judge had the authority and the discretion to suspend a portion of the sentence, giving what the senator from Chesterfield feels was a de minimis sentence. But that's not the same thing as a mandatory minimum. I would tell the senator from Chesterfield County that a mandatory minimum is exactly that. The judge must impose that sentence, as opposed to a range, robbery, 5 to life. A judge could say, I'm going to give you 20 years and suspend 18. There's a difference.
Thank you.
You're welcome.
Thank the senator. No other senators wish to be heard. Senator from Roanoke City, Senator Edwards.
Mr. President, I don't want to intrude upon your time. We've been here too long as it is, and I think the facts have been explained pretty well. The senator from Eastern Fairfax, the junior senator from Richmond. The bottom line is this: we do have sentencing guidelines, and they're working quite well, and we have a sentencing commission. They're working quite well. That evens it out throughout the entire Commonwealth of Virginia. But sentencing, the Supreme Court has said, should be individualized in order to be just. Look at the history of the defendant. You look at the nature of the crime, using the guidelines. We do not need and we should not straitjacket judges from the General Assembly. That's the most presumptuous thing I can think of, and we should pass this bill. Thank you, Mr. President. Bring fairness into the system. Thank you, Mr. President.
Thank the senator. Question is, shall Senate Bill 1443 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
Senator Chase, how do you vote?
Senator Chase votes no.
Senator Norman, how do you vote?
Senator Norman votes no.
Clerk will close the roll.
Ayes 21, noes 17.
Ayes 21, noes 17. Senate Bill 1443 passes.
Senate Bill 1462, a bill relating to Virginia Digital Equity Pilot Program and Fund.
Senator from Williamsburg, Senator Mason.
Thank you, Mr. President. Mr. President, move the bill pass and speaking the motion.
Senator's the floor.
Thank you, Mr. President. You know, I hadn't planned on speaking on this bill, but it is mine, so I guess I better go ahead and do it, sir. We've heard a lot in the last few days about access to the internet, particularly with our students learning from or doing the best they can to learn from home. This is an effort to try to tackle both access and affordability, but with an eye towards affordability. There's some federal government plans out there. The CARES Act actually has put $50 a month towards a plan that will only last for like the next 6 months, but there'd been an ongoing plan for $9.25 federal money to go to households that need help accessing the internet. Well, the lowest cost plan we have is $15. So this effort, Mr. President, is our effort working with the senator from Northwest Fairfax, who has worked very hard with the Internet Advisory Commission to try to target homes, and we use homes that receive SNAP benefits because they are households that we know where they are, 377,000. This would set up a pilot program that would run through July 1, 2024 to try to access as many as we possibly can, to try to find households through social services, target them, and then utilize monies that we have put a budget amendment forward to try to augment the federal money with some state money and try to see if we can get as many households as we can set up. This is only an attempt to stand up the program over the next year, trying to get between 1,000 and 2,000 households. That would be covered by the number we asked for in our budget amendment. The fiscal impact statement came out with a Cadillac plan, so we'll have to see on Sunday how that works. But, Mr. President, this is an effort to reach households that do not have access to the internet, to give them help in doing so, and to try to provide a bit of a stipend on top of the federal government to get them to the low-cost plan. So with that, Mr. President, I ask that the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 1462? Seeing none, question is shall Senate Bill 1462 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Are you ready to vote? No? Okay, good, because you can't. So we're going to wait 1 second.
I don't know. Sorry.
The Senate will be at ease.